Good morning. Welcome to one and all to the 35th Legislature's Committee on Homeland Security, Justice, and Public Safety hearing of Tuesday, May 15, 2024. Meeting hereby called to order. We'll be hearing testimony on about 5 bills in our committee today, and I look forward to a very productive discussion and thank everyone for being here. Before we get started, I must recognize that this is National Police Week, and as a career law enforcement officer, I'm pleased to extend my thanks and best wishes to all those currently serving, not only within the police department, but within our law enforcement agencies. Your efforts are sometimes thankless, but much appreciated. And I encourage all, as you traverse the island and you see our law enforcement officers, just be kind and extend healthy, happy Police Week. Tomorrow is, and I'm sorry, when I started, I think I said today's hearing is Tuesday, May 15th, but it's actually the 14th. My apologies. Tomorrow, being May 15th, is also Police Officers Memorial Day, which honors and pays tribute to police and law enforcement officers who have lost their lives or been disabled in the line of duty. There are several events planned for the day, including a motorcade here on the island of St. Croix, and I urge all of those who can do so to show your support again to our fallen officers. May 19th to the 25th is also National Emergency Medical Services Week, and I'd like to also thank all those who devoted themselves to providing our community with emergency medical services. A heartfelt thank you. We are currently looking forward to beginning the training of emergency medical technicians in our public high school system as a result of my legislation, through Act number 8506. When we last heard from the Department of Education, we were told that the EMT program would begin this fall. I'll be meeting with them in short order. Earlier this month, we also recognized National Hospital Week and National Nurses Week. However, the entire month of May is Older Americans Month. We used to call this Senior Citizen Month, as we have been recognizing this each year for more than about 60 years. President John Kennedy was the first to make the declaration back in about 1963, they indicated. And this is a time for us to honor older Americans and celebrate their contributions to our community and the nation. This year, we have about, to my recollection, about 4 centurions that we'll be recognizing in short order. That's 4 people here, right here, and I believe particularly on St. Croix, that will be making 100 years old. And at the appropriate time, I'll also be making those recognitions publicly. I'd like to thank Mr. Alvin Milligan of the Department of Human Services and his team for putting our local program together, where we would be without these men and women of these agencies. The legislature will also have the opportunity, I think it's next week, somewhere around May 23rd, to host a number of our senior citizens in a mock election, and I'm pretty sure that Senate President Francis will have a good show for that day as well. Looking forward to interacting with our seniors. At this time, Madam Clerk, can I get a roll call?
Yes, Mr. Chair. Senator Angel L. Bocas Jr. Senator Bocas Jr. present. Senator Dwayne M. DeGraff. Senator DeGraff absent. He's here? Okay. Senator DeGraff present. Senator Ray Fonseca.
I'm here.
Okay, Senator Fonseca present. Senator Alma Francis Heiliger.
Present.
Senator Francis Heiliger present. Senator Javon E. James Sr. Senator James Sr. absent. Senator Franklin D. Johnson. Senator Johnson present. Senator Kenneth L. Gittens.
Here.
Senator Gittens present. Mr. Chair, you have 6 present, 1 absent.
Thank you. We do have a quorum. We'll proceed. Madam Clerk, are there any correspondence to be read into the record?
No, Mr. Chair.
None. You may read the agenda into the record, please. Thank you.
Okay, yes, Mr. Chair. The agenda is as follows.
And my apologies, you could just you can indicate that there are 2 blocks, but just read block 1 at this time. Thank you.
Okay, the agenda is as follows. Block 1, 10 a.m., Bill 350248, a resolution petitioning United States Congress to amend the Revised Organic Act of the Virgin Islands to authorize the people of the Virgin Islands to elect the Attorney General of the Virgin Islands, sponsored by Senator Alma Francis Heiliger. Invited testifiers, Ian Clement, Acting Attorney General via Department of Justice, Julie Smith-Todman, Chief Public Defender, Office of the Territorial Public Defender, Carolyn Fox, Supervisor of Elections, Election Systems of the Virgin Islands, and Marjorie Wallen, President of the VI Bar Association. That concludes Block 1, Mr. Chair.
Thank you. We'll just do a systems check. There's no one online, so we'll start with the testifier on St. Thomas. You may identify yourself, your title, and agency you're representing, and then we'll come to the St. Croix district, and we'll start at my right. You may proceed on St. Thomas. Name, title, and agency representing.
Good morning. My name is Ian S.A. Clement. I am the Acting Attorney General. What's your name?
Department of Justice.
Department of Justice, yes.
Thank you. Am I right?
Good morning, Caroline Fox, Supervisor of Elections, Election Systems of the Virgin Islands.
Thank you. Welcome.
Good morning, Julie Smith-Todman, Chief Territorial Public Defender of the Office of the Territorial Public Defender.
Thank you. Welcome.
Good morning, Russell Pate, attorney with the Pate Law Firm. And though I am president-elect of the VI Bar Association, my testimony is not on behalf of the VI Bar Association. This is my personal testimony.
Thank you. Thank you to each of you, and welcome. We'll begin our, first off, who speaks to this bill? Senator Alma Francis Heiliger, you're recognized for the introduction of the bill. Oh, I'm sorry.
Thank you.
I'm sorry, before you go, my humble apologies. Let me also recognize the presence of our Senate President, Novalie Francis Jr. Welcome. Good morning. Senator Francis Heiliger, you may proceed.
Thank you very much. Good morning to my colleagues. Good morning to the people of the territory. Good morning to Central staff and the testifiers. As I sit here, I offer Bill number 35-0248. This is a resolution to petition Congress to give the Virgin Islands residents an opportunity to elect their Attorney General. As a talk show host for many years in this territory, I had listened to the cries of the people speaking many times of their need and want and desire to have an elected attorney general. When I started on my campaign trail over 12 years ago, one of the things that I pushed was for an elected attorney general. I continued on and I did quite a bit of research as to why I was continuously hearing the people of this territory speak to the need and their want and desire to have an elected attorney general. And in my research, I found out that a referendum, which was brought forward by this institution several years ago, was placed on a ballot. And over 73% of the people that went out to vote that year voted to have an elected attorney general. Senators such as Holland Redfield, Roosevelt David, Ali Petras, Senator Camacho, these were all the senators that came together to get that resolution put forward on behalf of the people, and the people spoke. Several things happened, and here we are, fast forward to 2024, and we still do not have an elected attorney general. One of the things that we have the ability to do is put this inside of a constitution. My first dabble into politics was in 2007 when I attempted to run for the 5th Constitutional Convention.
Ma'am,
And here we are.
excuse me, Senator, I'm going to just allow you to introduce the bill, and then you can get into your debate matters after. But just the introduction of the bill, please.
Well, this is the first time that I'm told, well, when you say just the introduction, because I've introduced bills several times and I was afforded an opportunity for the past 3 years to explain why I'm bringing this bill forward in my introduction. So you're the first person saying, so please explain to me what is your interpretation that you feel is just the introduction, because for almost 4 years I've always explained why the bill is coming forward in my introduction. What is it you desire, Mr. Chair?
For you to introduce the bill, and we proceed with any debate thereafter.
This was not a debate. This was me sharing information about the bill as a form of introduction. But again, this is Bill 35-0248. This is a bill, a resolution petitioning the United States Congress to amend the revised Organic Act of the Virgin Islands to authorize the people of the Virgin Islands to elect an attorney general. And in doing so, I am asking my colleagues to listen to the testimony today. If you have any questions or concerns, if you have any issues, please speak up, because I will be more than willing to answer any questions, as I'm sure we will engage in asking the testifiers. I am asking for your support of this piece of legislation. And thank you, Mr. Chair, for... Thank you.
Thank you, Senator Francis Heiliger. At this time, we will proceed with testimony, and we would begin with the Department of Justice. Acting AG on St. Thomas, you will proceed first. Then we will go to the Office of the Territorial Public Defender, then to Attorney Pate. Is it Pate or Pate?
Whatever you prefer, Senator.
And then we will end with the election system of the Virgin Islands. So, Acting AG, you may proceed.
Good morning, Chairman Gittins, Committee on Homeland Security, Justice and Public Safety members, legislative staff, and the viewing and listening audience. My name is Ian S.A. Clement, and I am the Acting Attorney General of the Virgin Islands. I am honored to be invited to provide a few remarks regarding Bill number 35-0248, as proposed by Senator Alma Francis Heilinger. Bill number 35-0248 seeks to petition the United States Congress to amend the Revised Organic Act of 1954 to authorize the people of the Virgin Islands to elect the territory's Attorney General. The Attorney General is a state or territory's chief legal advisor to government agencies, the legislature, and the chief law enforcement officer. The Attorney General is often the head of the state or territory's Justice Department, and this is the case in the Virgin Islands, where the office of the Attorney General sits within the Department of Justice. Although the role of the Attorney General can vary from one state or territory to another based on statutory requirements, Attorneys General typically issue formal opinions to government agencies, propose legislation, enforce environmental laws, represent the state or territory in local and federal court, handle criminal appeals, institute civil lawsuits on behalf of the jurisdiction, operate victim compensation programs, and act as public advocates in areas such as child support enforcement, consumer protection, antitrust, and utilities regulation. The qualifications for Attorney General vary by jurisdiction and include minimum age, residency, citizenship, voting status, and education requirements. Of these established qualifications, 1, 35 states have an age requirement, with 18 being the lowest and 31 being the highest minimum age. 43 states require the Attorney General to be a state resident, with some states specifying a minimum length of time as a resident. The shortest residency requirement is 30 days, and the longest is 7 years. 40 states require the Attorney General to be a United States citizen, with some states specifying a minimum time as a citizen. 30 states require the Attorney General to be a qualified voter. 20 states do not require the Attorney General to have a law degree or a valid license to practice law. The popular election is the most common way of selecting an Attorney General, with 43 states, the District of Columbia, and 2 territories, Guam and the Northern Marianas Islands, choosing this method. Attorneys General who are elected mostly serve 4-year terms. Only the elected Attorney General of Vermont serves a 2-year term. The governor appoints the Attorney General in 5 states and 3 territories, including American Samoa, Puerto Rico, and the Virgin Islands. In Tennessee, the Tennessee Supreme Court appoints the Attorney General for an 8-year term, while the Maine legislature elects the Attorney General to a 2-year term. Some jurisdictions have term limits, restricting the number of terms a person may serve as Attorney General. States that enforce term limits often limit terms to 2 consecutive or a maximum of 2. Maine allows its elected Attorney General to serve 4 2-year terms. Alternatively, Virginia's Constitution provides that there shall be no term limits on the terms of the Attorney General. There are no term limits for Attorneys General appointed by the governor. Currently, the governor has general supervision and control of all of the departments, bureaus, agencies, and other instrumentalities of the executive branch of the government of the Virgin Islands, including the Attorney General. Additionally, he shall appoint and may remove all officers and employees of the executive branch of the government of the Virgin Islands, except as otherwise provided in this or any other act of Congress or on the laws of the Virgin Islands, quoting from the Revised Organic Act. 19 states plus the District of Columbia permits the recall of elected state office officials. The recall is a political device that allows citizens to remove and replace public officials before the official's term of office ends. Recalls generally starts with a petition circulated to collect the required numbers of signatures before it is submitted to the election officials for verification and end with an election. The recall election can be held simultaneously with the election for a successor or separately. In some states, a successor is appointed after the recall election. After a recall election, recall elections are one method for removing an elected Attorney General. Impeachment is another. Impeachment is a legal process through which the legislature may bring and hold trials with penalties, including removal from office. Although the impeachment process varies by jurisdiction, it follows the bifurcated federal model. The first step involves a formal accusation and an investigation. If misconduct is found, articles of impeachment are developed and voted on. If affirmed, the second stage of impeachment begins with the formal consideration of charges. The second phase of the impeachment process resembles a trial with both sides presenting evidence. Once arguments are concluded, a second vote is held to determine whether the party is guilty of the charges. That said, the following should be considered as you evaluate and vote on the proposed Bill 35-0248. First, I would consider increasing the number of years a candidate for Attorney General is admitted to practice law in the Virgin Islands from 3 to 10. The 10-year requirement would help ensure the Attorney General candidates are intimately aware of the intricacies of our laws, which are unique due to the territory's rich history and identity. Second, I would consider the length of time an individual must be a resident of the Virgin Islands before running for the position of Attorney General. While 3 years is in line with the minimum residency for those seeking election to the legislature of the Virgin Islands, increasing the residency requirement would help ensure the elected Attorney General has a thorough understanding of the territory's laws, though I would not recommend requiring that the candidate's residency immediately precede their election. Third, I would consider adding a provision allowing the Attorney General to be removed for cause, whether by recall or impeachment. The removal for cause provision would allow an elected Attorney General to be removed from their position due to a violation of law or policy only. The removal for cause provision would also allow the Attorney General to remain independent from the influence of others. A process for replacing a deceased or incapacitated Attorney General should be instituted. This process could be similar to the process used for removing an Attorney General for misconduct. Finally, if Bill number 35-0248 moves forward, I would also consider adding the following provisions. No election for Attorney General shall occur before November 2026, provided that Congress approves the measure and the Revised Organic Act is amended to allow for such an election. The final governor-appointed Attorney General shall remain in the position until an election occurs and the Attorney General-elect is sworn into office. The elections for Attorney General shall occur in even-numbered years. The decision to petition the United States Congress to amend the Revised Organic of 1954 to authorize the people of the Virgin Islands to elect the territory's Attorney General is a policy decision, not a legal one. Ultimately, the Attorney General represents the interests of a territory. Arguments can be made both for and against electing the Attorney General. For example, if elected, the Attorney General would be able to solicit funds from people and businesses, creating a potential conflict of interest in deciding which cases to pursue or not. Thus, their independence will be affected in another way. On the other hand, the appointment process allows for a thorough consideration in selecting and vetting candidates. With that, I want to thank the committee for the invitation to testify on Bill number 35-0248. This concludes my formal remarks, and I remain available for any questions the members may have.
Thank you, Dr. Nagy. Now we'll proceed to the Office of the Territorial Public Defender.
Good morning. My name is Julie Smith Todman, and I am the Chief Territorial Public Defender. I thank the members and staff of the Committee on Homeland Security, Justice, and Public Safety of the 35th Legislature for this invitation to testify on proposed bill number 35-0248, a resolution petitioning the United States Congress to amend the Revised Organic Act of the Virgin Islands to authorize the people of the Virgin Islands to elect the Attorney General of the Virgin Islands. I thank Senator Gittens for the invitation to testify today on behalf of the Office of the Territorial Public Defender. My office, the OTPD deals with the Office of the Attorney General on a daily basis. As the agency tasked with representing indigent persons accused with crimes, our interaction with the Attorney General's office is in their role as prosecutor. The role as prosecutor is probably the most iconic of the Attorney General's many responsibilities. Of course, the Attorney General's mandate is broader than just prosecuting criminal actions. The Office of the Attorney General provides counsel to government actors. It represents the territory, its agencies and officials in litigation, and it is generally tasked with enforcing not only the criminal laws of the territory, but also the civil laws. In addition to the responsibility of representing the state, attorneys general are also tasked with representing the public interest. While our two offices are typically in direct opposition, OTPD shares in this body's interest in seeing that the Virgin Islands have the best possible Attorney General. Having an effective, ethical, and responsive Attorney General should be the goal for all Virgin Islanders, whether that person is appointed or elected. In preparing for this testimony today, I had the opportunity to review some of the legal commentary on the question of the election versus the appointment process. The two systems offer different approaches to delivering effective, ethical, and responsive leaders. There are lessons to be learned from our fellow jurisdictions under either approach. There are many arguments in support of the notion of electing attorneys general. First and foremost, and what appears to be surely embraced by Bill 35-0248, is the idea of popular sovereignty, the exercise by the people of their franchise, arguments that are foundational to our system of government. In addition to direct election by the people, a second argument supporting a change in the current appointment system concerns the independence of the position and keeping the AG's decision impartial from political influence. Finally, the bill quotes the federal government's Justice Manual as noting that the Attorney General should exercise their powers as prosecutor free from partisan consideration. While it is true that the majority of states conduct elections for Attorney General, it is noteworthy that the United States is the only country in the world that puts prosecutors up for popular vote. The bill points out that prosecutors should be free of partisan considerations, but the truth is that prosecutors cannot help but become more overtly political if they are required to stand for election. It has been shown that elected attorneys general are active political forces in their states and have aspirations for the higher political office. Of greater concern is that when faced with elections, officials may be unduly influenced by campaign contributions. The need for the Attorney General to campaign actively and solicit campaign contributions may present conflicts of interest after the election. They will be making campaign promises and taking campaign contributions from individuals who may become victims of crime or even the subject of criminal investigation. Most relevant to OTPD's role as defending those accused of crimes is concern that elected prosecutors will embrace harsher actions to placate public sentiment, what might be called the tough on crime problem. Crime is a leading concern for many members of our community. I am certain every member of this body has been the target of popular pressure to do something about crime. Given their role, an elected Attorney General will face even more of that public pressure. This creates a danger. Empirical studies show that in a country where prosecutors and often judges are elected, criminal sentences are longer in election years. Elected prosecutors will be the target of pressure, and the evidence shows that they will change how they do their job because of it. The system can become less even-handed with elections. Elections also may not be the best tool to measure an attorney's ability. There is evidence that voters pay less attention to lower ballot races, including attorney general races. In our last local general election, when the governor was on the ballot, about 1/2 of the electorate voted, but the highest polling non-gubernatorial candidate received a vote from only about 1/5 of the electorate. There are several other measures that this body can take to increase accountability. First and foremost, the revised Organic Act provides that the Attorney General shall have such powers and duties as may be prescribed by the legislature. So this body could conceivably make adjustments to increase accountability. Secondly, this jurisdiction could focus on the rules of professional conduct that govern all attorneys. Finally, we could leave the issue to the voters and ask them at public referendum if they seek this choice for themselves. What is noteworthy is that we all seek an effective, ethical, and responsive Attorney General, whether appointed or elected, who complies with the state professional conduct rules which govern lawyers. Thank you for the invitation and your time.
Thank you, Chief Public Defender. Now we'll move to Attorney Pate. Now you did respond to our email saying that you were responding on behalf of the bar. You're saying that you're not representing the bar this morning?
No, I think the email would not say I'm responding on behalf of the bar. It says that I have testimony that I've submitted on my letterhead. This has not been able to go through a bar committee in this amount of time.
Okay. You may proceed.
Yes.
We'll just make it clear that these are your comments and not that of the Bar Association. All right.
Good morning, Majority Leader Gittens and honorable members of the 35th Legislature. I write regarding Bill 35-248, the proposed resolution to Congress to amend the revised Organic Act to provide an elected Attorney General for the United States Virgin Islands. Regarding the resolution, it's well written, particularly the background whereas sections. As to the substance of the resolution, I would recommend edits as to 1, residency, and I'd note that my position here is opposite somewhat of the acting Attorney General. I would lower the residency from 3 years to 1 year. There's many well-qualified Virgin Island attorneys that work stateside. The residency should be lowered so that it's feasible to come back to the Virgin Islands to run for the Attorney General position. The U.S. VI population is small. There's a small pool of lawyers. So if the residency is as low as possible, that increases the available candidates as high as possible for office. 2, the practice of law. I would lower the practice of law from 3 years to 1 year. And this is because it's Virgin Islands practice of law. There is no law school in the Virgin Islands. Thus, a Virgin Islander who's either born or raised here has to go off island for law school. And they may have accepted work in a stateside law firm or an academic institution or law school and taken a stateside bar exam. Only later, he or she may decide to gain admission to the Virgin Islands bar. 3, term. For continuity, the term of office should be 4 years, not 6, and it should be scheduled for a staggered election on off-cycle years of the governor election. However, I would, for this body in a future consideration, I'd recommend raising the trial court judicial terms to 8 years instead of 6-year terms, which allows, a 6-year term allows a 2-year governor to appoint every trial court judge, and one governor appointing every single trial court judge in the territory should be avoided. 4, sharing. I'd recommend that the resolution not only be sent to the speakers of the House and Senate, but I would also include the majority and minority leaders for both chambers. Now, moving to the legal code revisions. This resolution is a good start, but it can be done locally. The legislature can draft an elected Attorney General law through creative language in the elections title and other sections of the VI Code, and this is pursuant to the power granted by Section 11 of the Revised Organic Act, which permits a provision in there except otherwise provided under the laws of the Virgin Islands. So the Virgin Islands has been provided the ability to work inside of the Revised Organic Act. What I would recommend here is, number one, on the elections, you create mostly the same qualifications to run for the Attorney General as to run for governor. Number two, that the candidate be an admitted member of the Virgin Islands Bar Associations, licensed to practice before the Virgin Islands Supreme Court for no less than 1 year. Again, the reason I put this low is you may have a Virgin Islander that has practiced in New York or Florida for 10 or 15 years. They can take the bar here and they understand the concepts of law and judicial practice. Number three, the election for the Attorney General should be on off-cycle years for the governor. That would increase participation of voters on those off-cycle years to be voting for an important position. And then number four, I would recommend that whatever language is put into our local code, you would state within a certain amount of days of the election, after it's been duly certified, that the duly elected Attorney General shall be speedily appointed by the governor to the position of the Attorney General of the Virgin Islands, and the legislature shall speedily confirm the nomination. If you want to write it, you could write it that way, preferably, or you could use it where you use the Revised Organic Act, Section 11, to directly put in the election. Number five, I would have, if the Attorney General resigns or is incapacitated, you'd want to have some provision that the Deputy Attorney General shall assume the position. And then number six, I would put in that the Attorney General may be only removed for good cause upon notice and a hearing before the legislature, in which the Attorney General may speak and have witnesses on the Attorney General's behalf, and that if the legislature votes at 13 members or greater, the Attorney General can be removed. In conclusion, I say that Thomas Paine and Thomas Jefferson wrote that natural rights and human power flow from the citizen upward, not from the king downward. Thus, government should be as local and close to the actual citizens as possible. The Attorney General should be a servant of the people and not the governor. The governor already has 2 to 3 in-house legal counsels on staff in Government House, and the lieutenant governor also has in-house legal counsels. This concludes my testimony. Thank you.
Thank you, Attorney Pate. And before I move to the final testifier, let me just recognize the presence of Senator Diane T. Capehart, Rules Committee Chair. Welcome. Supervisor Fox, or I would prefer to say Dr. Fox, you may proceed at this time.
Supervisor Fox, preferable today and all when I'm on duty. Good morning, Honorable Kenneth Gittins, Chairman on Homeland Security, Justice, and Public Safety, distinguished members of the 35th Legislature, members of the press, the viewing and listening audience. I am Caroline Fox, the Supervisor of Elections, of the election systems of the Virgin Islands. It is an honor to appear before you today to provide testimony on Bill 350248, a resolution petitioning the United States Congress to amend the Revised Organic Act of the Virgin Islands to authorize the people of the Virgin Islands to elect the Attorney General of the Virgin Islands. The Office of the Supervisor can only provide historical data and impact on any of the election laws if this proposal becomes law. 26 years and 8 days ago, the 22nd Legislature of the Virgin Islands adopted Bill number 220231, which established an opinion poll on whether legislation should be proposed to Congress of the United States to change the Revised Organic Act to provide for the election of the Attorney General. The bill's sponsors were Senators Miguel A. Camacho, Roosevelt St. C. David, Ali Allison Petrus, and Holland Ed Redfield. The opinion poll appeared on the 1998 general election ballot held on Tuesday, November 3rd, 1998. The 1998 general election was a gubernatorial election when a larger percentage of the voters cast their ballot compared to a non-gubernatorial election year. The certification of said election can be found on the Virgin Islands Election System website and is included in your testimony. Votes cast was the following. St. Croix, yes, 6,999. No, 2,124. St. Thomas, St. John, yes, 6,999. No, 2,854. In the St. Croix district, 77% of the voters who cast their votes for the opinion in favoring authorizing the legislature of the Virgin Islands to petition the United States Congress to amend the revised Organic Act of the Virgin Islands to elect the Attorney General of the Virgin Islands. In the St. Thomas, St. John district, 71% of voters who cast their votes for the opinion in favor of authorizing the legislature of the Virgin Islands to petition the United States Congress to amend the revised Organic Act of the Virgin Islands to elect the Attorney General of the Virgin Islands. The most prevalent method of selecting a state's Attorney General is by popular elections. 43 states have elected Attorney General. This equates to 86%. Elected Attorney Generals served a 4-year term, except in Vermont, where the term is 2 years. 7 states do not popularly elect an Attorney General. In Alaska, Hawaii, New Hampshire, New Jersey, and Wyoming, the Attorney General is appointed by the governor. The Attorney General in Tennessee is appointed by the Tennessee Supreme Court for an 8-year term. In Maine, the Attorney General is elected by the state legislature for a 2-year term. The District of Columbia and 2 U.S. territories, Guam and Northern Mariana Islands, elect the Attorney Generals for a 4-year term. This equates to 50%. 2014 marked the first year that the District of Columbia and the Northern American Islands held an election for that office. In America Samoa, Puerto Rico, and the U.S. Virgin Islands, 3 territories and a Commonwealth, the Attorney General is appointed by the governor. In Puerto Rico, the Attorney General is officially called the Secretary of Justice, but is commonly known as the Puerto Rico Attorney General. The legislature of the Virgin Islands must expound on the qualifications for office, such as being a qualified voter and who have not been convicted of a felon or a crime involving moral turpitude, and has not received a pardon restoring his civil rights. If granted, the election for the Attorney General shall begin in a non-gubernatorial year. The Office of the Supervisor reviewed to see what sections of Title 18 will have to be amended. An example, Title 18, Chapter 1, Section 7, must be amended to add the Attorney General. I would go as far as to state any public office created by the legislature of the Virgin Islands must be encoded in Title 18, Section 7, which addresses prohibition of dual candidacies. In any general, primary, or special election, no person's name may appear on a ballot as a candidate for more than one of these offices: governor, lieutenant governor, delegate to Congress, senator, board of election, and board of education. We will review Title 18 in its entirety to ensure the law is consistent throughout. Today, May 14th, 2024, beginning at 12 noon, nomination, petition, and papers can be filed in each elections office until Tuesday, May 21st, 2024, before 6 p.m. Honorable Kenneth Giddens, Chairman on Homeland Security, Justice, and Public Safety, thanks for inviting me to present testimony on Bill 350248, a resolution petitioning the United States Congress to amend the Revised Organic Act of the Virgin Islands to authorize the people of the Virgin Islands to elect the Attorney General of the Virgin Islands. I'm prepared to respond to any questions you may have. Your voice is your vote, and your vote is your voice. All right, thank you.
Thank you, Supervisor Fox. Colleagues, ladies and gentlemen, that concludes all testimony on Bill number 35-0248, which is a resolution petitioning the U.S. Congress to amend the Revised Organic Act of the Virgin Islands to authorize the people of the Virgin Islands to elect the Attorney General of the Virgin Islands. At this time, we'll take a quick 3-minute recess, and we will return to commence with our debate, which will be at 5 minutes. We will take a 3-minute recess. The Committee on Homeland Security, Justice, and Public Safety for Tuesday, May 14th, 2024 is back on record. We have exhausted the testimonies regarding Bill number 35, that's 0248, that seeks to petition Congress to allow for the Virgin Islands to elect an Attorney General. We heard testimony from the Department of Justice, the Office of the Territorial Public Defender, Attorney Pate, and the elections system. And we will now go to a 5-minute
Point of information.
5-minute debate, but before we go to the debate, let me recognize Senator Francis Heiliger for a point of information.
Thank you very much. As we're about to deliberate, I just wanted to put on the record that while many of the testimony that was brought forward shared many suggestions, there is a very poignant line that is inside of this document that gives the legislature the power, if this is passed, to add all of those things in at a later date. And that specific sentence says the Attorney General of the Virgin Islands and the legislature of the Virgin Islands to prescribe by laws the Attorney General's qualifications and terms of office. So that was deliberately put in there in Section 1 to give the legislature body the power to do quite a bit of the suggestions that you guys have made. Thank you very much, Mr. Chair.
Thank you, well noted. And before we proceed to Senator Bulkis Jr., I just want to say, while I do strongly agree that we need a change in how justice is administered here in the territory, but as I am equally concerned with further politicizing the office, but I will listen to all the debates and arguments here today and proceed thereafter. But even the testimonies, the information given are food for thought, and I will take all those into consideration as well. So we will begin with at-large Senator Angel Bulkis Jr. You're recognized for your 5 minutes, followed by Senate Minority Leader Dwayne DeGraff.
Thank you, Mr. Chair. Good morning, Mr. Chair. Good morning, colleagues. Good morning to the listening and viewing audience. And good morning to Acting Attorney General Clement, Chief Public Defender Smith Todman, Supervisor of Elections Fox, and Attorney Pate. This is definitely has a lot of magnitude. I would have liked to have a bit more than 5 minutes, but I'm sure the chair is going to be lenient. Attorney Pate emphasized that the Attorney General should serve as the servant of the people, not to the governor, advocating strongly for the election to enhance independence from the executive branch. And Acting Attorney Clement discusses the potential of elected officials, including the Attorney General, face different kinds of pressure, such as fundraising, which might affect the independence in another way. But merely being elected does not automatically ensure that an Attorney General has some sort of independence. There are other factors that could impact impartiality. Political affiliations, lobbying for special interests, personal relationships, career ambitions, media influence, financial conflicts, public expectations that do not align with the position, and of course, the political climate. These are all factors that sort of could sway anyone in any one direction. Now, I'm not saying that there's not an eminent issue here in the sense of electing an Attorney General. However, we have to consider what additional local legislation adjustments are necessary to support the election of an Attorney General beyond the resolution to Congress. My first question is going to go to the Acting Attorney General. You suggested, matter of fact, Attorney Pate suggested lowering the residency requirements, and the acting Attorney General suggested increasing them. So there's sort of a topsy-turvy going on here in a sense of requirements in that aspect. So I wanted to ask the acting Attorney General, you suggested increasing the practice law requirements from 3 to 10 years. Can you elaborate on the specific benefits that this change would bring for the Attorney General? Mr. Chair, may I ask if my time be held, as we are not able to hear the acting Attorney General from this side?
General Ian Clement, okay. Department of Justice. The reason that I would like to, or I suggest that you increase it is because it's not just a matter of the individual having legal knowledge or ability. It's about demonstrating a commitment to the Virgin Islands and demonstrating the particular knowledge of its history and what is going on here in the Virgin Islands that you really cannot obtain by practicing somewhere else and then coming in for 1 year. I don't think that that's enough. And the suggestion, I believe, is in line with what is required for judges. If I'm not mistaken, a judge is required to have 10 years of practice of Virgin Islands law before he can be nominated to become a judge. I think the same should be required for the Attorney General. And so I would point to our Attorney General nominee, who has been practicing, for 40 years and has that amount of experience, I believe, as a Virgin Islands attorney, and has lived here off and on, and would satisfy the 3-year requirement if this were a different situation. And I just feel like that it's required, or it would show the commitment to the Virgin Islands to have that type of requirement.
Okay, and on the other side of the spectrum, Attorney Pate, could you clarify?
Yes. So let's be real. Most people who would be running for the Attorney General position would likely be born or raised here. So if they go off to law school, they have to go off to law school, and they do very well. The money that they can make in the States is greater. So for that opportunity, they stay. And let's say this person becomes the Attorney General of Maryland, and then after doing that decides, hey, I'm going to retire. I'd like to go back home. And they move back. And you're going to say, no, you're not qualified enough.
Time.
So the voters now get to be the crucible. You shouldn't set these huge burdens for coming back, because the voters are going to compare you with the other people running and see who's the best fit. And now we talked about the new Attorney General, Gordon Ray, who's a close friend of mine. I don't think he would make the 3-year qualification. He's practiced many years down here, but he wouldn't even make it under the current qualification if you had it at 3 years. But presidents for the United States used to nominate the governors here, and the concern was they would nominate carpetbaggers under election favors, and that's what the Virgin Islands had for a while, was people who were nominated to be the governor that had very little connection to the Virgin Islands. That's where you need high stress levels of, you need to be here for 10 years or this amount of requirement, so you don't have an executive just putting in a carpetbagger. But here you have the electorate that's going to look at people and say, wow, this person grew up, was born and raised here, went to the States, was the Attorney General of Maryland or Virginia, or was a very famous attorney, and now wants to come home. Let the electorate decide that. You don't have to have the thing so strict that it's going to knock people out. Thank you.
And thank you for your answers. And Mr. Chair, I know my time has passed, but may I please ask one additional question?
You may ask an additional question.
Thank you, Mr. Chair. And for Acting Attorney General Clement, Could you further detail what specific causes or criteria that you would justify the removal of Attorney General? Because I believe you mentioned it in your testimony, and I'm curious to know if in fact, if a bill of this magnitude passes, then of course we need to create the framework for electing such an individual in Title 18, in addition to having parameters for his or her removal. Could you please elaborate further and let us know what your thoughts are on that, and how would these critical, this process be fair and not be misused for the removal of an individual?
It would be, I'm sorry, Acting Attorney General Ian Clement, Department of Justice. It would be probably impossible to name all the causes that someone you could remove someone for. I would generally put them in 3 buckets: misfeasance, malfeasance, and nonfeasance. So basically, you know, being involved in criminal activity, being convicted of a crime, misfeasance, or malfeasance, negligence in office, not doing the job correctly, basically, or nonfeasance, not showing up and not doing the job. So, you know, those are the 3 basic categories in which a public official is removed from office.
Okay, well, I appreciate the time, Mr. Chair, and thank you, Acting Attorney General Clement.
Thank you. Before I move to Senate Minority Leader, I wanted to ask the legal minds before us if there's any merit to the notion that prosecutors should be part of and committed to the local community. Starting with the AG.
Could you repeat the question?
Is there any merit to the notion that a prosecutor, I'm getting that feedback, should be a part of and committed to the local community?
Yeah, Acting Attorney General Ian Clement, Department of Justice. Yeah, I believe that there's a lot of merit to that notion, and that, and I will go back to Attorney Pate's example of the individual who's served in another capacity in another state. That doesn't help you to, you know, you may be a daughter or a son of the Virgin Islands, and you went off and went to law school, and you spent your entire career and life in the States, but it doesn't give you the intimate knowledge of what is going on in the Virgin Islands right now. And I think that notion is required. I think that it takes time to build that up. I would disagree with, I believe, with Attorney Pace's suggestion that Attorney Ray would not qualify under the residency requirement. I believe in talking to him at various points in time, he has lived here for.
Okay, I think you're going a little beyond what I asked. I was just asking about the merits of the notion, and I heard your first reply. Okay. Thank you. Chief Public Defender.
Yes, I do believe that whoever becomes Attorney General, whether it's through nomination or election, should be committed to the local community, have lived in the local community, participated in the local community, knows the rules, the laws, practice law here. Thank you.
Attorney Pate?
There's a difference between a slogan that sounds good, and that's what you would want your prosecutor to be involved in the community, and what actually happens in practice. So let's look at the federal attorneys that are appointed by the president.
So I just want to know about the notion.
To be effective, the Attorney General has prosecutors under him or her. Many of those prosecutors are brought down from the states and had no connection before they start prosecuting the murder cases or the misdemeanor cases. And an elected Attorney General is going to be vetted by the populace. And if they don't have a good enough connection to the community, how would they then win the election to be Attorney General? It's a tautological question.
All right. I'm just really concerned about the fish fry election dynamic, really and truly. So I just want us to be careful.
Well,
Senator Dwayne DeGraff, you're recognized for your 5 minutes, followed by Senator Johnson.
Thank you, Mr. Chair. Good morning, Mr. Chair. Good morning, colleagues. Good morning, testifiers, all of you listening and present. Okay, so basically, as Bill number 35-0248, Acting Attorney Clement, you would agree with it. You just have an issue with Section 2. Because it's basically to get a resolution to petition Congress. So you would agree with that part?
Okay. Acting Attorney General Ian Clement, yes, I agree with that part.
Okay, good. And Attorney Pate, you also agree with that part? The petition?
that you need Congress's authority to change the Revised Organic Act. For the Revised Organic Act, that's correct. Right. But I believe that in the Revised Organic Act, Section 11, there is a provision that says, pursuant to Virgin Islands laws, this body has the ability to create an elected Attorney General without the need for petitioning a change in the Revised Organic Act. In sum, you have the power to do this locally, and you do not need to go to Congress.
Okay, I got to follow up with our legal counsel. So right now, that since that was presented through the chair to legal counsel, is that, as Attorney Pate stated, is that, I don't want to say use the word factual, that he isn't giving us factual information, but is that accurate? Through the chair.
Is this question directed to me? Oh, okay.
No, through the chair.
That's through the chair to the legal counsel.
Okay. Mm-hmm. Okay.
Legal counsel, you may respond.
Morning. Through the chair to Senator DeGraff. Attorney Pate is correct in the sense of what he cites Section 11 to be of the Revised Organic Act of 1954 as amended. However, Section 16 of the Revised Organic Act specifically states that there are 9 executive departments of the government of the Virgin Islands, including the Department of Law. And that department is headed by an Attorney General. Section 16C says, of the Revised Organic Act, that all of these executive agencies or departments, including the Department of Law and the Attorney General, shall be appointed by the governor with the advice and consent of the legislature, and shall remain in office until such time as concomitant, I should say, with the term of the governor, or the governor removes the individual or changes the individual. So we have to look at Section 16C, which is specific, Section 16A and Section 16C of the Revised Organic Act, which is specific to the issue of an appointment, the appointment of Attorney General with advice and consent of the legislature. Section 11 is a general provision that gives this body the authority to amend or create any local law. So assuming or presuming the Congress agrees with this resolution and gives the legislature, the people of the Virgin Islands the authority to elect an Attorney General, then Section 11A would come into effect with this body passing local law, amending Title 18 to allow for the parameters, the structure, and the specifics of an elected Attorney General.
Okay, thank you for that. Thank you, Mr. Chair. You know, and for the conversation beforehand in regards to time, Attorney Pate, how long did you say you think it should be? Lower than 3 years?
My general recommendation is to make qualifications not onerous, because the people, the voters, are going to be the crucible that tests the character and quality of the candidate. And you need to keep, so let's say President Obama. President Obama would like to come to the Virgin Islands and run for the candidate of Attorney General. Would you think he's qualified? So
again, you know, the issue of qualification comes in terms of, like you say, if you're putting out to the voter, I'm a voter, I've lived here all my life, I would err on the side of acting Attorney General Clement in regards to having more experience here of the laws here, of the climate here, of the issue that we have here. So in terms of tenure, if, like I said, to increase it to beyond 3 years, I also would agree with that. But I'm just saying that for me, growing up in the Virgin Islands, have always seemed like somebody who come from away, who speak with American accent, always seems to be as if they were more intelligent or that they were better off, and I don't agree with that. So I would err on the side of Acting Attorney General Clement. Mr. Chair, if I may, one final question.
You may.
Okay, thank you. So, Attorney Carty stepped out. I basically wanted to know that based on what Attorney Pate put out, Attorney Clement.
If you want to hold it until he comes back. If you want to hold it until he comes back, I will allow you the time to ask a question or make your statement.
Okay, I'll wait until he comes back because I just wanted to ask in regards to that conversation that Attorney Pate brought forward. Okay, he is
we'll circle back.
I do apologize. He just came back in at Mr. Chair. You want me to continue or you want to?
Yes, you may proceed.
Okay. Okay, so I was just saying, so Attorney Carty, correction. Through the chair to Attorney Carty, in regards to what the conversation was with Section 11 and Section 16C, would this resolution still be needed going forward?
Mr. Chair, may I respond?
You may.
Through the chair to Senator Graff, help me to understand your question. When you say would the legislation still be needed?
Correct, because based on what you said, Attorney Payton said was factual, that Section 11 allows for the legislature to, without Congress, create this law.
Okay, so no. Let me be very specific.
Good.
The legislature has general authority pursuant to Section 11 to create, amend, and alter any law because Congress has given this body that authority to do so.
Correct.
However, in Section 16A and specifically C, Congress has specifically said that the Attorney General must be appointed by the governor with the advice and consent of the legislature. This resolution says to Congress, we want to change that. We want to change that to be able to have an elected Attorney General. So if Congress does give its blessing, then the legislature can then create the local law to be able to have an elected Attorney General. Without that authority from Congress, the legislature cannot exercise its general authority to create, by local law, an elected Attorney General.
I thank you for that. That was my understanding too. That's all just in reference to what Attorney Pate was saying, is I wanted to make sure in terms of what he was saying that we are all on the same page going forward. Thank you, Attorney Carty. Thank you for the time, Mr. Chair.
Thank you. And before we go to Senator Franklin D. Johnson from the West, let me just recognize the presence of Senator Maurice C. James from the East, non-committee member and Education Chair. Welcome. Thank you. Did I hear a point of information?
Yes.
Senator Francis Heiliger, you recognize for your point of information.
I just wanted to put two things on the record. One of the things that our governor, when he was campaigning, pushed for an elected Attorney General, and when he was elected, he submitted to this body legislation to create an elected Attorney General. And this body was told through legal counsel it could not be done. Henceforth, even when I put in legislation to do it, I was told it had to be done in resolution form to petition Congress to alter the revised Organic Act. And I also wanted to put on the record the continuous dialogue in regards to, for example, the statement of the fish fry dynamic. I, as a candidate, we all go out and solicit donations, but at the end of the day, anything can affect a human being. We have to make decisions on behalf of the people, so it's up to the people to elect decent human beings that will not be swayed by monies to alter laws and do things that are wrong. Thank you very much, Mr. Chair.
Thank you, Senator. And I don't believe that the statement was fully accurate with the request made by the chief executive, but if I have to go back and find those documents, we will. But I'll proceed for now until we get that information. Senator Franklin D. Johnson, you're recognized for your 5 minutes.
Good morning. Thank you very much, Mr. Chair. Good morning to my colleagues. Good morning to the testifiers. Good morning to the Viewing and Listening Alliance. This measure, at times I supported it, at times I don't. It's a half or one half or the other. And many times you have to stop and understand that as elected officials who have to raise funds, sometimes people who donate to your campaign, sometimes things they can manipulate you to doing things. And I've run into that sitting in this seat, my very first term. And I could go to instances where folks who donated check that I didn't even put into my account because I felt that was the initiative, the direction that they wanted to go. And it turned out to be just that. Nevertheless, I want to ask the legal minds, but first let me go to Ms. Fox, because I was paying attention and then I got off. In 1998, when they had the referendum, what actually stopped that from going forward?
Senator, a referendum, or call that opinion poll at the time, that's it. The next step will have to be the legislature would have to bring it forward to get it to be law. So it was just a referendum, opinion poll.
So as far as you can recall, no senator never did go forward in trying to move in legislation to do just that.
That's correct, Senator.
Okay, thank you. And then I want to ask all three, as far as attorneys that are here today, what's your take on it? What's your position? Yes, we should go to electing an attorney general, or no, we should remain the same. And that's just me asking you your opinion as people who practice law. So I'll start with Attorney Pate, then we go forward to the right, and then we go to the acting attorney general.
Senator Johnson, the numbers show that 95% of the states have independent attorney generals. 43 are elected, and another 5, when the governor appoints, out of those 5 states, the attorney general cannot be removed absent an impeachment or good cause. That only leaves 2 states, which were Alaska and Wyoming, that allow unfettered at-will termination of the attorney general from the governor. That's 5%. So if you look at 95% versus 5%, I think it weighs in the favor of 95% to say that's probably the more prudent course. The Virgin Islands has a very powerful executive branch. It's very powerful because of how many government employees there are and how small it is. And then when you add in PACs and political action committees, to say that there's not pressure on a non-elected attorney general, if there's pressure on the governor, there is pressure on the attorney general because they're linked. And so I'm going to read from Harvard Law Review here just very quickly. Even in the states using an appointment process, the attorney general is typically independent from the governor, with only Alaska and Wyoming permitting the governor to remove the attorney general at will. Given the common argument that attorney general elections are essential to allow the attorney general to serve as a check on the abuses of power by the executive actors, it's not unsurprising that 48 states have attorney generals that do not serve the governor's will but are elected. That's my position.
Yes or no?
Yes.
Okay. Thank you for that long. Go ahead.
Thank you. Julie Smith Todman on behalf of the Office of the Territorial Public Defender. Whether appointed or elected, our office has to work with the with the Attorney General's office. I would prefer to be Switzerland.
Thank you. we'll get back to Switzerland. I'm quite sure the chair would.
Switzerland meaning, I will allow you the time.
Well, I think we are neutral when it comes to this proposition.
Okay, and Acting Attorney General.
Acting Attorney General Ian Clement, Department of Justice. I too would like to be Switzerland. However,
Wait, we have no Virgin Islanders in here today?
Exactly.
1 minute.
I will say that to the extent that there is influence by the governor, him or herself, is elected and answerable to the people. When you have influence by donors, large donors, the people have no idea where that influence is coming from, and those people are not answerable to those donors are not answerable to the people. And so there's just a caveat as to whether or not to have an elected or appointed, but I have no personal opinion one way or the other. The Attorney General must be independent no matter how he's chosen.
Thank you. And then my next question will go to Attorney Pate. Could lowering the residency requirement influx a lot of, I guess, folks from outside of town who has no tie or will pretty much be aligned to big donors? And I could say this without fear, that I can say this without fear.
Time.
That the last 5 to 6 governors that we have elected, the governor that had won the last 6 times, had the most money spending. I guarantee what I'm saying here. From following the election, paying attention to it, the last 6 governors that we have elected spent the most money in the election versus the one that lost.
You hear time? You want more time?
Mr. Chair, can I allow Mr. Attorney Pate to answer?
I wanted to know, okay.
I sure did hear, but I got so into what I was saying based on
You may sum
factual points.
You may sum it up.
So Attorney Pate, could lowering these bars attract pretty much outside attorneys who might not have no ties to the territory, but come with big bucks?
You have to trust the voters, is what I'd say. If you want to keep it high, then you're saying, I don't trust you voters. And if you want to lower it, you say, I trust the voters. I mean, you can put names in for people who run. We know when Warren Mosler ran, I mean, you look at that and you could say he's outside, he came from here, and the voters got to decide who they wanted. Do you trust the voters or not? I see a situation where most people are not going to spend, if you're able to make the money in the States, you're not coming down just to run the Virgin Islands Department of Justice, which is like a small city. You're going to be someone who has a heart, who was born and raised here or raised here, who says, I want the opportunity to come home. I've made success in the States, and that's why I'm saying keep it low, because that is the 99% chance. The 1% chance of a carpetbagger, it could happen, but I think the voters would decide.
Thank you very much. Thank you very much, Mr. Chair, for the leniency.
Thank you, Senator Johnson. Now we'll move to the committee vice chair, Senator Fonseca. You're recognized for your 5 minutes.
Thank you so kindly, Mr. Chairman, for the time, and blessings and pleasant good morning to all the distinguished testifiers here. We give thanks and praises to the Most High, and good morning. You know, I'm definitely leaning in support of Bill number 35-0248, because I believe that we need a responsible Attorney General and ethical and complies with the law. And there's 2 real reasons why I favor this bill. And one of them is Epstein and the other is WAPA. You know, I've been a senator, this is my first term, and I think we've gone through 3 attorney generals already. But, you know, in studying the matter, I see that this has been back and forth since the 22nd legislature in 1998. This has been a measure that has been before. Should be provided to the Congress of the United States to change the revised Organic Act to provide for the election of the Attorney General. This is from 1998. And then, you know, I have to look at the testimony, right? Because, you know, our acting AG, Mr. Ian Clement, is telling us that actually there are 20 states that does not even require the Attorney General to have a law degree. In other words, you can elect an Attorney General, they don't even have a law degree. Some of them are not even qualified to represent, they're not bar certified in that state. You know, we're hearing the requirement should be 10 years. I'm hearing the requirement should be 1 year. I definitely will never vote for no Attorney General for no 1 year, because I think you need to know this community, you know, we're a different community from all the other states. The federal government treats us differently from all the other states. They don't give us the SSI benefits and, you know, other things. The Medicaid program is not funded like how it is in the states. But I do believe, according to the opinion given earlier from our chief legal counsel, Mr. Cardi, that based on Section 11 of the Revised Organic Act of 1954, that the VI legislature has the general authority. However, Section 16C has to be revised, where we do need to petition the Congress to get that specific authority for the Attorney General. So I can see where the VI government, the legislature, will ultimately have the authority to decide. But I also agree with my colleague from St. Croix, the independent senator from Frederiksted, who said that in the last 6 elections, the governor that won in the general election spent the most money. The governors that win the election spend the most money. That means they have the most financial resources. That means that they are good in soliciting funds from businesses and other people. And when you become an elected official, if your integrity and your accountability is not in line, you're subject to public pressure. And this can affect how you decide on your selective measures that you prosecute. And remember, the Attorney General is the chief prosecutor of the Virgin Islands. They enforce the criminal laws and the civil laws. The Attorney General can decide who they're going to prosecute to go to jail. Mr. Chair, I didn't know, was my time call? I didn't hear the...
No, she said 1 minute. Continue.
Okay, good. So I definitely believe that to be the Attorney General, you must have qualifications. And I think that you should be here at least 6 years. You should be in the territory at least 6 years so you can know the nuances, and you should be admitted to practice law in the Virgin Islands. Now, so there's some issues, but I am in favor of a responsible and ethical Attorney General. I want to go real quickly to Acting Attorney General Ian Clement. I wanted to ask you about the formal opinions that the Attorney General would issue. What would be the difference in the opinions if the Attorney General was elected or if they were selected by the governor? What do you think would be the difference in the formal opinions the Attorney General would issue?
Time.
Can I answer?
You may proceed. You may respond.
Department of Justice. As to the formal written opinions, they have the force of law, and it wouldn't matter how the Attorney General was selected. So once you're in the office, you're in the office, and then your powers and duties, including drafting and publishing formal written opinions, are what they are, and they have the force of law.
Okay, Mr. Chair, if I could just be allowed to wrap up one final question. Okay, thanks. Also, now, I wanted to get your opinion on the process for removing the Attorney General, because we received comment from Russell Pate that 13 senators, he's recommending that 13 senators would have to vote to remove the Attorney General. I don't think there's any other thing that the Virgin Islands legislature requires 13 members to agree on, not even to override the governor's veto do we need 13 senators to agree on. So what would your opinion be on the process to remove the Attorney General?
Well, as I stated in my testimony, there is the process of recall, there's the process of impeachment. We did not consider the vote threshold as far as that is concerned. So I can't give you a formal opinion on that, but I would say that in order to have the Attorney General only removed for cause, in order to have them be independent, it should be onerous to have them removed. It should not be an at-will type of thing. And so I don't know if 13 is the number, but it should not be a simple, I believe, majority vote.
Thank you, Mr. Chair, for the time.
Thank you, Senator Fonseca. Before I recognize Senate President Nova Francis for his 5 minutes, you know, I want us to really think about what's missing from the current system as it is. Again, while I strongly agree that we have a problem with how justice is administered here in the territory by way of the Attorney General's office, because we've seen the movement in at least the last 2 AGs. While we're trying to move away from, while we're trying to depoliticize the office, I'm truly concerned about forcing this in that direction. What seemed to be missing for me in this, and testifiers, you can let me know what seems to be missing is what was just stated, the termination for cause clause within the legislation here, or to terminate by impeachment. We've seen on the national level where Congress even the other day moved to impeach, I think it was the Department of Homeland Security secretary. And I'm saying that probably we need to look at this as well and add in a clause where an Attorney General here in the Virgin Islands can't just be asked to resign, the political way of terminating them, or outright terminating without having that termination for cause clause within our laws. And this will basically take a simple 2/3 vote by the legislature as well. So I think as we continue the discussion, we need to think on this clause as well that I firmly believe is missing from our current system. Senate President Francis, you recognize for your 5 minutes, followed by Senator Capehart.
Thank you very much, Mr. Chair. Good morning to you. Good morning to my colleagues. Good morning to the testifiers, and of course, good morning to the people of the Virgin Islands. I want to thank our testifiers for their testimony this morning in regards to the elected Attorney General. Some have somewhat skirted the issue, in my opinion, or taken a position of not to select one side or the other, but that is certainly your free will. What is concerning to me, and I'll tell you that first of all, in addressing the issue of the administration posture, my recollection at the time in regards to the Attorney General is that the governor had seek to have an overlapping Attorney General, which would be able to surpass his 4-year term, at that time, and had asked for the Attorney General to be considered for 6 years back then. So, that's what my recollection is of that particular issue. But how far are we going to take it? And when we look at this and we talk about the elected Attorney General, are we then going to ask also for elected judges? If we're really truly seeking the people's Attorney General, are we going to also seek for the people's judges? We have a situation where we have judges that will not make a decision whether or not we should have Virgin Islands history in schools, where we are able to educate our community and the history of the Virgin Islands. We moved legislation sometime back, Act 8529, that addressed the issue of Assistant Attorney Generals, where myself and the chair moved legislation to allow for those individuals to actually be removed for cause. Prior to that, the governor had the authority to just remove an Attorney General at his beck and call. There's current legislation, Act 8529. Now those individuals have to be removed for cause. So we know money talk and BS walk. When we talk about the funding that's required for us to be able to move an election forward and select someone to be Attorney General, I wanted to ask you, Attorney Pate, since you have certainly taken the position, the steadfast position, that you believe that this individual should be elected, how will you navigate the issue of conflict of interest in individuals that, again, may placate to the money?
The wheel does not have to be reinvented. There's 43 states that have elected attorney generals. You would use whatever the National Center for State Courts or the National Center for State Legislatures use for those 43 attorney generals.
And in respect to those 43 states, have you not also come across issues where those individual attorney generals have been removed or threatened to be removed as a result of not being available to fulfill their duties of the people's attorney?
I don't know anything that comes to mind recently about attorney generals besides Texas had an impeachment of one of their attorney generals. But I think what we're doing when we talk about money in elections is we're skirting the issue. The real issue is political action committees, where that's dark money that is not reported. And yes, I do believe that the people who can make the donations of $100 or $200 or $300,000 to political action committees, we don't know where that money is going. I don't know if you want to try to challenge the Supreme Court on that. That's the Supreme Court of the United States on Citizens United. That's the decision. But you could put in your local legislation that the Attorney General cannot take donations from political action committees. But right now, the governor appoints the Attorney General. That's the king for the Attorney General. And so, I mean, when you say there's political influence or not, the political influence comes from the governor. That's your boss at the end of the day. And so when you're asking about writing an opinion from the Attorney General, if you're elected, you go, all right, I should do what the people need. But if you're not elected, you go, well, let me check with the governor on what he wants first, because I don't want to be removed at will. So that's the decision you have. It's a binary decision here. And to the elected judges—
1 minute.
I think that's a false comparison. There's voter fatigue. You have to pick what are the most important positions that voters will vote for. If you wanted to elect judges, we have 5 trial court judges on each island, 4 magistrates, 4 Supreme Court. There's 18 judges that would be elected. That's a little much. Your voter can't handle that. But I'm pretty certain that a voter every other year, we vote for governor every 4 years, every other year they could handle on the off election cycle saying, this very important person, let me learn about them. And that's my answer in sum. Thank you, Senator.
Thank you for that. Supervisor Fox, in respect to the opinion poll that was done in 1998, which is some 26 years ago, what is your position in terms of us taking this for another referendum to be able? I think that the dynamics or demographics of the community has changed within the last 26 years based on census report. Do you believe that that it's time for us to perhaps have a discussion in regards to what the people would like to see happen in this issue of the Mr. Chair, if I may just wrap up here?
Sure, go ahead and wrap up.
Thank you. Do you believe that we should go back out for perhaps a referendum and see what exactly the community would want in this instance? Or you believe that the position that was taken back in 1998, some 26 years ago, will suffice?
Senator Caroline Fox, supervisor of elections. From the election perspective, we continue to do opinion polls and referendums and do not take the voice of the people into consideration. So I would not recommend going back out to do it again. We need to look at many referendums that we have done, testing, and no action at the end. So the voters' apathy continues.
Well, thank you for that. Mr. Chair, if I may just ask the Attorney General, the Acting Attorney General, a quick question.
Go ahead.
Acting Attorney General, in regards to your testimony today, have you been able to discuss with the incoming Attorney General, Government House, or any other entity, or Solicitor General? How did you prepare for your testimony this morning in regards to answering or providing your testimony? Any dialogue or discussion with others?
Acting Attorney General Ian Clement, Department of Justice. The only discussions that were undertaken were with the Attorney General nominee and my special assistant, and that's it.
Very well. Thank you. Thank you for that. Thank you, Mr. Chair, for the time.
Thank you very much for your line of questioning. Senator Diane Capard, you are recognized for your 5 minutes.
Thank you, Mr. Chair, and good afternoon, colleagues. And good afternoon to the people of the Virgin Islands. Good afternoon, testifiers. I'm not a member of this committee, but I thought it was very important to come and listen and hear from all that is here before us to give testimony. And I was here saying, well, I remember there was a referendum, and I didn't even know it went all the way back to 1998, 1999. So based on the people of the Virgin Islands, they're saying their biggest question has always been, can the Attorney General act independently? Because this position is appointed by the governor. So, you know, there's always conversations. And then you look at what's happening in the States versus the Virgin Islands. And one of my things, and I've seen it with even being in rules as the chair, since this administration, we've had 2 resignations of Attorney General. So I don't know what the problem is, but there is concerns. And one of my questions I wanted to ask, if an appointed Attorney General was found to do something unethical, is that done by the removal of the governor solely, or is that the Supreme Court that would be responsible for that? Acting Attorney General?
Acting Attorney General Ian Clement. With respect to attorney ethics, that would fall to here and in many states, the Supreme Court and the Office of Attorney Discipline, as far as that's concerned, if you're talking about ethics alone.
Okay. And can the elected Attorney General decline to represent the governors on a position or on an issue that they're concerned with, that is sensitive issues? Can they recluse themselves from giving an opinion?
I need some more clarification from the senator. Are you asking if the attorney general can decline to represent the governor in a court matter, or whether or not he could or she could decline to advise the governor?
That's a good question that you like for clarification on both issues. On both issues.
The attorney general is the chief law enforcement officer. He represents the government in all
Right.
court matters. The attorney general.
I want to know if there's something that's sensitive, that there may be a conflict, can that attorney general say, I decline to represent, and who would be that person that would deal with that issue if the attorney general says, I don't want to touch this? Who would deal with that?
If theoretically the governor did something that was not within the scope of his elected office, there might be a situation where, and I haven't researched this, but there might be a situation where the attorney general might not be able to represent the sitting governor. But I would need more facts and more information to really intelligently answer this question.
1 minute.
Thank you. Mr. Chair, I will just continue to hear the conversation on this very important matter that's before us today. I totally understand the intent of this legislation, and I totally understand that the people of the Virgin Islands, they've obviously said that this is a concern. This is what they want from 1998 to 99, where there was a referendum. I look forward to further discussion. Thank you, Mr. Chair.
Thank you, Senator Capehart. And before I move on to Senator Maurice James, I also, as I'm still trying to look at this, because again, I want to continue to say, I understand exactly what the proponent of the measure is seeking to do, because we do have a problem. But another issue that I'm seeing that we might be creating with the elected Attorney General proposal is that we will remove the legislature's ability to have oversight of the Department of Justice's activities. Do we really want to give up that oversight responsibility as a legislative body, which creates that level of checks and balances? Again, I will continue to listen to the debate and the arguments, but I do have real concerns regarding the election of an Attorney General. Senator Maurice C. James, you're recognized for your 5 minutes.
Thank you, Mr. Chair. Good morning, Virgin Islands. Good morning, testifiers. Good morning, colleagues.
Good afternoon, 14 minutes after.
Oh, good afternoon. Thank you. Thank you. You know, when I first saw the resolution, I responded emotionally based on the fact that we've had the dismissal of 2 women attorneys general. Quite frankly, I did. I said, you know what, we need to elect. But then I said, well, let me look at this a little more. And so, like Attorney Pate, I also looked at the founders. And Alexander Hamilton was for a unified executive structure. If men were angels, no government would be necessary. Right? We know that.
Repeat that.
If men were angels, no government would be necessary. You know? Human beings. So,
You got it now, right? Okay.
if human beings were angels,
Okay. Okay.
no government would be necessary. But you know, I looked at what Alexander Hamilton said, but I also looked at the history of why this resolution is before us. And you know, I said the governor, in fact, selected very qualified women to be attorneys general. We had no problem because the Senate confirmed the both of them. And so we were able, as senators, to look at their qualifications closely, more so than voters would have during an election. So I thought, maybe I need to rethink whether or not electing an attorney general is the right way to go. And mostly because in an election for governor, and I'm using that specifically, we elect anyone to become governor of the Virgin Islands, quite frankly. But an attorney general has to have not only administrative skills, but also must have, to me, a high degree of legal expertise. And it's very difficult for voters in any election, whether it's governor, senators, delegate to Congress, at-large senator, to really have the opportunity to be informed about qualifications. So that came up in my thinking about the position. So I wanted to ask Attorney Pate, going back to Alexander Hamilton, and his position that the unitary executive system is better because he feared, number one, that having an attorney general run independently from a governor, that it would create confusion in the community because they would be split on different issues. In addition to that, history has shown that most attorney generals who are elected eventually run for governor because it gives them the opportunity to, and their focus is more on running for governor. So I wanted to ask Attorney Pate to just have this conversation with me about what Alexander Hamilton said. Because he also said, he also said that, I hope we have another wrong, that it would conceal faults and destroy responsibility. And it would be difficult for the public to know exactly who is responsible for failed policies because the governor would be blaming the attorney general and the attorney general would be blaming the governor. And he also said that in this system, right now that we have, the responsibility for failed policies rests with the governor, right? What's your response to that, Attorney Pate? Thank you.
This debate has raged for 250 years, and the antagonist to Hamilton was Thomas Jefferson.
Yeah.
Thomas Jefferson said, Hamilton, you want George Washington to be a king. You're a Tory. You don't believe in the voters. You're elitist. And that's what Thomas Jefferson called Alexander Hamilton. And Jefferson won. That's why 95% of the attorney generals are independent, and 43 states elect their attorney generals.
But I'm going to, but not the federal government. The federal government still has a unitary executive system. And when, okay.
And that's correct. And then we had comments here on that we need this goes back to what some of our honorable senators here said, we want the attorney generals to be local and plugged in and understand. Yet almost all of the federal government attorney general appointments, the attorney generals for the federal government up until recently have been people who were sent down here. Attorney Ron Sharp.
I agree.
Gretchen Chaparrott, even Dave Nisman when he came down. And so when I hear the comments saying, oh, you need this, well then where's the indictment on the federal system? I want to hear one word out of anybody's mouth saying these were terrible attorney generals for the federal government.
U.S. attorneys.
Okay, so
right? Yeah.
what's happened is Alexander Hamilton created a strong federal government that has stayed, which was not, it was not supposed to be that strong, but it has turned into, the Leviathan. And Jefferson said, no, there should be rights to the states, and that's why states have more elections than the federal system. It all comes down to what you want is you're elected by the people. So every time you say, well, I don't really trust the people to look at qualifications, that's an indictment to every senator that sits in this body.
No, I agree. May I wrap up, Mr. Chair? But let me say this too. The voters elect an attorney general, and the attorney general gets donations from Jeffrey Epstein. What then? That's the question. So what then? The donors that, right? There is still that's the big problem. That challenge, right? That we face. So,
that is the big issue that we're not addressing head on, is the elephant in the room, and that's political action committees. So when you see we don't know what political action committees donated to the executive branch, and this is not any governor now. This is every governor's problem. And then if you look at EDC, who runs EDC? That's a government executive branch that runs EDC. So that means if you are getting tax credits for EDC and you're a very wealthy person who came down from the states, how do you keep your tax credits flowing? You keep the governor happy, who then keeps his committee happy. So how do you get money for re-election? That's the elephant in the room that the body needs to be looking at, because if you solve that issue, you solve the Attorney General elected issue. Because right now it passes right from the governor to the Attorney General, because any influence on the governor is the influence on the Attorney General.
But I will remind you that we had 2 women attorneys general who were independent in their thinking about what they were going to do. Thank you, Mr. Chair.
You're welcome, Senator James. And I agree with you. I'll get to you in a minute for your point of information. You're absolutely right in a lot of your comments. And a lot of mainland attorney generals that I could think and, spend a lot of time at AG conferences and whatnot. You know what basically doing? To seek the governorship thereafter. Again, we just need to be careful on how we cross the treacherous seas in further politicizing the office of the Attorney General. I will do my comments, but let me hear the point of information from Senator Frances Heiliger before I recognize her as well.
Thank you so much. Good afternoon once again. I would like to make sure, put on the record, that there are several senators in this body that received donations from Jeffrey Epstein. So to make that an argument, I am not supporting that today. Please. And there are several senators in this body that have gubernatorial aspirations. Several senators from within this body have left this body to run for the governorship. So please, let us not try to attribute everything to electing an attorney general. Because the fact of the matter is, if we're going to sit here and tell the public that they're good enough to elect the governor, they're good enough to elect us as senators to sit here and represent them, but somehow miraculously they can't figure out how to elect an attorney general when 13,000 of them went to the polls already and told us, their representatives, we want this done. Shame on us. Thank you very much, Mr. Chair.
I want to also remind colleagues what the debate process is. We may not agree with another colleague's comments, but it is for us to put on there. And as a proponent of the bill, you did state that you want to hear from others. So let's not indict each other based on certain comments. Senator Senator James, you recognized for a point of information.
Thank you, Mr. Chair. I want to thank you for what you just said. I really want to thank you because if you look at, it's kind of interesting because when I said I did my research, it was because as an attorney, I did exactly what Attorney Pate did. He went and he looked at the Harvard Law Review, and so did I. And one of the parts of it was the political pressure that is put on elected attorney generals, and the fact that it becomes so contentious in the community. So I was simply being what I think I should be as a senator and considering all sides. As I started, I said, I actually lean towards an elected attorney general, but I'm doing my research, and I need to be informed when I make decisions in this body. So I want to thank you for what you just said.
Thank you. And point of information, Senator President Francis.
Thank you very much, Mr. Chair. I think that the conversation is necessary today in respect to what we're experiencing and discussing. While we're talking about there's several attorney general that have resigned in this administration, in the prior administration, and the prior administration, there have also been challenges as well with the attorney generals. This is a long-standing issue. I think the discussion is how do we move forward to address this this issue of the attorney general. So, debate and discussion is definitely necessary, and I appreciate the discussion today. Thank you.
Definitely, thanks. And point of information at large, Senator Bulkers.
Thank you, Mr. Chair. And, conversations such as this sort of give us the importance of the 6th Constitutional Convention, which is incredibly important to the Virgin Islands because it allows us to address and fix governance issues by coming together and drafting a constitution so we can create a legal framework that truly reflects the values and needs of our society, not the reflections of individuals from the 1950s. This is our opportunity to enhance our territory, our autonomy, and ensure greater accountability and increase democratic participation. For example, this issue that's before us, this is an issue that the 6th Constitutional Convention should be able to cover, in essence. So ultimately, this convention is about empowering us to shape our future and build a stronger, more determined territory. Thank you, Mr. Chair.
Thank you. Senator Bulkers, you could put 5 minutes on the clock there, Madam Clerk. Again, I want to remind us that what's the system that's currently before us allows for the nomination and appointment of our Attorney General. And what we do currently see is that they come before us well suitable and qualified. Most, if not all, have been approved by the legislature. Again, you have that check and balance. We may not agree on some of their decisions, but we know that they come qualified. Again, what we must seek to do is to not have the governor, any governor, not just this particular governor, but any governor have the sole responsibility or the sole authority to decide whether to terminate the Attorney General just because he or she may not see a particular subject matter in the same way that the chief executive sees it. And again, this is why too, I have coming before the legislature in short order the bill to enact the Commission on Ethics and Conflict of Interest, and which has a companion bill And that bill is 35-0227, and the companion bill, which will be 35-0228, that enumerates the duties and responsibilities, or the duties and functions of the VI Commission on Ethics and Conflict of Interest, and appropriating monies to organize this office. We know we have to address this problem, but again, I'm not sure about further politicizing the office. There's nothing to ensure that an elected AG will be more effective in carrying out their duties and responsibilities if they were to be elected. In an elected position, the best sounding name or the most recognized name, or those with the largest pockets, may prevail. Is that what we want to really see and create another problem? I don't believe that's exactly what we want to see. So again, I just would like us to work more collectively and find a way forward in addressing this matter. But at this time, really and truly, to further politicize the office, this sitting senator does not agree in going in that direction. Again, the checks and balances are there. We know we just seen some rogue behavior, and when we see the rogue behavior again, I blame this body, because we are a body of 15, and if we're gonna allow one to just run rogue and do what he or she wants, then who is to blame? Every tub must sit on its own bottom. That said, Senator Francis Heiliger, I'll allow you to conclude the round. You're recognized for your 5 minutes.
Thank you. Just for clarity, I'm going to leave that alone. Good afternoon once again to my colleagues, to the testifiers. There are several things I want to address here. I'm not sure what the rogue behavior comment was in regards to, but apparently speaking truth on this legislative floor is offensive to some. 1 year versus 10 years has been the statement of two different individuals here. In the resolution, the reason why I opted to do 3 years, it was because our laws allow for individuals running for Senate to have a 3-year term. 3 years prior to the proceeding of the next general election. I didn't want to make the term so small that people are not ingrained in our community to the point that they really don't know us as a people, our culture, and who we are. I didn't want to make it so great and far out that it's almost unreachable to be able to run for this office when you might have been embedded within this community. One of the things that is continuously being spoke about here today is funding and money. I am one of 15 senators, and we are now in an election year. And when we go out, we solicit donations. People contact us and offer us funding to help with our campaigns, all 15 of us. And I am sure, like one of my colleagues said, sometimes there is undue pressure. But the very electorate that went to the polls and put each one of us in here, they made the decision that we're going to trust you to be our representative. We're going to trust that you are a decent human being. We're going to trust that you're going to be fair to us. We're going to trust you're not going to fall into the hands of those that are offering money just to create laws for their personal benefit. I have sat in this institution and watched a lot of things over the last 3.5 years. I see people get up and want to give the public one perception of who they are, but in reality, it's not the same thing. When we have a people that have gone to the polls and have said, we want an elected attorney general, for some reason, this body over the years continuously figures out a way to tell them, yeah, you told us this is what you want, but we don't think it's necessary. We don't think that's what you should do. Well, then why do these polls? I sat here and I listened to the comments of fish fries. I, as an independent candidate, I've never held a food sale or fish fry ever. I got elected. So there are some of us that will get into this body without doing those things. The people decide. And when are we going to get away from always speaking to them that they're smart enough to put us here to make decisions for them, but somehow they're not smart enough to elect someone that could be their attorney general? That is where I took offense for my people. I also heard about the politicizing of this office. By nature, this office is politicized.
1 minute.
Give this office an opportunity to be independent and elected and be held accountable to the people, I could understand that. But I also take note, several individuals here spoke today and specifically talked about the potential of the undue pressure coming from a governor. I don't want anybody to walk away with the impression that this is a knee-jerk piece of legislation I'm putting forward here. This legislation was submitted January the 11th, 2021. And this is far before any of these firings, people leaving office. This was already submitted. Because when I got elected and got sworn in, I came in with a mission to do the will of the people. And that was always my motive. So any other aspersions outside of that has nothing to do with me. All of the suggestions that were made by several, Mr. Chair, may I wrap up?
You may.
Thank you. All of the suggestions that were made by several individuals here, the Board of Elections, the AG's office, I applaud them. Within this resolution, all we are seeking to do is say, Congress, can you give the legislature permission to allow us to craft legislation that we can elect our Attorney General? That's what we want. And at the end of the day, between the 15 of us, we'll decide that. But one of my colleagues made a note in regards to, let's wait again now for the 6th Constitutional Convention. 2007 is when the 5th Constitutional Convention started. From then up until now, we're still debating over this 5th Constitutional Convention, which included an elected Attorney General. So even in that body, the will of the people was spoken. It was included in the 5th Constitutional Convention. But because we can't decide how to get that sorted out, we on to a 6th. So here we are again telling the people to sit back and wait. Let me wait till the 6th, maybe for another 20 years. We have to stop. The people put us here to represent them. Now, as my colleague, is one man, one vote. We are all different and unique people in this institution. But I always came in here with one agenda. Put the people and their needs first. Nothing more, nothing less. And I am asking my colleagues to support the will of the people, because they have clearly said to us over and over again, we would like an elected Attorney General. Let their voice be heard. Thank you very much, Mr. Chair.
Thank you, Senator Francis Heiliger. Colleagues, we've concluded all debate time on Bill number 35. There's 0 248, a resolution petitioning the U.S. Congress to amend the revised Organic Act of the Virgin Islands to authorize the people of the Virgin Islands to elect the Attorney General of the Virgin Islands. We've heard testimony again from the Department of Justice, the election system of the Virgin Islands, the Office of the Territorial Public Defender, and Attorney Pate, who is representing himself. The committee will take a brief, and I say again, a brief 3-minute recess, and we will be back to make a motion on this bill. 3 minutes. The Committee on Homeland Security, Justice, and Public Safety for Tuesday, May 14, 2024 is back on record. At this time, I will allow for the closeout remarks from each of the testifiers, beginning with Attorney Pate this time.
Thank you, Majority Leader Gittens. My testimony was more to educate the body. You are the elected people of the Virgin Islands, and I just thank you for the deliberation on this issue. The majority of states have elected attorney generals. It is possible to have an elected attorney general. I think the backup would be, if you do not want an elected attorney general, then this body should create a way to protect the attorney general, like the other 7 states that have appointed attorney generals, that you can put in a process that removal should be through good cause, and they should go through the legislature for that removal, and you can set up that process. That may be a fallback that's safe. I would conclude with, you have more power than you think you do. I know you think you're constrained by the Revised Organic Act, but at the same time, Congress is very far away. And I think even a lot of people in Congress, they don't even know about the Virgin Islands. You need to push forward on things that are important to the people of the Virgin Islands, and then get Congress's attention, that you're doing something here, you're taking action, instead of trying to yell in their ear when they're dealing with other issues of immigration and dysfunction in Congress. It's dysfunctional. Show the people of the Virgin Islands that your body works, and move forward with local legislation. And I highly respect Attorney Amos Carty, and he's being, looking at this very diligently. But it's a more conservative opinion. And my opinion to the body would be, go ahead and draft the local legislation, flex your muscle. It's that old parable of there is this giant horse and a little boy riding the horse. And that horse could have thrown that boy off any second. But that horse has been trained for so many years to be docile. And that's what's happened with the Virgin Islands is, the Virgin Islands was under the Navy, and then it's under, a presidential appointment, and you've grown from Danish power. So you are the people who speak. You're the elected representatives. Power derives from the people. So do what you think is best, and don't be worried so much about Congress.
Thank you. Beyond 30 seconds, but thank you.
I'm sorry.
I like your fallback to terminate for good cause. And I'll add the removal by impeachment of 2/3 votes of the legislature. I don't want to get in trouble. Supervisor Fox, you're recognized.
Thank you, Senator Gittens, for this opportunity. But being from election matters. So the election, the people spoke. When they did opinions, we do continuously to do referendums. So I will support elections. Just send them to us. Your voice is your vote, and your vote is your voice. Thank you.
I understand. It keeps you in business. Thank you. Chief Territorial Public Defender, you're recognized for your 30 seconds.
Thank you. Julie Todman on behalf of the Office of the Territorial Public Defender. What I've heard today from everyone, including all of the senators that have testified today and the senators that have spoken, is that there seems to be an issue with the removal by will of the attorney generals. And I agree with Attorney Pate that something should be done, and should not be a removal by will, but a removal for cause, because it is the legislature has to, the governor nominates and appoints, and the person is chosen by the advice and consent of the legislature. And because of that, the removal by will seems to be disingenuous by the governor. And so I would suggest that there should be something that the legislature can do with their power, so that the Attorney General is protected. That's what I would suggest.
Thank you so much. In essence, again, the clause that is missing currently from our code. Acting Attorney General Clement, you recognize.
Thank you. I am a member of the National Association of Attorneys General. 43 of my colleagues are elected to their office. Don't want to besmirch their integrity. They what is right for the states may not be right for the Virgin Islands. And I'm not saying that an election is not right, but you really do have to be careful and mindful. And I know this body will, at the end of the day, whether elected or appointed, the Attorney General must be independent, independent of all influences, whether it be the governor or any other outside influence. And we endeavor to do so. And I really do thank you for the opportunity to speak before you today.
Thank you so much for that closing. And I do agree. What's good for the state is not necessarily good for this small knit community. And I think, someone may have said it, but it wasn't said enough of our small knit community and what this election of an Attorney General could be. But at this time, I will entertain a motion on the bill that's before us.
Motion.
Motion, Senator Francis Heiliger, you're recognized for your motion.
Thank you very much, Mr. Chair. I move to offer Bill number 35-0248, a resolution petitioning Congress of United States Congress to amend the Revised Organic Act of the Virgin Islands to authorize the people of the Virgin Islands to elect an Attorney General of the Virgin Islands. That this bill be voted on favorably in this committee and sent to the Committee of Jurisdiction, Rules, and the Judiciary. I so move.
Second.
The bill was properly moved by Senator Francis Heiliger, second by the Senate Minority Leader Dwayne DeGraff, and objected to by Senator Franklin D. Johnson. Roll call on bill number 35-0248.
Senator Angel L. Bocas Jr. Senator Bocas Jr., nay. Senator Dwayne M. DeGraff.
Yes.
Senator DeGraff, yea. Senator Ray Fonseca. Senator Ray Fonseca?
Not voting.
Wait, not voting? Okay. Senator Alma Francis Heiliger?
Yes.
Senator Francis Heiliger, yay. Senator Javon James not voting. Okay.
No, absent.
Absent, I apologize. Senator Javon James absent. Senator Franklin D. Johnson? No. Senator Johnson, nay. Senator Kenneth L. Gittens?
No.
Senator Gittens, nay. Okay. Mr. Chair, you have 2 yeas, 3 nays, and 1 absent. Oh, I'm sorry, I apologize. 1 absent and 1 not voting.
Thank you. The motion has, bill number 35-0248 has failed. 3 no,
I'll repeat.
2 yeas, 1 not voting, and 1 absent. The measure has failed. The Committee on Homeland Security, Justice, and Public Safety hereby recess for, it's now 12:58. We will resume at 1:30. Committee on Homeland Security, Justice, and Public Safety for Tuesday, May 14, 2024, stands in recess. The Committee on Homeland Security, Justice, and Public Safety for Tuesday, May 14, 2024 is back on record. Good afternoon. Earlier this morning into the afternoon, we heard testimony on Bill number 35, that's 0248, which was a resolution to petition Congress to allow for the people of the Virgin Islands to elect an Attorney General. We had debate and a motion made that failed, so that measure died. Now we're moving into Block 2, and I'll ask Madam Clerk to please read Block 2 into the record, just Block 2. We have 3 blocks, but just Block 2.
Block 2 to start at 1:30 p.m. Bill 350238, an act to confer peace officer status on qualified enforcement officers employed by the Government Employees Retirement System of the Virgin Islands, sponsored by Senators Milton E. Potter and Angel L. Bocas Jr. Invited testifiers are the Honorable Ray Martinez, Commissioner of the VI Police Department, and Angel L. Dawson Jr., Administrator of the Government Employee Retirement System. That concludes Block 2, Mr. Chair.
Thank you. Noted that we start at 1:50. Welcome. At this time, I will just do a mic check, make sure that your mics are working and that we identify the testifiers before us. I don't see anyone online nor any testifiers at the testifiers table on St. Thomas. So starting on my right, with the GRS Administrator, please state your name, title, and agency you're representing.
Yes, Honorable Senator Gittens. I'm Angel Dawson, E. Dawson, Jr. I am the Administrator and Chief Executive Officer of the Government Employees Retirement System of the Virgin Islands.
Thank you.
And here today in my capacity as head of the Havenside Mall.
Thank you, and welcome.
Good afternoon. I'm Roy Moorhead, Acting Property Manager and Chief Security Officer of the Government Employees Retirement System at Havenside Mall.
Thank you. I didn't recognize you, sir. How are you?
Well.
Welcome.
Thank you.
Sir?
Good afternoon.
Good afternoon,
I'm Sidney
sir.
Olsko, Assistant Commissioner of VIPD. Today I'll be sitting in for Commissioner Ray Martinez as he could not be here.
Thank you. Welcome to all of you as we begin our discussion on Bill number 35, that's 0238, an act to confer peace officer status on qualified enforcement officers employed by the Government Employees Retirement System of the Virgin Islands, sponsored by Senators Potter and Bocas Jr. At this time, who speaks to this bill?
Senator Angel Dawson.
Senator? Senator Potter? And I'm also recognizing the presence of non-committee member, Senator Milton Potter. You're also recognized for the introduction of this bill.
Thank you very much, Mr. Chair. Good afternoon, colleagues, and a special good afternoon to the GRS Administrator and CEO, Mr. Angel Dawson Jr., Acting Property Manager and Chief Security Officer, Mr. Roy Moorhead, and Assistant Police Commissioner, Mr. Sidney Elsko. Colleagues, I ask for your support on Bill number 35-0238, an act granting peace officer status to qualified enforcement officers employed by the Government Employees Retirement System. This designation would improve security and safety for both tourists and locals alike at the Havenside Mall. Over the past 2 years, we've witnessed a spate of serious crimes committed at that facility. The passage of Bill number 35-0238 would enable GERS enforcement officers stationed at the Havenside Mall to complete the requisite peace officer training via the police academy, the VI Police Academy. These officers would have the authority to respond to emergencies, enforce laws, and maintain order within the Havenside mall premises, thereby deterring criminal activity and ensuring a peaceful environment for both locals and visitors alike. Additionally, having peace officers on site will enhance the overall reputation of the mall as a safe and secure destination, potentially attracting more visitors and boosting the local economy. While I'm not a member of the Committee on Homeland Security, Justice, and Public Safety, Mr. Chairman, I respectfully ask for your support and the support of the other committee members to move Bill number 35-0238 on to the Committee on Rules and Judiciary for further consideration. Thank you very much.
Thank you, Senator Potter. At this time, we will hear testimony from, let's start with the GRS Administrator. You're recognized for your testimony at this time.
Yes, good afternoon, Senator Gittens, members of the Committee on Homeland Security, Justice, and Public Safety, all other senators, and all others who have tuned in to this meeting. My name is Angel E. Dawson, Jr. I'm the Administrator and Chief Executive Officer of the Government Employees Retirement System, and we are the proud owners of the Havenside Mall. I have with me today Mr. Roy Moorhead, who is the Acting Property Manager and the Chief of Security of Havenside Mall. He will be taking the lead on our testimony as he is the subject matter expert. I would certainly like to thank Senator Milton Potter and Senator Angel Bolkes for seeing the importance of bringing this measure forward. Havenside Mall is a very important asset to the GERS and to the people of the Virgin Islands. We have almost 1 million persons that visit our property, either through cruise ships or locals and persons that stay at our hotels. When you consider the fact that we also have next door Yacht Haven Grand and we have Port of Sail, you have what we would like to consider a district that warrants a great level of security to ensure the safety and security of our visitors, as well as our locals that patronize the facilities mentioned. So with that, I'm going to turn it over to Mr. Moorhead, who will give our testimony. But I would also like to recognize that this is National Police Week, and we would like to thank all police officers, police personnel, wherever they may be, including you, Senator Gittens. Thank you for your service.
Thank you, and thank you for that reminder. I did say it earlier today, but I was supposed to say it again, so thank you for that. Mr. Moorhead, also, I don't know if to say formal law enforcement or whatever, but you have the floor.
Good afternoon, Senate Majority Leader Kenneth L. Gittens, Chairperson of the Committee on Homeland Security, Justice, and Public Safety, esteemed committee members, other legislators present, and members of the viewing and listening audience. I am Roy Moorhead, Acting Property Manager and Chief Security Officer of the Government Employees Retirement System at Havenside Mall. We respectively request your support for this legislative amendment, Bill number 35-0238, which aims to confer peace officer status on qualified enforcement officers employed by the Government Employees Retirement System of the Virgin Islands. For those who may not be aware, the Government Employees Retirement System owns and operates Havenside Mall. This proposed legislation, sponsored by Senators Milton E. Potter and Angel L. Bolkes, Jr., is not...
Can I ask you to hold one second?
Sure.
I'm going to take a recess just to ensure that all my colleagues have a copy of your testimony.
Sure.
Okay?
Sure.
The committee is standing in recess for 3 minutes. My apologies. The Committee on Rules, the Committee on Homeland Security, Justice, and Public Safety is back on record Tuesday, May 14, 2024. We will continue with the testimony from the Government Employees Retirement System, and you may begin from the start.
Good afternoon, Senate Majority Leader Kenneth L. Gittens, Chairperson of the Committee on Homeland Security, Justice, and Public Safety, esteemed committee members, other legislators present, and members of the viewing and listening audience. I am Roy Moorhead, Acting Property Manager and Chief Security Officer of the Government Employees Retirement System at Havenside Mall. We respectfully request your support for this legislative amendment, Bill number 35-0238, which aims to confer peace officer status on qualified enforcement officers employed by the Government Employees Retirement System of the Virgin Islands. For those who may not be aware, the Government Employees Retirement System owns and operates Havenside Mall. This proposed legislation, sponsored by Senators Milton E. Potter and Angel L. Bolquez Jr., is not merely a request for enhanced authority. It is a strategic initiative to enhance the safety and security framework of Havenside Mall, a bustling hub and significant cruise port in the U.S. Virgin Islands. Your support for this amendment is pivotal to realizing GERS's shared vision of a safe and flourishing community. Havenside Mall's diverse commercial ecosystem includes a wide variety of venues, ranging from popular restaurants such as Agave, Tap and Still, Smoking Rooster, and Virgin's Haven, which draw significant local nighttime activity, to many retail stores, including jewelry, souvenir, and clothing stores. This vibrant mix attracts a significant daily influx of locals and tourists, notable cruise ship passengers who account for a substantial amount of our foot traffic. The variety of offerings, from dining to shopping, ensures that Havenside Mall remains a key destination for visitors and residents alike, contributing to the vibrant atmosphere and economic vitality of the area. Therefore, it is imperative that our security apparatus be robust, responsive, and equipped with the necessary authority to ensure the well-being of all who visit. Granting peace officer status to our security officers will elevate our capability to address potential threats and emergencies with the greatest success. We view this proposed legislation as being rooted in a collaborative security model. It respects the primary role of the Virgin Islands Police Department, VIPD, during emergencies, suggesting that in such times, peace officers, including GRS enforcement officers, would be temporarily assigned to VIPD to leverage our law enforcement resources effectively. This approach enhances the operational response to emergencies and solidifies an ongoing partnership with the VIPD. Furthermore, the proposed legislation empowers our officers to assist the VIPD in enforcing a broader spectrum of laws and ordinances, thereby comprehensively enhancing public safety. This includes aiding in traffic control activities, enforcing other laws, and responding to assist the VIPD when needed. By working collaboratively with the VIPD, our officers will play a vital role in upholding the law, deterring potential infractions, and contributing to a safer environment for the residents and visitors. A noteworthy aspect of this initiative is its impact on the visitor experience. The presence of peace officers at Havenside Mall is crucial, especially during critical times such as the disembarkation of cruise ships, some of which can carry up to 6,000 passengers each. On days when as many as 3 ships are docked at the Waiko cruise ship dock, the total number of passengers can be as high as 14,000 passengers, and up to 4,000 crew members. In 2023, Havenside Mall welcomed approximately 800,000 cruise ship passengers, excluding local resident shopping, overnight hotel guests, and participants in nighttime events or local entertainment. For 2024, we anticipate the number of cruise ship passengers to range from 800,000 to 1 million, not accounting for these additional groups. This forecast, coupled with the popularity of nighttime activities and events that attract further crowds, underscores the critical need for maintaining a secure and welcoming environment at the mall. The presence of peace officers provide a profound feeling of safety and assurance to visitors and tourists during such peak periods. This reassurance is vital for sustaining and enhancing the Virgin Islands' reputation as a safe and welcoming destination. It also aligns with our economic objectives by encouraging tourism and spending, which are essential to our local economy's vitality. In essence, the proposed amendment is a comprehensive strategy to reinforce public safety, foster a secure environment for economic activity, and enhance the overall experience of visitors and locals alike. It underscores our commitment to proactive security measures and collaborative law enforcement practices that benefit our community. The GRS wholeheartedly supports this legislation and deeply appreciates your consideration of this amendment. Your support in enacting this legislation will mark a significant step forward in our ongoing efforts to ensure Havenside Mall remains a safe, attractive, and prosperous center for commerce and tourism in the U.S. Virgin Islands. We look forward to working together to make this important change a reality, and we are available for any additional information or questions you may have.
Thank you, Mr. Moorhead. I almost had me sold, boy. Virgin Islands Police Department.
Yes, good afternoon to all. Sidney Olsko, Assistant Commissioner of Virgin Islands Police Department. Senator Gittens, I have before me a letter from Commissioner Ray Martinez. I'd like to enter it into the record.
And all my colleagues have a copy of that letter. I think you may proceed.
It's titled, Invitation to Provide Testimony on Amendment to Bill Number 35-0196.
Okay, we're not there yet. We're discussing specifically Bill number 35, that's 0238. So my apologies, you could skip that one.
Yes, sir, I will continue with the content. It says, thank you for providing the, standby one, please. Thank you for providing the Virgin Islands Police Department the opportunity to offer testimony on an amendment to Bill number, there it goes again.
You may just proceed with your testimony and leave that letter for the other one.
If I can, I'd like to just skip over the part that does not have anything to do with what
this. Okay, you may proceed.
It says, peace officers employed with GERS would lend heavily to the tourism-oriented policing initiative, GERS property, and the neighboring highly traversed tourist areas. Moreover, VIPD's resources could be transferred to other areas of need. In short, we welcome confirming such status to said officers to assist in providing a more robust public safety experience for our tourist product. Law enforcement agencies around the nation continue to experience common tourist-oriented patrol issues in the areas be able to cover upon conferring peace officer status as referenced. Among the major problems are lack of finances. Law enforcement agencies interviewed stated that despite the importance of tourism to their local economy, city, state, provincial, or national governments did not provide those agencies with the proper level of funding. There was a common perception that governments want tourists to receive extraordinary services within the confines of ordinary budgets. Often, law enforcement agents suffer from low morale due in part to low pay and lack of resources. Personnel shortages. Police departments indicated that increasing uniformed personnel in high traffic areas is a major way to prevent crime. However, due to budget constraints, and in the case of regulations regarding compensatory time, efforts by police departments are limited. This results in the inability of departments to schedule the requisite number of patrols in dense tourist areas. There's a need for greater community cooperation. Law enforcement agencies cannot completely end crime. Instead, they must depend on the local population and the tourism industry in particular to help them fight crime prior to the occurrence of an incident. Law enforcement agencies see prevention as their best tool, especially when there exists the opportunity to forge relationships with enforcement units and the business community. We imagine that the use of GERS peace officers would be like that of the officers positioned at the Roy Lester Schneider Hospital and the Juan F. Louis Hospital. Specifically, GERS officers would be responsible for the tourism-intensive areas in and around the GERS property. Based upon the information provided herein, we wholeheartedly support this measure. Cordially, Ray A. Martinez, Police Commissioner.
Thank you. That was his comments. Do you have a testimony now, or?
I do.
May continue.
Good afternoon to the Chair, Honorable Kenneth Gittens, legislative body, and staff, members of the VIPD executive team, and to the members of the listening and viewing audience. My name is Sidney Olsko, Assistant Commissioner of Police for the United States Virgin Islands Police Department. We thank you for the opportunity to present testimony regarding a proposed territorial assault weapon ban, extending the firearm license renewal period from 3 to 5 years, and the creation of a mechanism empowering the police commissioner with defined authority to monitor and approve or deny the ability to import rifle parts into the territory. 1 second. I know you said that you wanted to cover just this subject.
Yes, we're in block 2, which is specifically to 35-0238.
Have a complete testimony. It does include the GERS subject. I will read that portion and then stop.
Yes.
Okay.
Thank you.
Regarding GERS police peace officers, the Virgin Islands Police Department is not the sole law enforcement agency in the territory. Additional agencies include peace officers with the Department of Planning and Natural Resources, the Division of Licensing and Consumer Affairs, the Department of Health, the Taxi Cab Commission, the VI Lottery, the Department of Waste Management, the VI Port Authority, Fire EMS, the Marshal Service, and the University of the Virgin Islands. All law enforcement agencies in the Virgin Islands collaborate in the responsibility of maintaining a safe environment for all. The named agencies exist to fill a necessity. As attempts are made to ensure the gaps in our safety are filled, change elicits new approaches to routine law enforcement. The Virgin Islands Police Department supports all genuine attempts to create a safer society. That's the completion of my testimony.
Thank you, Assistant Commissioner. As we commence block 2, we will move at a debate time of 4 minutes. And and I'm looking at this measure as I've been before. And why I told my good friend, Mr. Moorhead, he almost had me sold on this, is that I firmly believe, and this committee has started the process already of evaluating all our law enforcement entities within the territory. And we have found already that we have fallen short on fulfilling our duties and responsibilities in a lot of these areas. And so I am cautioned by the experiences and what I'm seeing currently with our law enforcement entities. What I've seen is that, and I've sat here just now because I couldn't recall exactly how many we have, but I've written down over 15 different law enforcement entities we have here in this territory. And I mean, if everybody pull up their socks, tie up those boots, and whatnot, we will have a safer community. And I don't want you to disbelieve what I'm saying. I've written down from the Virgin Islands Police Department to the Department of Justice, to the VA Fire Service, to the Bureau of Corrections, to YRC under DHS, to the Environmental Protection Agency under the Department of Health, DPNR, Licensing and Consumer Affairs, Lottery, the Taxi Cab Commission, the legislature, the Virgin Islands, the marshals at the courts, hospital police, both St. Croix and St. Thomas, the University of the Virgin Islands, Port Authority, and even the Inspector General Office. And I'm pretty sure that there's more. And I'm saying, if we want to just create another mall security, as an elected official, I am going to do due diligence on this, because what also concerned me in listening to the testimony is there's a lot of mention of the mall. But this also sent me back to legislation that I've proposed, but that was preempted on, in the merger of WICO and the Virgin Islands Port Authority. Because while we're talking about the mall, it's right there bordering WICO docks. And it's those tourists that you're more concentrating on that's coming off those ships. So with WICO and Port Authority doing basically the same thing, why not come under one umbrella? And then you already have the Virgin Islands Port Authority police force, which can just be expanded to have more officers there. Now, again, as an elected official, what I would like to see is because we will have to talk about increasing budgets and putting monies to now create this mall police concept that we're talking about. Why not channel those monies to the respective agency, which will probably namely be the Virgin Islands Police Department, and fund the tourist-oriented policing initiative? Or let's do what we're supposed to do with the merger of WICO and Port Authority and increase the budget, the police budget for the Port Authority, and then this will now encompass not only the WICO docks, but the bordering mall areas, and even your respective offices in both districts. Just food for thought. I am here to listen to everyone on this, and then we'll make a decision thereafter. All right, at this time we'll move to Senator at Large Angel Bolquez. You're recognized for your 4 minutes.
Thank you, Mr. Chair. Good afternoon, Mr. Chair. Good afternoon to the listening and viewing audience, and of course, good afternoon to the testifying panel on bill number 35-0238. And as a prime sponsor of the bill, I'm obviously in support of this bill, but I wanted to say that Havenside is a key commercial tourist hub. And by granting the security officers that work there the peace officer status to enforce, this legislation becomes a vital partnership with the VIPD, allowing for a collaborative and effective response to emergencies. And of course, improving public safety overall. Let's not forget that, we've had a number of things that have transpired in that location, to include the unfortunate death of a woman at a jewelry store. I hate to bring that up now, but I need to the importance of this legislation and what it's trying to accomplish. And by creating a more secure environment, the bill not only reassures visitors and also supports local businesses and local tenants who come in and out of the mall of the security, but also brings up economic activity. And of course, we want to assure anyone, regardless if they're a local or a tourist who traverses within that mall, that it's a safe environment. And of course, being that the peace officers are technically under GERS, who knows, perhaps they could, if GERS has any other locations that may require some sort of security, they can be dispatched to those locations as well. So it opens up a lot of opportunities for GERS. And I wanted to start by asking a question concerning the plans of GERS through Havenside Mall to adjust, whether it's recruitment, training, or the compensation packages for those potential officers who will now receive this new status and responsibilities.
Senator Bolkus, Angel Dawson. I'm going to allow Chief Moorhead to address certain aspects, but I would like to make a brief comment, and I know that your time is limited, so I try to speak quickly. I do appreciate Senator Gittins' thought process with regards to what about WICO, what about Port Authority, what have you, and the fact that there are a number of law enforcement agencies in the territory. But on the Havenside property alone, as we indicated in my testimony as well as Chief Moorhead's, we have essentially 1 million people who are under our care and jurisdiction for the day. No other agency, not even the police department, frankly, could say that they have that many people to secure. With regards to WICO and Port Authority and policing, their focus would be on the docks, primarily, I would imagine, Port Authority or the port facilities, whereas the concept that we're developing for Havenside is really one of retail, dining, and entertainment. Let us not forget that the first hotel to be built in the St. Thomas and John district in almost 30 years is being built at Havenside. So we have a 24-hour operation, which is very varied, with a lot of people.
1 minute.
Every day. So that is something that ought to be considered as well. With regards to the officer recruitment and development, I'll allow Chief Moorhead to address that.
Our security staff is varied, and there's a lot of excitement within our security staff to become peace officers. So I think we're going to start in-house and recruit from in-house. And I think that we will get quite a few security officers that are prepared to be peace officers. As far as the salary, it's going to be quite competitive with the starting salary of VIPD. So we still have some research and stuff to do, but it's going to be quite competitive with VIPD. It isn't going to be more than that, so that we'll be taking officers away from VIPD, but it's going to be on par with VIPD.
Thank you for your responses, and I appreciate you illustrating that narrative because I believe that this also enhances the VIPD in a sense of, I know during emergency situations, and Mr. Chair.
Pardon, and I want you all to remember, let's respect the timekeeper. When she calls time, I expect for you to ask to be given extra time. You may wrap it up at this time.
Noted, Mr. Chair. Thank you. As I left off concerning in situations of emergency, the Commissioner of the Virgin Islands Police Department is able to dispatch all peace officers from wherever for specific functions, sort of like our festivals, carnivals, and so forth. So now this also broadens the amount of access or people that he can utilize for those functions. So I think it's a plus for everyone. Thank you for the time, Mr. Chair.
Thank you, Senator Bolkus. Senator Dwayne DeGraff, you're recognized for your 4 minutes. If you're saying anything, we can't hear you on St. Croix end. Senator Dwayne DeGraff is recognized.
Nothing yet. Oh, thank you, Mr. Chair. Good afternoon, colleagues. Good afternoon, testifiers, all viewing, listening, and present. Administrator Dawson, good afternoon. How you doing today?
Good afternoon, Senator.
What is your... How much money does the legislature give you toward your budget for security?
None.
Why is that?
Well, we have asked the legislature in recent times to consider covering the administrative costs of the GERS. That has not been forthcoming. A request specifically for funding of security has not been made.
Okay, so how many security officers do you have presently that you would like with this status?
If I may defer to Chief Moorhead.
Good afternoon, Roy Moorhead, Chief of Security, Havenside Mall. The goal is to have between 4 and 6 officers that are peace officers.
Okay, good. That's good to hear. Now, how will they be funded? How will they be paid for as peace officers in their capacity?
Yes, Senator, I'll answer that one. It'll be funded from the Havenside Mall budget, which is reviewed and approved annually.
Okay, so the Havenside Mall budget is looking good, because I know from the last couple of meetings and stuff, they were having issues. So you're saying it can be sustained where these persons will be hired, and you sustain them by paying for them yearly. You can cover that.
Yes, sir.
Okay, so for 4 to 6 officers, what are we estimating in cost to you for them?
Well, we, as Chief Moorhead indicated, there would not necessarily be new hires, so there would be an increment in their pay. And of course, we expect that we would have to absorb all of the initial costs for equipment, what have you. But in terms of the payroll, we would be looking at an increment of less than $100,000.
Okay, so we're basically looking at where you would get 4 to 6 officers that you would pay for them. It doesn't have to come out of where we have to appropriate funds, and you want peace officer status for them. So it becomes a win-win for the government regardless.
Absolutely.
Okay, I think that becomes a win-win, because I've heard the statement that my colleague made, and I would agree, because when I heard GRS, peace officer, I was thinking down by Griffith Park, where they're going to do security for the park or something.
Right.
Not realizing for the Havenside Mall.
Right, that's why I added that in my opening remarks, that we're here primarily in our role with the Havenside Mall.
1 minute.
Right, so again, just for me, you're going to get 4 to 6 officers who will be very well trained, post-certified, peace officer status, at no cost to the government, where you will be able to fund them through the monies that you generate. I think that's a win-win. So unless there's anything else that I'm missing. Now, the only other issue I would have, it becomes authority. The authority being Wycodoc, the Havenside Mall, and the next mall is
Port of Sale.
The name of it? Port of Sale, correct. Port of Sale. Now, where do their authority end and those other entities take over? Or are they now going to provide additional security for Port of Sale and the rest of Wycodoc?
Time.
Mr. Chairman?
If I may answer...
Yes, you may complete your...
You continue?
Yes, you may continue.
Thank you.
Complete.
So to answer your question, Senator, the Wyco property and the Havenside Mall property are 2 distinct properties. The Port of Sale Mall actually has a ground lease from Haven site, from GERS, so they're operating on GERS property. Our peace officer request would be to cover the officers that secure primarily the Haven site mall.
Thank you, Administrator. Thank you, Mr. Chair.
Thank you, Senate Minority Leader. Before I recognize the President for his point of information, piggybacking on the Minority Leader's questions, how many security officers you're now currently funded under the mall operation?
Roy Moorhead, Chief of Security, Havenside Mall, 17.
17?
Yes.
At what cost?
Senator, we don't have that exact figure. It's probably somewhere. And for proprietary purposes, we would not want to share that publicly.
Okay. Well, you're gonna have to share it if you want public funds to be used for this. So I don't want us to get into that type of thing where we're trying to use that in hiding anything. When it comes to the public funds, I'm always wanting for us to be upfront. Now, granting this authority, have you looked at what it will cost for adding the number of law enforcement officers that you're talking about, the 4 to 6, which I don't think would be sufficient to run a 24-hour operation either?
So, Senator, to answer your first question with regards to the existing cost, it's about $850,000. We had no reason to feel that we should share that. I was going to share it with you, but that's what we're looking at. In terms of incremental costs, as I indicated before, we're looking probably at less than $100,000 in that we would not necessarily be hiring new officers, but training existing officers so that they could attain their peace officer status.
But it still comes with an increased cost.
Yes, it does.
Right.
Which we will absorb at Haven site.
All right. Senator President Francis, you recognize for your point of information.
Thank you very much, Mr. Chair. Just going along with the conversation from the previous senator, and I wanted to understand, if you could help me to understand that it's your determination that you want to perhaps convert your current security officers over to peace officers.
Yes, that is correct.
A portion of them.
So it is your intention then to make sure that these individuals will qualify for the training regimen that's required, 960 hours or so of police officer or peace officers training, as well as to be able to qualify for all of the other requirements, psychological and everything else, physical fitness and everything else for that.
That is correct.
I have security officers here at the legislature, and all of them cannot go to receive peace officers. So you know that there's definitely some requirements there.
That is correct.
2.
Mr. President, if I may, let me just remind the testifiers, when you respond, put your name on the record, because the stenographer will need to know which one of you are responding to the senator, okay?
Additionally, peace officers' status is not just reserved to the 4 corners of GRS. If they're granted peace officer status, that goes with them everywhere they go and comes with some responsibility. You're also mindful of that?
Yes, sir.
Okay, because I heard some discussion about where their boundaries would be situated or whatever. The peace officers are peace officers regardless of where they go throughout this territory.
Yes, Senator, that's a very valid point. I appreciate that.
Please state your name.
Angel Dawson, Administrator of the GERS. In agreeing with Senator Francis, in terms of the scope of a peace officer, we acknowledge the fact that while they may be contractually responsible for Haven Site Mall, that they will be in what we consider a district, which includes Yacht Haven Grand and Port of Sale, and even the properties across the street, so that if something were to happen, we expect that the peace officer status would cover them and actually require them to intervene and be available should it be warranted.
So their responsibility rests once they're peace officers, regardless of where they're at.
Precisely.
Regardless of whether I got they're on GRS property, or they're in McDonald's line, or they're in St. John, regardless of where they're at, peace officers are required to act and carry out their duties wherever they're at.
The word, Angel Dawson, the word collaborative was used earlier by the police, the assistant commissioner, as well as Chief of Security Moorhead. And that is exactly what we would intend to do, because we do plan to assist the police department, frankly, by taking away some of the load from them and providing safety and security, not only for Havenside Mall, but indirectly for Yard Haven Grand, Port of Sale, the tramway across the street, and all those properties. We consider it, and we'll be working with the other property managers and owners to develop a district.
Thank you for your response, and thank you, Senate President Francis, for that question, because that's where I was going to. When you're granting peace officer status, it don't rest to the mall property or to GRS property. It's the entire territory. And we have a number of agencies that have this hands-off approach, that is not my area, let the police handle it. Yet still they have full peace officer status. I am not about arming a bunch of what you call, making them armed secretaries. That is not what we want. We want people to fulfill. If there's an accident on the property and whatnot, we expect that if you're granted that authority, that your officers will be able to handle those accident scenes and not be calling on the VIPD to come in there to handle those, or any other infractions that occur within your areas. But again, like the Senate President said, we want y'all to be clear that if this is passed, peace officer status means territory-wide. Senator Franklin Johnson, you're recognized for your 4 minutes.
Good afternoon. Thank you very much, Mr. Chair. Good afternoon to my colleagues. Good afternoon to the testifiers. Good afternoon to the viewer and listening audience. They went down my line of questioning, but I still have some more questions. Because it's important that we understand the peace officer status. Some people just take it that since you're going to get peace officer status, you're only working on the pier. Doesn't work like that at all. One of my questions is, have you had this discussion with your officers and in depth for them to understand that these are the new duties that they will be taking on, and they understand and agree to take on these new roles?
Roy Moorhead, Chief of Security, Havenside Mall. Yes, we've had those preliminary conversations with them. We've spoken about what the peace officer entails. We talked about the training to become a peace officer. It's quite rigorous. The goal is for them to attend the Virgin Islands Police Academy so that they become post-certified, and that is a rigorous academy. So yes, we've had those discussions.
As we speak right now, your enforcement officers, do they carry firearms?
No, they do not.
Nobody?
Nobody.
And now you said that you have 17 officers.
That is correct.
You do shift work?
We do.
How many shifts do you have?
We carry a 10-hour shift, and we have 3 shifts a day.
10-hour shift, 3 shifts a day.
Yes.
Now, with all the bells and whistles going to go with peace officer status, cars, equipment, do you guys put this into consideration and have an estimated cost, or what it's going to cost to equip your staff with weapons, firearm training annually?
We certainly have considered that. We have done some preliminary research on outfitting a unit like this. So yes, we have considered those costs, and those initial upfront costs.
I think it can be a plus, and as the chair said, you have a lot of agency that has this peace officer status, and they pass crime going on left and right. They pass accident, tickets. All of these are part of the peace officer status. Now, so as we speak right now, you rely on the police department to assist you with any kind of criminal activity that goes on the pier.
Roy Moorhead, Chief of Security, that is correct.
All right. I kind of like the idea of doing it, but I want to make sure that your officers are fully knowledgeable and understand the new role that they're going to be embarked on. because some people take it for granted, and you can be arrested if you don't carry out your peace officer status and charged with the crime that took place in your presence. And this is why I'm kind of pushing on this, that make sure your men and women that you have there understand their new role is a very serious role. And if they're willing to comply with this role, then they stay on board. If not, this might not be a job for them when the peace officer status is implemented. It's very important. You can't see a crime taking place and you don't take part and assist. So I hope that this is kind of message that you guys are going to be relating to them, and knowing that if they're going to stay on board, these responsibilities are very serious. You say you have 3 shifts and you have 17, and you're saying that you're not going to make all 17 peace officers?
That is correct. We don't necessarily need all 17 to be peace officers. The goal is to have between 4 and 6 officers as peace officers, and we will develop a schedule that's conducive to that amount of officers.
If you're doing 3 shifts, you're going to need a minimum of 6.
Yes.
Because somebody have to have 2 days off.
Correct.
So that is going to be your minimum right there. They got to get 2 days off. If you're on the 8 to 4 shift, you need 2 days off while the next person is on. And the days might staggered, so both of them will be together at some time. But your minimum number is 6, not 4. In order for you to walk, may I conclude, Mr. Chair?
You may conclude.
I want a beating from you today. In order for you to walk, you're going to definitely need 6. In order for it to be staggered and at all time have peace officers presence on your pier and your premises. Nothing under 6. Thank you very much, Mr. Chair.
Thank you, Senator Johnson. And based on his line of questioning, brings me to ask you, Mr. Moorhead, do you or anyone on your team currently have peace officer status?
Roy Moorhead, Chief of Security, Havenside Mall. No, no one has peace officer status.
Vice Chair Fonseca, you're recognized for your 4 minutes. Followed by
Thank you.
Senator Alma Francis Heliger.
Yes, thank you so kindly, Mr. Chair, and pleasant good afternoon to all the testifiers. Quickly, I wanted to just go over the testimony here from Mr. Sidney Elsko, the Assistant Commissioner of Police. And, it's very interesting in that he points out that the Virgin Islands Police Department is not the sole law enforcement agency in the Virgin Islands, and in the letter here from the Commissioner, it says to solve these law enforcement issues, they need greater community operations. And I wanted to bring that real quickly, if I may, to the mental health issues that we're facing in the community. Because, the mental health is not just the Commissioner of Health. It also involves VIPD gets involved with mental health, education, the human services, the Bureau of Corrections, Catholic Charities, the hospitals, even the Women's Coalition and the homeless population. A lot of the mental patients are also dual diagnosis with substance abuse and alcoholism. So it's interesting the chairman of the committee just let us know that there's about over 15 different agencies in the government that's involved with law enforcement. It's the same issue that we have to look at it to be able to solve the mental health issues in the community. It's not just the Department of Health, it's a whole lot of others. So real quickly, I wanted to go to Administrator Angel Dawson. So we want 4 to 6 peace officers. And this bill, number 35-0238, seeks to grant peace officer status to qualified enforcement officers employed at GERS. And it proposes an amendment to Title V of the VI Code to include enforcement officers, training, etc. So these, like the President just indicated, these 4 to 6 peace officers that you selected, they are going to go through the regular VIPD training. Is that correct, Administrator Dawson?
Yes, Senator Fonseca, Angel Dawson. As indicated by Chief Moorhead a short while ago, yes, they will go through the police academy. And I think that the chief would actually like to make one small clarification with regards to a question as to whether we have any peace officers on staff presently.
Roy
Okay,
Moore.
wait. You do that on the chairman's time, not on my time. Let me just continue with my line of questioning. Okay, so back with you, Administrator Dawson. So are the salaries then going to be competitive with the regular VIPD and the other enforcement officer salaries in the territory?
Absolutely, that would be a requirement if we wanted to attract and retain qualified individuals.
Okay.
1
I'm
minute.
definitely in support of Bill 35-0238 because, like our Senator at Large mentioned, we've had some serious robberies that occurred a few years ago. And this is additional security because, like we've received testimony, there's over 800,000 passengers that are traversing on that Waiko dock. And they're projecting it might even come close to 1 million passengers. So 1 million passengers or whatever it is, 800,000, we need to show that we are serious about security over there. So we are spending, you know, what I would consider a good spent money to ensure the security of all of those passengers because crime is very serious over there in that area. So I'd like to end by saying that this bill is a good bill and I am definitely in favor of this bill and I will be casting my vote in support of it at the appropriate time. Thank you, Mr. Chair, for the time.
Thank you, Vice Chair. So based on the Vice Chair's line of question also leads me to ask, do you have currently any armed security officers on the property?
Roy Moorhead, Chief of Security. I need to make a correction. Earlier I said we did not, but we do have...
Earlier you said you did not what?
Have armed either peace officers. We did not have peace officers.
So let me be clear. The previous question, piggybacking off of Senator Johnson's line of questioning, was whether or not you or anyone on your team currently has peace officer status.
That is correct. And
what's the response to that?
The answer is yes. We do have 3 part-time officers that are peace officers with Department of Planning and Natural Resources. They work for us part-time.
So those 3 officers are DPNR officers?
That is correct.
Okay. But none of your full-time staffers have law enforcement status? Peace officer status?
That is correct.
Okay. And now you understand the one that I just asked?
That is correct.
Okay, so how many of your security officers are armed?
We have 4 security officers that have licensed firearms. None are allowed to work with those licensed firearms.
So don't tell me about those. Again, let's keep it, how you said? Let's keep it simple.
Okay.
Any one of your security officers are armed security officers, meaning authorized to carry a firearm on the job. Because just like, how you call those security company, Ranger America and some of the others, you have armed and unarmed security officers. So I'm trying to determine if GRS security, mall security, whatever y'all call them, anyone of them are armed?
No.
Okay. Because safety and security is the key thing here for your property, correct?
Correct.
Do you have a problem there with parking and loitering, etc.?
Yes.
How is this being handled currently?
Our security officers respond. And if we can't handle it, then we call 911.
And how often is this happening?
Several times a week.
So it's being handled. Safety and security versus law enforcement granting peace officer status. I want people to understand that in between, because again, I don't see a problem in having you have armed security officers. But again, going the route of granting, creating another level of peace officers, gotta think about that. Senator Alma Francis Heiliger, you're recognized for your 4 minutes. Happy to have you back.
Good afternoon to my colleagues. Good afternoon to the testifiers. Good afternoon to the people of this territory. My first question has to do with the selection process. Is it going to be one where it's open for all? How do you said you had about, is it 17 or so individuals, and it might be only limited to what, 4 or 6? How are you going to select who those individuals are?
Roy Moorhead, Chief of Security. What we're going to do is we're going to ask them, is this something that they would like to participate in? And those that answer in the affirmative, we will put them through the same requirements as the Virgin Islands Police Department does for their officers. We would go through a screening, we would go through the...
Well, I understand that. Let me say this. You said you only need about 4 to 6, if I recall. What if 12 of them say yes?
Well,
so I'm saying, how do you select the number you want at the end of the day? Because you might have more than the amount you actually want to be peace officers.
Well, Roy Moorhead, Chief of Security, Havenside Mall, we'd go through a selection process just as if you would, if we were hiring new employees. We would have interviews and we would review their backgrounds, and then we would make a determination.
How often do you guys have criminal activities? For example, at Havenside Mall, do you guys keep a stat report of the activities of that sort? And do you utilize that information to help curtail crime in that area? Because sometimes when you know what type of situations you're dealing with, it could help you to prevent future situations. Do you collect that type of data?
So all incidents are logged in our incident log system, and we don't necessarily keep stats on specific crimes, but we do have, as I indicated earlier, several times a week where we have to call 911 to get police assistance.
Okay. Now, what is the difference between potentially utilizing an outside entity versus going through the process of having your own peace officers? Because for me, what is the stark difference for you? I understand why you want to do it, but what is the stark difference for you? Is it about the money? Is it about, internal controls? How did you come up with going down this pathway as an option?
Roy Moorhead, Chief of Security, Havenside Mall. I think Havenside Mall is owned by the GRS, and I think we feel we have a responsibility to provide that safety and security for our tenants and our guests that come onto the mall. We have a very a great relationship with VIPD. They respond anytime we call. So at the end of the day, it is either we do it or we tap the resources of VIPD to do it. And VIPD resources may be limited. So this is something that we think that we can do, and we could do it because we will have the officers on our property, right there to respond.
currently, how the makeup is? Do you guys have like officer stations where individuals can go to file complaints, or if something happened while security might not have been around, that they could directly connect with someone on the properties that you guys own?
Time.
Or is this a situation where they're going to be built once? Because you're literally creating your own police department. That's basically what's going to happen when you have all these peace officers.
So, Roy Moorhead, Chief of Security, Havenside Mall. So we do have a security control center, and we have officers assigned to that center. We do have a security booth at the front of the mall that an officer is assigned in that area. And then we have officers that rove the property. With as many people as we have on the property, we really have to have that presence throughout the mall when ships are in port. So yes, we take police, incident reports. So if something happens, then, our officer would respond and take a report.
Okay. Well, thank you very much for your responses. Mr. Chair, I heard time call. I will continue to listen. Thank you.
Thank you, Senator Alma Francis Heilegger. And before we go to Senate President Francis Jr., I wanted to ask GERS and Mr. Moorhead, what has been, being that you have not instituted this, what has been the overarching challenge in the aspect of not having individuals who are deemed to be post-certified? What has been sort of the challenge? What sort of got you to the point where you felt that this is something that we needed right now?
Roy Moorhead, Chief of Security, Havenside Mall. I think that over the course of the past year, we have had several incidents that have happened, and we feel that having the presence of law enforcement acts as a deterrent. I think that as passengers come off the ship, they see law enforcement officers. There is a sense of security that they have. And keep in mind, we're a mall. And knowing that there are law enforcement officers in the mall may entice someone to go in a jewelry store and spend $5,000 or $10,000 on a piece of jewelry. So I think it's led by the fact that we would like to have that presence on the mall. In terms of response, we want to have the authority to act and to do what we need to do when an incident happens. We want to be there, and we want to be able to act quickly.
And I believe that the administrator wants to chime in as well.
Senator Bolkus, Angel Dawson, GRS Administrator. I would also like to add that the Havenside Mall property is fairly unique in the Virgin Islands and St. Thomas. Not only is it the best as far as we're concerned, but it's also the largest, because we're talking about a property spanning 14 acres that entertains almost 1 million people between cruise ship passengers, locals, and visitors that spend time in our hotels and condos, timeshares. So it is a unique asset in that regard, just given the sheer numbers that we're looking at and the size of the property.
Okay, and thank you, gentlemen, for your responses. Senate President Francis Jr., you're recognized for your line of questioning.
Thank you very much, Mr. Chair. Good afternoon to everyone, and thank you for your testimony. First of all, I want to say I'm not a member of this committee, but nonetheless, I attend most of or all of the committee hearings whenever possible. So while the Haven site, the security officers will be responsible for that area, I heard an assertion that it might be where the most individuals congregate at any given time. The responsibility of law enforcement rests with the Virgin Islands Police Department overall. And that includes the entire territory, our local population, as well as our 3 million or so tourists that comes into the territory. As a matter of fact, whenever there is an incident where a law enforcement officer may be the subject of a shooting or some other incident, the VIPD is also called to handle those type of situations. As a former law enforcement officer, former police commissioner, I must put on a record that our responsibility still rests on the shoulder of the Virgin Islands Police Department. So I'm very, very open to supporting this initiative to make sure that you're having your own peace officers. But I also have a responsibility for you to understand what you're about to undertake. It's an awesome responsibility. You're talking about training individuals. You'll be losing them for about 6 months to the police training academy. And you talk about wanting about 4 to 6. That means you have to train about 10 in order to get that 4 to 6 that you seek to get. A lot of individuals that go through the police academy could be washed out. Even if they're qualified to enter the academy in itself, they could be washed out. Not to mention the requirements and regimen that they have to adhere to be able to qualify just to be able to enter into the academy. So I want you to be mindful of that. When you talk about having peace officers as well, you have to up your insurance. Because here it is now you have individuals that's armed and you have some responsibility associated with that. You have to have a retirement plan built into that. If they're having peace officers started, I mean, they could retire within 20 years. In most instances, or 25 years, as the law now applies. You have to take into consideration training costs that's associated with that. Equipment, uniform, vehicles. All of these things come into play when you consider this particular issue. If you have 2 officers per shift, also, because you can't have one individual working by themselves, chances are you will have to at least have 2 officers. So you talk about 6 officers off the bat there. You have to have a supervisor or chief of security or whoever going to be OIC or be in charge of these individuals. You can't have a civilian then being responsible to oversee a law enforcement officer. There'll be some trade-off.
1 minute.
Language that's understood there. So I wanted to ask you whether or not all of these things have been taken into consideration in this endeavor.
Roy Moorhead, Chief of Security, Havenside Mall. Yes, we have, Senator. I'm a 23-year vet, former law enforcement officer, so I'm familiar with some of the things that you're talking about. I also want to add that this gives us access to LEPC and getting some grants from LEPC. And we've spoken to LEPC, and they're prepared to be able to talk to us about getting some grants, startup money, as well as grants to maintain the peace officers. So, yeah, this is going to open up some opportunities for us.
Okay, and of course you'll have to create policies. You have to create rules and regulations in regards to these individuals. You'll have to deal with the situation where now if you have armed or peace officers, that the other security will be a little bit reluctant to want to take action because they say, I don't have the training, I don't carry a gun. So now it becomes your responsibility as a peace officers. So all of those things really have to be contemplated in this final decision to move into moving towards peace officers. But I support that endeavor. I believe that having, Mr. Chair, if I may just conclude, once you're able to be self-supportive, then again, that will alleviate and assist and support the Virgin Islands Police Department, hence the reason why I always support individual entities actually having their peace officers to be able to at least handle and take that pressure off of the Virgin Islands Police Department. So good luck. I don't have a vote in this committee, but whenever it gets to session, I'll certainly make my due consideration in that matter. Thank you.
Thank you, President. So have we given any thought that if talking these 3P initiatives lately, anyone give any thought that if the mall were to be sold, what would happen if you have that mall police force that you're trying to create?
Senator Banghill Dawson, GRS Administrator, I certainly have never allowed the words "sell them all" to come out of my mouth because that would be one political hot potato. But so no consideration has been given to that, Senator.
Okay. Something to think about because, again, where we heard the government running a mall, I mean the Virgin Islands. I ain't saying it's a bad thing, but I'm just asking that.
Well, it's a profitable investment.
If later on, if it were to be sold, then what happens to those employees, etc.? I'll yield anyway to the bill sponsor. I think everyone else has spoken. Senator Milton Potter, you're recognized for your 4 minutes.
Good afternoon. Thank you very much, Mr. Chairman, and good afternoon once again to our testifiers who will be before us today. I wanted to ask Mr. Moorhead once again to tell us a little bit about your law enforcement background. I know you kind of brushed on it, for a second, but I wanted to just to hear a little bit about your background as the head of the enforcement division. What is your background?
Roy Moorhead, Chief of Security, Havenside Mall. I started in 1990 as a police officer, went through the police academy. I've worked with several of the law enforcement, several of the senators here that are former law enforcement officers. And then I went to the Department of Justice, and I was an agent at the Department of Justice in its heyday for several years. And then after that, I was assigned to the Executive Security Unit, and I was the district supervisor for the Executive Security Unit on St. Thomas. And then after that, it was 23 years, and then I joined WICO as the chief of security when I left the government house. And I've been on the dock now between WICO and GRS for about 10 years or almost 11 years. So I've worked with several of the agencies that we talked about earlier. So I've got a little bit of a background.
I know you're a humble guy. You don't necessarily want to toot your own horn. So I wanted to just give you an opportunity to tell us a little bit about your background, because I think you're more than prepared to lead the security division, at the Virgin Islands, at the GRS. Without question, you have the background and the capabilities to get something like this going. Clearly, the Virgin Islands Police Department has expressed gratitude, if that is the word, at the move that GRS is moving towards to secure peace officers at their facilities. It will ease the burden from the Virgin Islands Police Department. And it was dramatic when you mentioned that you have close to 1 million persons traversing that area on any given day. It's a major tourist spot. It's a major spot where locals congregate. So having enhanced security presence there, I think, can be nothing but a plus for GRS and the people of the Virgin Islands. I wanted to ask you, I think you mentioned what the additional cost to the system would be. You mentioned
1 minute.
$100,000. Is there any anticipated cost to the central government?
Senator Potter, good afternoon. Angel Dawson, GRS Administrator. As it presently stands, we do not receive any administrative funds from the central government, so the answer would be no.
Okay, thank you very much, sir. How has the lack, and I know you've touched on it earlier, how has the lack of an enforcement team with peace officer status adversely impacted, just from a safety and security standpoint, how has it adversely impacted the general public, and how will the establishment of this peace officer status division, how will it improve the safety and security outcomes in your view?
Time.
Roy Moorhead, Chief of Security, Havenside Mall. I think there are two considerations. Firstly, during the day, when we have the cruise ship passengers on our facility, having peace officers acts as a deterrent. I think the passengers like to see law enforcement officers there. As a matter of fact, anytime a VIPD officer is there, tourists want to take pictures with VIPD officers. So I think that's what they expect at a an area that has such a high footprint. And then secondly, during the evening, we have a lot of activity. We have bars, we have restaurants, we have live music. So I think we have a hotel that's coming. So I think having peace officers on property also acts as a deterrent during the evening. I also want to mention that Port of Sale, we talked a little bit about it earlier, but we do have a bank in Port of Sale, and we have a casino in Port of Sale. So I think that having peace officers and the ability to respond quickly when incidents happen, I think those are the key factors that make this really something that we want to do.
Thank you very much. Thank you very much. I know my time was called, Mr. Chair. Thank you very much, testifiers, colleagues. I ask for your support on this very important piece of legislation. Thank you very much.
Thank you. You are the bill sponsor, so I granted you that leeway. Senate President, you're recognized for your point of information.
Thank you very much, Mr. Chair. I wanted to ask you, Mr. Moorhead, Chief Moorhead, Director Moorhead, is there any collaboration at this point right now with the Virgin Islands Port Authority Police? So how do you see them playing a role because your facility also, along the line of ports? Is there any collaboration, any synergy between your security and Virgin Islands Port Authority?
Roy Moorhead, Chief of Security. Our port, the dock itself is owned by WICO. And as such, we don't see Port Authority in the area much. I know that they have some other responsibilities, but we don't see Port Authority on our facility too much at all.
So how do you how is the Homeland Security issues handled? You have a port that you're managing and securing. What's your Homeland Security affiliations?
So the port, GRS doesn't have a port, but WICO does, and WICO manages our relationship with the U.S. Coast Guard, with Homeland Security. We do actively train with WICO and their security officers, but that's WICO's responsibility to deal with the port facility itself.
All right. Good. Reminder, WICO, GRS. So I wouldn't ask you their questions. I'll ask them. You had a point of information, Senator Johnson? Senator Johnson.
Thank you very much, Mr. Chair. So my question to you will be then, because Senator Giddens pretty much asked what I want to ask, but I'll still go a little farther. After hours when there's no ship, port police is not down in the pier area or in the premises at all?
Roy Moorhead, Chief of Security, Havenside Mall. No, Senator.
All right. Thank you very much.
Thank you. Committee will recess 3 minutes. The Committee on Homeland Security, Justice, and Public Safety for Tuesday, May 14, 2024 is back on record. Just before I ask you for your closeout, Mr. Administrator, GRS is a government entity?
GRS is a public entity.
Public entity.
Yes.
So I know the police department have already supported the initiative and whatnot. Have you had a conversation with Post as well? And who will compensate for the curriculum of these officers, if any?
Well, we will have to have that discussion, and we'll have to agree with the commissioner as to how they would be compensated. We haven't done so as yet.
Okay. Thank you. At this time, I'll allow for closeout, 30 seconds. And I'll start with the VIPD and then just let you have the last say before I entertain a moment. Assistant Commissioner Elsko?
Yes, Assistant Commissioner Elsko, VIPD. You know, we are a paramilitary organization, and one of the fundamentals is that we ensure that there are contingencies in place to do our job. Adding another law enforcement agency would be that contingency. All I ask is that law enforcement isn't for everyone. And if you take some individuals that are security guards, they may be security guards because they could not become police. So when you ask them to make that transition, do your homework, make sure they are fit for the job, and not create a liability for the rest of law enforcement on a whole. That's what I have.
It's like the difference between a bodyguard and an executive protection agent, right?
Yes, sir.
One use the muscle and one use the brain. All right. Thank you. Both of you want to close out or?
I'll say something.
Roy Moorhead, Chief of Security, Havenside Mall. I'll be brief.
You only have 30 seconds anyway.
Okay. We urge your support for Bill number 35-0238 to grant peace officer status to our enforcement officers. This measure will not only bolster our security framework, but also support the Virgin Islands Police Department in maintaining public safety, especially during peak periods of tourist activity. We thank you for considering this particular legislation.
You're welcome.
Gittins, I'd like to thank you for your invitation and your courtesies here today. I'd like to thank Senator Milton Potter and Senator Angel Bolkes for sponsoring Bill number 35-0238 that would confer peace officer status on the officers at Havenside Mall. We at the GERS are proud owners of the Havenside Mall, and there's a real strong historical legacy of that property here in the Virgin Islands. At one point, it was essentially owned by the country of Denmark, even after the transfer. So we consider ourselves to be custodians of Virgin Islands history and plan to continue to provide the best experience possible to our residents and to our visitors. We have a lot of exciting things happening at the Havenside Mall. There's a new hotel being built, and we are in the process of converting the mall from primarily retail to being retail, dining, and entertainment, for it to be an experience for all to come and enjoy. And with that goes the responsibility of ensuring that the million-plus people that traverse our premises are safe and secure, and we feel that this bill will help us to do exactly that. So we ask for your support, and we thank you for your support.
You're welcome.
Welcome.
Thank you for your closing statement.
Thank you.
I didn't even remember the hotel for real.
There you go.
And they might be coming with their own security too. But
there can never be too much security.
do I hear a motion at this time? I'll entertain a motion. Senator Volkes Jr., you're recognized for your motion.
Thank you, Mr. Chair. Mr. Chair, I move that Bill number 35-0238, an act to confer peace officer status on qualified enforcement officers employed by the Government Employees Retirement System of the Virgin Islands, be favorably voted upon in this committee and forwarded out to the Committee on Rules and Judiciary for further action and consideration. I so move.
Properly moved by Senator Volkes, second by Senator Franklin D. Johnson, and Vice Chair Ray Fonseca, and Minority Leader Dwayne DeGraff. Roll call on Bill number 35, that's 0238.
Yes, Mr. Chair. Senator Angel L. Volkes Jr. Senator Volkes Jr., yay. Senator Dwayne M. DeGraff.
Yes.
Senator DeGraff, yay. Senator Ray Fonseca.
Yay.
Senator Fonseca, yay. Senator Alma Francis Heiliger.
Yes.
Senator Francis Heiliger, yay. Senator Javon James, absent. Senator Franklin D. Johnson. Senator Johnson, yay. Senator Kenneth L. Gittens.
No.
Senator Gittens, nay. Okay, Mr. Chair, you have 5 yeas, 1 nay, and 1 absent.
Thank you. The measure has passed. Congratulations. Bill number 35, that's 0238, an act to confer peace officer status on qualified enforcement officers employed by the Government Employees Retirement System of the Virgin Islands, has been properly moved and voted upon favorably and will be forwarded to the Rules and Judiciary Committee for further vetting and consideration. Congratulations, gentlemen, and we'll now take a 5-minute recess to bring in the other testifiers, move into Block 3 so that we could end the day. Again, thank you all for all that you do. Assistant Commissioner, to you and the other law enforcement officers, I say happy police officers, happy Police Week. Thank you.
Thank you. Yeah, it's on the drive. We're right there.
A committee on Homeland Security, Justice, and Public Safety for Tuesday, May 14, 2024 is back on record. We are almost at the end. We heard Block 1 this morning, Bill 35-0248, the resolution petitioning Congress to allow or authorize the people of the Virgin Islands to elect an Attorney General. That measure did not pass. In Block 2, we heard Bill number 35-0238, an act to confer peace officer status on qualified enforcement officers employed by the GERS of the Virgin Islands. That measure passed. And now we are at Block 3, and I'll ask the clerk to read Block 3 into the record.
Yes, Mr. Chair. Block 3, Bill 35-0215, an act amending Title 23, Virgin Islands Code, Chapter 5, Section 457, Subsection A, Paragraph 3, relating to the contents of a firearm license to change the statement in the license, increasing the term of the license from 3 years to 5 years, sponsored by Senator Milton E. Potter. Invited testifiers, the Honorable Ray Martinez, Commissioner of the VI Police Department. Bill 35-0243, an act amending Title 23, Virgin Islands Code, Chapter 5, Section 470, to require individuals to obtain permission from the Commissioner of the Virgin Islands Police Department before purchasing firearm components that will be mailed or shipped to the Virgin Islands. Sponsored by Senator Dwayne M. DeGraff. Invited testifiers, the Honorable Ray Martinez, Commissioner of the VI Police Department, Ian Clement, Acting Attorney General of the VI Department of Justice, Eric Oram, Postal Inspector, the United States Postal Service, and Levi McSheen, Firearms Dealer, Star Time Firearms. Lastly will be Bill 35-0250, an act amending Title 23.
35 what?
Title 23, Virgin Islands Code, Chapter 5, by adding Section 454B, banning assault rifles in the Virgin Islands, sponsored by Senator Dwayne M. DeGraff. Testifiers, or invited testifiers, the Honorable Ray Martinez, Commissioner of the VI Police Department, Ian Clement, Acting Attorney General of the VI Department of Justice, and Levi McSheen, Firearms Dealer, Star Time Firearms. That concludes Block 3, Mr. Chair.
And that was 35-0250.
Zero,
the last
yes. That's what
one. In addition to the invited testifiers, we do have in the St. Croix chambers 2 residents of the island of St. Croix, or Virgin Islands residents, Mr. Horace McGrath and Mr. Gregory McGrath. Welcome. Do we have any correspondence to be read into the record? Madam Clerk?
We do have correspondence from the Postal Inspector. You wanted to?
Yes. We will proceed to the testimonies at this time. The Postal Inspector is not here, but as we proceed, we'll see if that's necessary. So we'll go ahead with the testimony before us. We will be discussing all 3 measures here. So colleagues, I ask that when you're posing your questions to be specific to which bill that you're referring to, and in this block we have 0215, 0243, and 0250. So we'll proceed with the testimony from the Virgin Islands Police Department first, and then on to the Acting Police Commissioner, and then Mr. McSheen, and then the 2 testifiers, the M&M team. Before we proceed to the testimony, Senator Potter, you can introduce Bill number 35, that's 0215, and then Minority Leader DeGraff can speak to the other two.
Thank you very much, Mr. Chair. Good afternoon, colleagues, once again. I offer Bill number 35-0215. This bill is relatively straightforward in that it amends Title 23 of the Virgin Islands Code to extend the term of firearm licensure from 3 years to 5 years. Colleagues, as a general rule, persons possessing licensed firearms are law-abiding citizens who take the responsibility of holding a firearm license very seriously. Increasing the term of firearm licensure from 3 years to 5 years will enhance efficiency by reducing the administrative burden on both license holders and the Virgin Islands Police Department, while maintaining stringent monitoring protocols to ensure responsible firearm ownership. The fee structure will be adjusted to ensure that the Virgin Islands Police Department has no drop-off in revenues due to the expanded licensure period. While I'm not a member of this committee, Mr. Chair, I respectfully ask for your support and that of the other members of the committee to move Bill number 35-0215 forward. Additionally, I met with Commissioner Ray Martinez very recently, and I will be preparing an amendment in the Committee on Rules and Judiciary to require at least one firearm safety refresher course during the course of that 5-year period, the extended 5-year licensure period. Mr. Chair, at the appropriate time, I'm asking you and the additional members of this committee for your support. Thank you very much.
Thank you, Senator Potter. Senator Dwayne M. DeGraff, you're recognized for the introduction of Bills 0243 and 0250.
So the 90,000 is...
Mr. Chair, thank you, Mr. Chair. Good afternoon, colleagues. Good afternoon, testifiers, all of you and listeners present. Bill number 35-0243, an act amended Title 23, Virgin Islands Code, Chapter 5, Section 470, to require individuals to obtain permission from the Commissioner of Virgin Islands Police Department before purchasing firearm components that will be mailed or shipped to the Virgin Islands. That bill is in regards to, I've met with the Virgin Islands Police Department and the postal inspector and the federal agents in regards to firearm components, large extended magazines and other components coming through the mail. And because there's no nexus law that states it is not illegal to send them through, so they have no choice but to give it to the individual once it comes. But they have recommended that if we ask to create a law to request permission from the police commissioner, then it allows for them to turn it over to the police department rather than turn it over to the individuals who it is not a federal law to order. And there were several extended magazines and stuff, so individuals are ordering those components for the firearms and receiving them through the mail, and it's not illegal to go and pick them up. So they want where, with permission from the police department, then they have to go with permission for these components. So rather than turn it over to an individual, they turn it over to the police department. Then the police department can determine, hey, whether you had the permission or not to bring in those extended magazines and other components. So that's what Bill number 35-0243 is in regards. I'm asking for permission and support from this committee to see fit to move this bill forward. Bill number 35-0250, an act amended Title 23, Virgin Islands Code, Chapter 5, by adding Section 454B, banning assault rifles in the Virgin Islands. is basically self-explanatory. You know, there are some amendments that we could add or not add, but this bill makes it illegal to own, possess, sell, or transfer any assault rifles in the Virgin Islands except for military and law enforcement personnel and persons who owned assault rifles prior to the ban. Anyone who owned assault rifles, who have them licensed and stuff, it does not apply to you. So the legal person who took the time out to go through the process to obtain a licensed firearm and it's a rifle, they'd be allowed to keep it. We as a society have to do something about weapons in our territory, crime in our territory. That's my background. You know, I've lived it, breathed it. You cut me, I'm gonna bleed blue. But the fact remains that these weapons are here in our territory and they're being used to kill people. For lack of a better word, they're being used to kill people. The licensed, registered owners who out there legally who possess them aren't using them in that manner. But these individuals who obtain them and have them on the street, they're parts of ghost guns and different weapons like that, and they're out there killing people. So this is one measure. Another measure, I'm trying to save lives, for lack of a better word. And there has been a ban in the United States from 1994, a 10-year ban that was passed by the Congress and signed by President Bill Clinton. And it sunset in September 13, 2004. There were several constitutional challenges against that ban for the 10 years, and they were all filed against it, and they were rejected by the courts. So again, and there were also several attempts to try to renew the ban, but that too has also been unsuccessful. So it has been put in place. It has met constitutional muster. And again, I'm trying to save lives here in the Virgin Islands. I'm asking for support of this committee and my fellow colleagues. Thank you for the time, Mr. Chair.
Thank you, Minority Leader DeGraff. I will allow for the testimonies before I ask legal counsel to give us a clarification before the debate time. So at this time, we'll hear from the Virgin Islands Police Department, then the Department of Justice.
Good afternoon. I am Sidney Olsko, Assistant Commissioner with the Virgin Islands Police Department. Good afternoon to the Chair, Honorable Kenneth Gittens, legislative body and staff, members of the VIPD executive team, and to the members of the listening and viewing audience. Again, my name is Sidney Olsko, Assistant Commissioner. We thank you for the opportunity to present testimony regarding a proposed territorial assault weapon ban. Also extending the firearm license renewal period from 3 to 5 years, and the creation of a mechanism empowering the police commissioner with defined authority to monitor and approve or deny the ability to import rifle parts into the territory. Regarding the assault weapon ban, firearm ownership is a part of the daily fabric of our community. Opinions regarding firearms range from views which are good, bad, or indifferent. The Second Amendment of the United States Constitution is part of the Bill of Rights, and it reads, "A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed." In brief, the Second Amendment protects the rights of individuals to keep and bear arms. It was adopted in 1791 and has been the subject of significant debate and interpretation throughout American history. Some view it as affirming an individual's right to own firearms for self-defense and other lawful purposes, while others interpret it as primarily protecting the collective right of states to maintain militias. In simple terms, a firearm is a tool that uses a controlled explosion or combustion to propel a projectile through a barrel. In 1791, when the Second Amendment was promulgated, the mechanism and operation of a firearm was vastly different than it is today. One of the many arguments against firearm ownership, especially related to assault-style weapons, is the Second Amendment requires an update to match the technology that currently exists. At the time, loading, aiming, and firing a firearm was a complicated process which limited the user to firing 2 to 3 rounds a minute. 2 to 3 rounds a minute. Current technology allows an assault rifle to fire rounds at a rate of 1 per second. A typical 40-round magazine can then be swapped for a full load in a matter of seconds. The pro-assault rifle argument rarely considers necessity unless you reside in an area which hunting is readily available. It does include the right reflected in the Second Amendment to bear arms. The Virgin Islands Police Department takes a somewhat neutral position in the argument. I do recall Switzerland being spoken about earlier. The agency does, however, remain cognizant and ready to perform its duty to ensure safety is addressed across the board. Generally, the law-abiding citizens that request a firearm license falls in one of few categories: employment-related protection, personal protection, or sport, target practice. Most encounters involving a firearm occur in a close quarters environment at a distance of 7 yards or less. For protection, a pistol or a shotgun, which is accurate at the range described, is sufficient. A .223 caliber round fired from an assault weapon can travel 400 to 500 yards. This presents the possibility that a high-velocity rifle round, as described, could affect persons or property well outside of the area of the incident. This fact requires an open and honest discussion regarding all high-powered rifles owned in the community. Regarding the firearm license renewal period,
Assistant Commissioner, do me a favor and speak like directly into the mic, because no, you're
How's
speaking.
that?
No, that's to the side. Shift your chair over so the mic could be directly right. Now bring the mic.
How's that?
Turn the mic so you could be directly in front of you.
Like
right.
that.
You're speaking to the side of it. Right.
Okay, technology.
Okay. Right.
Got it. Okay, regarding the firearm license renewal period, we have also been invited to discuss extending the firearm licensing period from 3 years to 5 years. Each firearm license applicant undergoes a vetting process to ensure the user possesses the capacity to handle and safely maintain a firearm. The process ensures the firearm owner is trained in proper usage. The process also ensures the licensee possesses a secure location to store the firearm in a safe or lockbox to prevent loss or theft. Once the licensee is approved, the person must renew their license every 3 years. The renewal process does not include capacity review or storage inspection. It does require some paperwork and an interview. Generally, a law-abiding person that licenses a firearm is not of immediate criminal concern to the Virgin Islands Police Department. It is the agency's position that a 3-year renewal period is already quite lenient. We must also consider our own independent life experiences. I recall a recent ad campaign in which the tagline read, "Life comes at you fast." Many things can change in three years. Many more can change in 5. Recently in the state of Ohio, an Uber driver was killed by an elderly male that legally owned a firearm. The man had been tricked by a scammer, and the Uber driver was unknowingly a pawn in the event. The news report showed video of the incident. As I viewed the news report displaying the actions and them playing the 911 call made by the weapon owner, I can't help but think of all of the senior members of this community that are legal owners of firearms. This may require some extra scrutiny to assess their ability to process gun ownership and response. This is only one example that reveals there may be a need for more time-based review rather than the alternative. I'd also like to remind everyone that this is National Police Week. It extends from Sunday, May 12th through Saturday, May 18th. It is a time to reflect on the past and present actions and sacrifices of the members of the law enforcement community. This week, we also pay homage to the members of law enforcement who gave their lives in the line of duty. Our colleague and brother in blue, Detective Delbert Phipps Jr., who was tragically lost on July 4th, 2023, will be honored tomorrow, May 15th, 2024, at the U.S. Capitol. His name will be affixed to the wall at the National Law Enforcement Officers Memorial in Washington, D.C. Police Commissioner Ray Martinez and Police Chief Stephen Phillip will be in attendance. Virgin Islands Police Department is your department, ladies and gentlemen. This week, please make an effort to thank your officers for their service. I thank this body for the opportunity to testify. I stand ready to answer your questions.
Thank you, Assistant Commissioner. Acting AG, you're recognized for your testimony.
The Department of Justice, Acting AG, Acting Attorney General Ian Clement, the Department of Justice does not have testimony with regards to Bill 350215, but I will offer testimony on Bills 350243 and 350250 in order. Good afternoon, Chairman Gittens, Committee on Homeland Security, Justice, and Public Safety members, legislative staff, and the viewing and listening audience. My name is Ian S.A. Clement, and I am the Acting Attorney General of the Virgin Islands. I am honored to be invited to provide a few remarks regarding Bill number 350243, as proposed by Senator Dwayne DeGraff. Bill number 350243 seeks to amend Title 23 of the Virgin Islands Code, Chapter 5, Section 470, to require individuals to obtain permission from the Commissioner of the Virgin Islands Police Department before purchasing firearm components that will be mailed or shipped to the Virgin Islands. The Department of Justice has done a preliminary review and offers the following comments. The stated purpose of Bill number 350243 is to require a person to obtain permission from the police commissioner before purchasing firearm components that will be sent to the Virgin Islands. Unfortunately, the proposed statute is too ambiguous and criminalizes a broad category of conduct by failing to define firearm component within Title 23, Virgin Islands Code, Section 451. This ambiguity could have serious consequences, as innocent or cosmetic modifications of a firearm could constitute a crime if not reported. For example, changing a grip from plastic to wood or adding a scope to a firearm could become illegal if firearm components remain undefined. Additionally, by giving the police commissioner sole discretion to approve or deny requests for firearm components that will be sent to the territory, Bill number 350243 could run afoul of the recent United States Supreme Court decision in New York State Rifle and Pistol Association versus Bruin. The court in Bruin struck down a New York concealed carry license law and changed how the Second Amendment challenges will be reviewed. The Bruin decision has yet to fully play out, as the Supreme Court suggests that any firearm regulation inconsistent with the nation's historical tradition would be invalid under the expanded post-Bruin reading of the Second Amendment. With that said, the following should be considered as you evaluate and vote on the proposed bill number 350243. First, I would consider defining firearm components in Title 23, Virgin Islands Code, Section 451. Firearm components could specifically include barrels, slides, triggers, magazines, and any other mechanisms designed to increase the rate of fire or to reduce the weapon's identification. Second, in consultation with the Virgin Islands Police Department, I would consider refocusing Bill number 350243 into an anti-modification statute rather than an anti-import statute. Rewriting the bill as an anti-modification law would make a criminal act to alter a weapon to make it more lethal. The anti-modification law would include binary triggers that increase the rate of fire and extended magazines. It would also cover firearms altered to be less traceable, including removing the serial number. Finally, I would urge careful consideration of any possible Bruin conflicts. The court in Bruin decision is a crucial issue, particularly since the Bruin court opted for historical analysis in place of individual discretion and traditional means-ends testing. I thank the committee for the invitation to testify on bill number 35243. This concludes my formal remarks and remain available for any members' questions. And now, my testimony for bill 350250. Good afternoon, Chairman Giddens, Committee on Homeland Security, Justice and Public Safety members, legislative staff, and the viewing and listening audience. My name is Ian S.A. Clement, and I am the Acting Attorney General of the Virgin Islands. I am honored to be invited to provide a few remarks regarding Bill number 35-20250, as proposed by Senator Dwayne DeGraff. Bill number 350250 seeks to amend Title 23 of the Virgin Islands Code, Chapter 5, by adding a new section 454, subsection B, which would ban assault rifles in the Virgin Islands. The Department of Justice has done a preliminary review and offers the following comments. Bill number 35-0250 addresses an issue that many states have considered in recent years. Currently, 10 states and the District of Columbia ban the manufacturing, selling, and transferring of assault weapons. Some states take the ban a step further by also prohibiting the possession of assault weapons. Because there is not a federal assault rifle ban in place, states and territories have the freedom to decide whether assault weapons are prohibited within their jurisdiction. As a result, laws vary from state to state but have one common goal: to prevent assault weapons from being readily available to the general public. Brady, a nonprofit advocate for gun control and against gun violence, found that 14 assault weapons and large capacity magazines are used in public mass shootings. Nearly 14 times as many are injured, and twice as many people are killed. Bill number 350250, if passed, hopes to decrease the potential for mass shooting events with mass casualties in the Virgin Islands. To be effective, Bill number 350250 must also be constitutional. Probably of most concern is how Bill number 35-0250 will fare next to the First and Second Amendments of the United States Constitution and the recent Bruin ruling. First, we should consider if Bill number 35-250 infringes on the First Amendment, which protects freedom of speech, among other things.
Acting AG. I really didn't want to interrupt you, but the more you keep saying 35, that's 0250, it just irritates. It's 0250 is the number for legislative record, all right? I don't want it to be 0250. O is a letter. You may proceed.
Thank you. Okay. First, you must consider if Bill number 350250 infringes on the First Amendment, which protects freedom of speech, among other things. Specifically, does bearing arms constitute speech covered by the First Amendment? While these claims have been increasing recently, judges have consistently rejected them, finding that carrying a firearm does not constitute expressive conduct. Several courts have found that gun control laws are not entitled to First Amendment coverage because they do not satisfy either prong of the Spence test, which states that a nonverbal act is expressive if and only if it is, one, intended to communicate a particularized message, and two, the circumstances in which the action is performed, the likelihood is great that the observers will understand the message. While the Spence test first prong concerns speaker's intentions, the second concerns the listener. Courts have consistently recognized that the most likely reaction of a bystander to a firearm, especially an assault weapon in public, is fear. Next, we should look at the Second Amendment to the U.S. Constitution, which protects the right to keep and bear arms. In 2008, the United States Supreme Court held a rule that the Americans, through the Second Amendment, have the right to own guns absent military service and to use them for lawful purposes. This right, however, is not without limits. Justice Antonin Scalia wrote in the Heller decision, like most rights, the right secured by the Second Amendment is not unlimited. It is not a right to keep and carry any weapon whatsoever, in any manner whatsoever, and for whatever purpose. Although the Second Amendment and the Heller decision opened the door to more Americans owning firearms, the ruling did not reverse prohibitions related to the possession of firearms by felons or the mentally ill, or laws forbidding guns in certain places, including schools and government buildings. With self-defense in mind, the Heller opinion also found the right to bear arms does not include the right to carry dangerous or unusual weapons, which has been regularly upheld since. Again, we should also consider the Supreme Court's decision in Bruin, which struck down a New York concealed carry license and changed how future Second Amendment challenges will be reviewed. Instead of using an analytical test that considers the nature and the government's interest in regarding an activity, the new test is rooted in history. Under Bruin, courts must decide if the plain text of the Second Amendment covers the conduct at issue. If the conduct is covered, the regulation must be consistent with the country's historical tradition of firearms regulation. With that said, the following should be considered as you evaluate and vote on Bill number 350250. First, assault rifle, as defined by 23 Virgin Islands Code Section 451M, requires the weapon to be automatic. This narrow definition excludes semi-automatic weapons, including AR-15s, which are frequently used in mass shooting instances and alarmingly are turned up on the streets of the Virgin Islands. Bill number 350250 may not ban the weapon if it's meant to target. I would consider modeling the Virgin Islands legislation after the laws in Connecticut, which explicitly includes semi-automatic weapons, and California, which creates classes of assault weapons subject to the ban, and a class of named models, including AK and AR models. Secondly, the proposed penalty structure outlined in 23 Virgin Islands Code, Section 454, Section 454B, is inconsistent with the other firearm penalties in the criminal code. Under 14 Virgin Islands Code, Section 2253A, simple possession of an unlicensed weapon is a mandatory 10-year period of incarceration. The proposed penalty for simple possession of an assault weapon is not more than 5 years. As a result, the offender with an unlicensed 6-shot revolver could serve 10 years in prison, but if he possessed a military-grade assault weapon, he would not serve more than 5 years. I would consider making the penalties at least even, if not greater, for owning, possessing, selling, or transferring an assault rifle. This recent Supreme Court decision in Bruin has yet to play out, And as I've already stated, finally, as a matter of housekeeping, I would add the word code after Virgin Islands in the newly proposed 23454B subsection A. I thank the committee for the invitation to testify on Bill number 350250. This concludes my formal remarks and remain available for any members' questions.
Thank you, Acting Attorney General Clement. Next up, we'll hear from Mr. Levi McSheen. You're recognized for your testimony.
Good day, Your Honorable Senator Kenneth. Honorable Senator Kenneth Gittins and members of the committee. My name is Levi McSheen. Thank you for allowing StarTime Firearm, a local certified FFL dealer of the territory to test in it. A local dealer to test. Hold on. Wow. All right, one sec. My name is Levi McSheen. Thank you for allowing StarTime Firearm, a local certified FFL dealer, to offer testimony in supporting of Bill number 35-0243, amending Title 23 of the Virgin Islands Code, Chapter 5, requiring licensed firearm holders to obtain permission from the U.S. Virgin Islands Police Commissioner purchasing firearm components being mail shipped to the U.S. Virgin Islands, being heard in the Committee of Homeland Security, Justice, and Public Safety. As the owner of StarTime Firearms, a federal licensed dealer with storefronts location in St. Thomas, VI, Atlanta, Georgia, and Miami, Florida, I have been involved in firearm industry for over 10 years, accumulating extensive experience within the sector. Furthermore, having spent my formative years in the U.S. Virgin Islands, I have directly encountered both advantage and disadvantage of firearms. This first-hand experience drives my primary objective to impact knowledge on firearm safety to fellow members of the community, of my community. I am testifying in favor of obtaining the police commissioner approval before allowing the purchase of firearm component being mailed and shipped to the U.S. Virgin Islands. Having the commissioner involved in the approval process will provide an additional layer of oversight and accountability, potentially helping identify and prevent suspicious unlawful firearm transactions in our community. This measure can help crime prevention and avoid illegal activities. Firearm components should be shipped to an FFL dealer after obtaining commissioner's approval, adding a layer of accountability protection for our citizens. Passing legislation regarding police commissioner approval for a firearm component is a critical step towards promoting responsible firearm ownership, provides accountability, and aligns with our efforts to mitigate the risk of firearm falling into the wrong hands. Again, my name is Levi McSheen. Thank you for allowing StarTime Firearms, a local certified federal dealer, to offer testimony on Bill number 35-0250, amending Title 23 of Virgin Islands Code, Chapter 5, adding sections to ban assault rifles in the U.S. Virgin Islands. I acknowledge the pressing need to address the issue illegal rifles in the U.S. Virgin Islands. As a licensed firearm dealer, a pronoun of the right for citizens to own licensed weapons, I do not support the outright ban on assault rifles. Instead, I am advocating for implementing stricter policies for the possession and imposing more rigorous requirements for approval of such firearms including length of time per tail owners have held a firearm license, limited magazine capacity, mandatory training, and psychological evaluations. Exploring another aspect, which is a major area of concern in current is a major area of concern is the current process at the airport, where passengers are permitted to declare firearm into the territory via honor system. This presents a significant loophole that needs to be addressed. It would be alarming to note the number of firearms entering the territory through the airports due to this system. Allow us the opportunity to enhance the procedure before considering total ban of assault rifles in the U.S. Virgin Islands. Startime Firearms support the committee efforts to develop a balanced approach to uphold our Second Amendment right while prioritizing safety of residents. Thank you.
The committee will take a 5-minute recess. The Committee on Homeland Security, Justice, and Public Safety for Tuesday, May 14, 2024, back on record, in record time, less than 5 minutes, right? Mr. Machin, you could wrap up?
Yeah, I just wanted to say thank you for your time. I'm available for questions, to answer any question at this time.
Thank you. McGrath brothers, you want to put anything on record before we start the debate?
Yes.
Please start with your name.
Good afternoon. My name is Gregory McGrath. I'm
President of St. Croix.
I am the former Director of Safety for WAPA and former Acting Chief Administrative Officer. I'm very well versed on compliance issues, CFRs, and legal compliance. I'm very concerned about the cavalier way in which we handle the constitutional rights of the people of the Virgin Islands. We have the Supreme Court, which is the Supreme Court of the land. That's not a questionable thing. We have the Constitution, which is the supreme law of the land. And the people are entitled to equal coverage and equal protection under the law. The Supreme Court has ruled on several items here related to these bills. First and foremost, you're not allowed to charge exorbitant fees for licensing, have excessive wait times, or use those licensing fees to raise revenue. This is not me saying this. This is a Supreme Court case decision. So when I hear that you need to make sure that VIPD doesn't lose revenue, that is a violation of my constitutional rights. I want to be very clear. With regard to the parts, so now if you give the commissioner the sole authority to determine if I can have parts that I need to maintain my firearm, you're saying that if he has the right to deny me that, he can deny me the right to own a functional firearm. Suppose a trigger breaks, a component breaks, and he decides he's not going to approve it. Where do I go from there? The assault weapons ban. I disagree with the AG. The Supreme Court has ruled that AR-15s are firearms in common use, and they're not unusual, and as so are protected under the Second Amendment. Now, if the Supreme Court has ruled on all of this, what is this debate we're having? Do the Virgin Islands believe that they can usurp the Supreme Court, or that they can usurp the Constitution? I served in the military 11 years, and I swore to uphold the Constitution and defend it from all enemies, foreign and domestic. I am a constitutionalist, and I really do not appreciate the cavalier way in which this is being handled. And community safety does not trump constitutional rights. I'm hearing a lot of people's logic and philosophy and belief system. This is the rule of law. And when you lose the rule of law, you lose order. And you invite anarchy and chaos. Because if you are not going to abide by the Constitution and the Supreme Court decisions, then why should anybody abide by what anybody in here says or does? We were given our freedom by the 13th Amendment. Not the proclamation, not the Emancipation Proclamation. And in America now, your freedom that gives you the right to sit here and have these conversations is guaranteed by the 13th Amendment. And when you start pulling at the thread of one amendment like a cancer, it will reach all the other amendments. And for us to be 12% of the population, I think we need to be very careful about how we handle that document, because that's the only thing between us, and as President Biden said, careful you don't find yourself back in chains. So we need to be very careful about our civil rights and our constitutional rights, and we need to guard them jealously, and we need to balance the safety of the people with our constitutional rights. Senator DeGraff said that the people that legally own firearms are not the ones he's concerned about when it comes to automatic weapons. And then you want to turn around and then deny them the right and do nothing to the illegal gun activities that we have here? So if I'm supposed to understand this correctly, you're telling me, yes, I know that you're not doing it, and I know the criminals are doing it, but we're not going to punish them, and we're not going to ban their weapons. We'll ban yours, because you're the guy that's responsible enough to get the safe and to apply for a license and to be a responsible gun owner. So we're gonna penalize you. But the guys on the street that are selling AK-47s out of their truck, you're not gonna talk to those guys, right? I am one voice that represents many other people who feel the exact same way. And these half measures and quick fix today become tomorrow's problem. So I'm asking this body to do their due diligence and due care and protect the constitutional rights of the people, protect their civil rights. And one of them is the right to defend yourself, because you can't give me a 38 to contend with a man that's kicking down my door with an AK-47. I don't know what the AG or whoever got that, whoever was saying about, I guess it's the assistant commissioner, about a pistol and everything happens in 7 yards and less. That's not what I've seen. That's not the videos that are circulating around here. And they're not carrying pistols. Our defense must match the threat. If I'm a gun owner and I'm a solid citizen, I must be able to defend myself from the credible, proven threat that exists. And it's not coming with these handguns.
Thank you, Mr. Gregory McGrath. Next up, we'll hear from Mr. Horace McGrath.
Good afternoon, Mr. Chair, other members of this body,
Good afternoon.
listening and viewing audience. My name is Horace McGrath, Director, Bureau of Corrections, retired. Put it on the record because I believe that I have a keen working knowledge of the impact of crime on victims and on our society as a whole. Violent crime and gun crime in particular is of major concern. However, the need to address crime should not be at a cost to individuals' rights, period. The Bill of Rights, commonly referred to as the Constitution, and the Second Amendment in particular, is the issue today. The Second Amendment is not a second-class right. It's a right like any other right enshrined in the Constitution. With regards to the so-called assault rifle, the Supreme Court of the United States has ruled that any firearm that is in common use may not be banned. I didn't say that. The most recent Supreme Court ruling said that. I hear mention of previous cases before the Brewing case. But there are those of us here that are doing our research. We know better. Either we choose to ignore or we doing the work around. But whatever it is, it's not in compliance with the Supreme Court ruling. And that's a fact. I think we need to target the criminal element. The importation of firearms, illegal firearms and ammunition should be the focus. The focus should be on crime and criminals, not your law-abiding citizens. Criminals don't care what we put on the books. They don't comply. They have their own set of rules that they subscribe to. So when we create rules, laws, to further restrict, who are we restricting? Those that are in compliance, the law-abiding? I missed the boat. I don't get it. So we further restrict the law-abiding from the ability to protect themselves, their family, their property, but there's no mention of those who are actually out there perpetrating the crimes. Are we saying that duly licensed firearm owners are committing the crimes or they're not? And if they're not, then why are we further restricting folks from actually going out there, applying for and receiving gun license? AR or whatever they choose, you're going to know exactly who have what. And if the research has indicated or proven that these are not the folks that are committing crimes with these firearms, then why are we targeting these individuals, the common law-abiding citizens of these territories? It just don't add up. We've heard nothing but talk about restricting the purchase of parts. We've heard of the ban on assault, the so-called assault rifle, which is I know AR to be a semi-automatic rifle. You can't take an AR-15 into war, to battle. So why are we making that kind of comparison? I don't get it. Lastly, the Supreme Court left open the challenge to licensing schemes and exorbitant fees that states and jurisdictions are going to impose on the Second Amendment issue because they knew it was going to come. And lo and behold, it happened here in the Virgin Islands. The cost went up double. Don't take my word for it, ladies and gentlemen. Do the research. The Bruin decision. The Supreme Court left open the challenge because they knew that this was going to come, and it came. Some of us are paying attention, we're watching, but when we start to tread on the Constitution, there's going to be a pushback. We're paying attention. That concludes my testimony. Thank you for your time.
Thank you, Mr. Horace McGrath. Thank you all for your testimony. And I think I truly enjoyed these testimonies, and I like when we have pros and cons, or those for and those against, and then we start the conversation so that we could have a balanced conversation. So we will recess for 3 minutes and come right back and commence our debate on this matter, which will go a 4-minute debate once we get back. So the committee will recess for 3 minutes. The Committee on Homeland Security, Justice, and Public Safety for Tuesday, May 14, 2024 is back on record. We'll start, well, before we go to the first speaker, I did say I wanted to hear the testimony and then go to legal counsel to ask. I'm seeing that counsel is there. Yeah, we did have a testimony from postal inspection, but again, I'll make an exception for that. Are you prepared with that? I'll make an exception to hear from them, since that's a federal entity that plays a crucial role in our Homeland Security efforts. But it's not usually my practice to allow testimonies to be read into the record and individuals are not here to be queried on what it is they're stating. But I'll make an exception here, and we will hear the testimony from the postal inspector, and then legal counsel, just stand by. I do have a question for you on Act 7091. Madam Clerk, you may proceed.
Yes. Yes, Mr. Chair. We received a response from Inspector Brian Bone, who's a program manager, Congressional Affairs with the U.S. Postal Inspection Service, Washington, D.C. It proceeds as follows. It says, good afternoon. The U.S. Postal Inspection Service received your request for testimony on Bill 35-0243. Unfortunately, we must respectfully decline the opportunity to testify on this matter. However, please know that the Postal Service Inspection Service works aggressively at all levels of our organization to prevent the domestic and international transportation of firearms through the mail. Postal inspectors seize firearms both through targeted interdiction operations and incidental to other investigations, such as narcotics. Please do not hesitate to contact me if there are other concerns regarding this matter. Respectfully, Brian. That concludes the correspondence.
Thank you, Madam Clerk. Legal counsel, as we discuss the bills before us, in particular, I'm looking at, I believe it's 35, that's 0250, the banning of assault rifles. Looking at that bill that we're discussing today, and looking at Act number 7091, that also speaks to assault weapons therein through definition. It is to actually prohibit the unlawful possession of automatic weapons with assault weapons defined. Is there a difference between these two measures? The Act number 7091, which is already in place back in the 28th legislature, versus what's being proposed today?
Mr. Chairman, you reference Act 7091, which codifies specific sections entitled, actually there's a few things. It codifies the unlawful possession of automatic weapons in Title 14, Chapter 113 of the Virgin Islands Code, and also amends Chapter 5 of Title 23 of the Code. And so to answer your question specifically, the first portion of Act 7091 is a criminal code. So it specifically speaks to the penalties, the criminal penalties, if one were to violate the provisions. For instance, it states that, and I'm just going to paraphrase a portion of what is in the statute, they may be arrested without warrant and shall be sentenced to imprisonment of not less than 10 years, or more than 20 years, and fined not more than $25,000. And then it goes on for individuals who have been convicted of a felony in any state, territorial or federal court of the United States, and so forth. whereas Bill 35-250 simply makes it unlawful for a person to own, possess, sell, or transfer any assault rifle in the Virgin Islands. And it also says that the section, whoever violates the section is guilty of a felony punishable by imprisonment of not more than 5 years or a fine of not more than $10,000 or both. So the fundamental difference is that if we were to equate the weapons that are defined in Title 14 as similar or substantially similar to what is being stated in this bill, the criminal penalty in the current statute is not less than 10 years and not more than 20 years, whereas this bill, it is not more than 5 years and a fine of not more than $10,000 or both. So that is, even though this current bill that is before this committee is addressing similar types of weapon, the criminal statute is more stringent with respect to what would occur if an individual were to violate it, specifically Title 14, Chapter 113, Section 2253. And I believe testimony earlier today alluded to the fact that the statute should be in consonance, or the penalties should be equivalent. And I believe that was discussed earlier today. Does that answer your inquiry, Mr. Chairman?
It really doesn't. And I'm left even more doubtful. But, you know, I will listen to the testimony and proceed. So, and before Senator Bulkers go up, VIPD or the AG's office, anyone, I mean, you guys could back up each other. What have you seen, like over the past 5 years, that's been, what's the weapon used more frequently or most popular weapon identified in the last 5 years of homicides? Please recognize the mic of the testifier, Assistant Commissioner Elsko.
Test. Sidney Elsko, Assistant Commissioner, VIPD. For the most part, those weapons include handguns.
Those weapons include what?
Handguns, pistols.
Thank you. Senator Angel Bulkers, you're recognized for your 4 minutes.
Thank you, Mr. Chair. Good afternoon to the testifying panel here. And I want to say, you know, this is definitely a very much needed, robust conversation that surrounds the topic of gun safety in the Virgin Islands, right? And I want to take the time out to commend the bill sponsors for their efforts, regardless of however this goes this afternoon. Because we know that our gun violence here in the Virgin Islands has been running rampant. And of course, everybody has a part to play, to include the VIPD and all public safety officers. And in addition to that, we as legislators have our part to play in the sense of trying to help or adhere to create frameworks for law to operate. I want to start off with Bill number 35-0215, and I know that the bill sponsor mentioned that there is a subsequent amendment that would technically create a fee structure that would accommodate the fact that we're changing the terms of the licensure. So I look forward to that amendment, and I believe if that amendment comes forward, that would be a plus for the bill so that we do not lose any revenues. We don't want to see any economic impact that would impact the VIPD in the sense of a negative economic impact concerning that. I see no harm in extending the amount of years for a gun license, so I don't have any questions surrounding that, as long as there's an amendment to accommodate for any potential loss of revenues. Concerning Bill number 35-0243, concerning obtaining the permission from the Commissioner of the Virgin Islands Police Department, I know that the Gun Control Act of 1968 regulates the sale and transfer of firearms and firearm components across state lines and requires licensed dealers to comply with federal standards. And it also defines the conditions in which firearms and firearm components can be shipped or transported. And under the GCA, individuals purchasing firearms or firearm components must do so through federally licensed dealers. And I fear that this bill in its current form potentially conflicts with the GCA and the principles of the Commerce Clause. And the bill requires that there should be some local permission before purchasing or shipping the firearm components, which could preempt that federal law, which could be preempted by that federal law. Sorry, let me clarify.
1 minute.
Which already comprehensively regulates those types of transactions. So I cannot support that bill in its current form because of that. And of course, we've heard testimony here today from a number of individuals concerning their concerns with federal constitutional laws. And so in that case, along with some other issues that I have, which I don't have enough time to elaborate on, and I just want to move forward to the last measure, which is 35-0250, concerning the banning of assault rifles, which also has some constitutional issues as well concerning the Second Amendment. In addition to the fact that there was a federal assault weapons ban, I believe the bill sponsor mentioned it lasted from 1994 to 2004. That ban was removed for whatever reasons. And of course, there is nothing that prohibits us from trying to be innovative, Mr. Chair, if I may.
You may.
Thank you, Mr. Chair.
You may conclude.
There is nothing that prohibits us from being innovative in how we try to approach the situation concerning the aspect of how we want to craft the law. We did hear some suggestions from the acting Attorney General concerning how the law should specifically be crafted so that there is no constitutional issue. And I do agree with the acting Attorney General in that case. And I'm hoping that the bill sponsor does adhere to those recommendations so that the bill can be amended or changed to reflect that. So, but in its current form, 35-0250, I will not be able to support that measure as well, but I will support 0215 as long as there is that amendment which is subsequent. Mr. Chair, I didn't have any questions. I just wanted to at least clarify my position on the floor. Thank you for the time.
Thank you, Senator Bolkes. Next up, Senator Franklin D. Johnson, you're recognized for your 4 minutes.
Good afternoon. Thank you very much, Mr. Chair. Good afternoon again to the testifiers, viewing and listening audience. I really don't have any issue with Bill 35-0215, but I definitely want to ask a question because when the bill sponsor was presenting the bill, he spoke about the cost of firearms, but I do not see that in this measure here. But I definitely wanted to ask Assistant Commissioner Chief Esco, I understand there was an increase in licensing firearm. And that increase went pretty much double. Why that double in the increase? Because it now infringe on folks being able to maintain licensing their firearms. The price have doubled. And we're attacking folks who are legit, licensed firearms carrier. It's creating a hardship. If a person have 3 guns, for example, instead of he paying $150, $225, he's now going all the way up to $450, if I'm right with my numbers. Someplace around there. Mm-hmm. What's the increase and why for that large of an increase?
Sidney Olsko, VIPD. I can't tell you why it went up What I can tell you is that services cost money. Whoever made the decision on how much the increase was, I can't tell you why they made that decision, but I can look into it and get back to you.
That's my issue with that measure. I have no problem supporting that measure. The other two bills, I definitely have some issues in regards to them. And I wanted to probably through the chair to legal counsel for bill number 350250, section C, subsection A is not applicable to law enforcement and military personnel and persons who owned own assault rifles before the enactment of this section. What my question to legal counsel is this not some sort of violation or discrimination on those some people have already, and now you're telling the rest of the legit folks that they cannot have? So I needed to hear from legal counsel with that subsection, especially where if someone already have the rifle, he can continue having it, but now I who carry a licensed firearm cannot. Is that some constitutional violation that where some already have this weapon and now a next set cannot even engage in acquiring that weapon? Mr. President, Mr. Chair.
Legal counsel, you may respond.
Through the chair to Senator Johnson. With respect to your question, I don't know that necessarily there's a constitutional issue. The Supreme Court of the United States has given states and territories the ability to enact reasonable gun control legislation, which is why in several states of the United States you have varied gun control legislation or gun control laws, and they differ from state to state, which includes some state outright ban assault rifles and so forth.
1 minute.
With respect to whether or not the fact that somebody who may have a licensed handgun or licensed weapon that is not an assault weapon, I don't know if that's a constitutional issue. Obviously, it can be challenged, but it would seem it would come down to the fact that what is reasonable, what is the reasonableness of such a restriction. So it clearly indicates that if this body, and unless it's challenged, is ultimately decided that it's reasonable, that this statute is prospective and applies to people who do not have it now, then it would be upheld. If it is unreasonable, it would not be upheld. So to whether or not that is a constitutional issue, that's something that we'd have to do some more research on. But on its face, I don't know that it is, given the way that assault rifles and assault weapons are now treated so differently in various jurisdictions.
Thank you very much, and may I wrap up, Mr. Chair?
Thank you. You may wrap up, Senator Johnson.
Thank you very much, Mr. Chair. I do support the first piece of measure we have here, but the other two I really have some resolve, feelings about them banning and stopping individuals from being able to protect themselves. What I think we really need to do as a body is find ways of stopping the infiltration of all of these unlicensed firearms that is coming to our territory. Because the folks who have licensed firearms, and I think the Assistant Commissioner will need to answer to this, are we having problem with people who have licensed firearm utilizing the firearm wrongfully? Have you been having to arrest individual that has licensed firearm? Or most of the problems are people with illegal firearm in our territory?
Sidney Olsko, VIPD. So, no. Generally, we have not seen many issues with the members of the society that license their firearms.
Thank you very much. I rest my case right there. Thank you very much, Mr. Chair.
Thank you, Senator Johnson. But for a minute, I was wondering if that was a trick question. And the reason for that being is that, and again, I like the conversation. So, if there is no ban on particular firearms, there's no ban. So, there's no law, nothing is illegal for you to possess it. So, unless you make something, put something into law, and it's not prohibited, and you go ahead and possess it, then you're in violation of something. But if something is not banned, then what are you in violation of? Nothing. So I am, aim for you to answer. I'm just trying to see here where we're going, because of course, it's not about licensed firearm owners being in violation or breaking the law. Obviously, they've gone the right route in securing a firearm license. What the bill sponsor is seeking to do is prohibit individuals who don't want to follow the law from bringing in firearms. Again, I will continue to listen to the testimony, to the debate back and forth, and see where we go, because I think he's looking at particular, no, not I think, he's looking at particular firearms in his bill here on 0250, which in particular are the assault rifles. But at the same time, I understand from Mr. Gregory McGrath about meeting fire with fire, and which made me think back on this movie where what's his name again? The guy said, "That's not a knife. This is a knife." Crocodile Dundee, yeah. You know, so I mean, again, you ain't gonna send a man to war with a 6-shooter pistol. Right. But we'll proceed. Vice Chair Fonseca. Vice Chair Fonseca, you're up for your 4 minutes.
Yes, thank you so kindly, Mr. Chair. Pleasant good afternoon to the listening audiences. Ladies and gentlemen, welcome to the distinguished panel of testifiers. So in this block 3, we have 3 bills under consideration. Bill number 35-0215, basically it increases the term of the firearm license from 3 to 5 years. That bill, I think, is very needed in the community. We have bill number 35-0243, which deals with the purchasing of firearm components that will be mailed or shipped to the Virgin Islands. And basically, the acting attorney general gave testimony that the bill may need some revision. And bill number 35-0250, which is would ban assault rifles in the Virgin Islands. And it seeks to enhance public safety by prohibiting the ownership, possession, sale of those weapons, with exception of law enforcement military personnel. You know, gun violence, you know, first I want to start by offering my condolences to all the family and friends of our people in the Virgin Islands who have lost members due to gun violence. You know, I have a question, you know, why do mostly younger males in our community, why do they feel the need to own these guns? You know, why is it that they need these type of guns? You know, and then of course, you know, I agree that every illegal gun off the street reduces the homicides, it saves guns. So I am definitely for reducing those illegal guns on the street. But you know, today in this session, we have to be mindful that the Second Amendment gives you the right to keep and bear arms, and it says that it should not be infringed, the right to keep and bear arms. So I wanted to ask start time firearms. How you involved with shipping? You're a legal gun dealer. How are the guns them coming into the territory? The illegal guns you are bringing them in legally to the territory. Tell me, because you hear all kind of thing. How the illegal guns them coming in here?
From being in the territory and my observation, I think that most of them coming from the airport.
They're coming in through the airport. So it's Virgin Islands bringing them in, or people from the States coming in with them? Do you know?
I can't answer that part, but I could tell you that they're coming in from the airport due to the fact of the honor system. When we take a firearm to the mainland, the firearm don't come around on the same belt and we just pick it up. We got to go someplace different to collect it with your ID, with your tag, your bag tag. So if it could be reciprocated here, that will help decrease a lot of those illegal firearms from coming through the airport.
Okay, that's good information, because we heard testimony. Well, we read testimony from the male inspector saying that they're doing their part. Of course, people that say that a certain group of people bringing them in on the boat. Some people been saying that we're bringing them in furniture and thing, but you're telling me they're coming into the airport. So that's good, because if they're coming into the airport, I know Commissioner Ray Martinez gonna beef that up, because he's one of the good. Mr. Chair, can I be allowed to finish my last question?
You may conclude.
Okay, yes. So I wanted to specifically ask another question now, because start time firearm, what's the process to get a legal gun? What is the process right now? You provide training, or you just sell the arms? What's the process?
Well, we're NRA certified trainers, so we do the training. After we do the training, the VIPD issue a coupon for you to come and get your firearm from us. Once you possess that coupon, we take that coupon and then do our own NICI background check on you, and then the feds basically tell us whether to deny or proceed. And once we get proceed, then we release that firearm to you. However, I think that I think that's just my opinion in terms of how the firearms are coming in through the airport illegally. I think it's through the airport, but that's the procedure here on island overall.
Good. Because we want to send a message to all them with them gun in the community, moving around, gun pack. If a jailhouse you come from, we sending you go back. Thank you very much for the time, Mr. Chair.
Thank you, Vice Chair. Before we proceed to, I think it's Senator Francis Heiliger. Next, just playing devil's advocate here. Regarding Bill number 35, that's 0215, that seeks to increase the term of firearm licensure from 3 years to 5 years. Assistant Commissioner Elsko made reference to the recent unfortunate incident in the state of Ohio, where an Uber driver was shot and killed because of what they believe was a scam or something like that. And both were elderly people, if I recall clearly. And I say, let me play devil's advocate here, because no matter what lawmakers try to do, we always seem to hit a hard surface somewhere. And I say that because I remember several terms back, I had proposed legislation for individuals seeking to carry a firearm to have psych evaluations done, which we do psych evaluations for every law enforcement officer and psych evaluation for every security officer that carries a firearm in the territory. And I thought of that because I said, you know what, the government is responsible for licensing individuals to carry a firearm. And I firmly believe that if the government licensed an individual to carry a firearm, knowing that that individual have some mental instability and he kill somebody, that the government too should be liable. But then how does the government do the official mandate of having him or her to go through the psych evaluation? So in any case, that wasn't passed. In this case, going back to the state of Ohio, I'm saying so I'm looking at 0215 now, which seeks to increase the licensure from 3 years to 5 years. And like the assistant commissioner said, a lot, or was it the AG, I think, some one of them said that a lot could happen between the 3 and 5 years. And what can happen too is even the mental state in between that time and even the age difference. Now, if you were to do something with this and say, you know, you need to do whatever evaluation, I know that I heard, I think the bill sponsor saying something about bringing an amendment for training or recertification or something. But what I don't want to run into the block with here, again, is the fact that, especially if it comes to age, that there be an age discrimination coming into play. But more of concern to me is what about the psychological state in between that time? And even with the age, I mean, if my grandfather, for instance, was a war veteran, he might have had a high-powered rifle there in the house or something, and he passed on. We're hopeful that the family members will be responsible to turn in this firearm at his passing. What happens? The firearm is not turned in, and a grandson, a great-grandson, or somebody knows that this weapon is there and end up utilizing the firearm. Again, I'm just saying this for thought-provoking and for conversation, that we take things into consideration. I don't think that any one of us, while I'm not comfortable with a lot of the language either, I don't think that any of my colleagues just want to violate anyone's civil rights, but trying to find that avenue to make sure that we safeguard individuals. Okay, what should actually be happening is that our Homeland Security needs to be beefed up, stepped up, and make sure that we stop the infiltration of weapons coming into this territory. And I'm gonna say it one more time that I've always said before. A lot of these guns coming into the territory are not coming here illegally. They're coming into the territory legally because they're coming in through our airports and they're coming in through our mailing system. And that's why I'm sad too that the postal inspector couldn't be here, because they will tell you some really gruesome stories. And to know that they have intercepted certain packages and can't do anything, absent of a law being in place. So again, food for thought as we continue these discussions. Senator Francis Heiliger, I'm told that you're online. Are you there?
Yes, I'm here.
Okay, you may proceed with your 4 minutes.
Thank you. Good afternoon once again to my colleagues. Good afternoon to the people of the territory. Good afternoon to the testifiers. My first line of question has to do with the banning of the assault rifles. Currently, does the Virgin Islands Police Department have a listing as to how many assault rifles are registered in the territory? And do you also keep a listing of weapons used during crimes? Because I'm trying to figure out the impact this piece of legislation potentially might have in regards to who already have these types of weapons registered, as well as are these weapons currently being used in some of the crimes happening here in the territory? Do you have those types of statistical data that the VIPD keeps?
Assistant Commissioner Elsko, thank you for that question. So we do have records of individuals that have assault-type weapons. That information can be reduced to a list. We don't have necessarily a list, but it can be reduced to a list.
Okay. When it comes to consequences, are there any? This is where my concern is coming in. From listening to testifiers as well as listening to the proponents of the piece of legislation with assault rifles, I am very much a balanced person, and I need to make sure I'm not stepping on anyone's toes constitutionally. And while I am hearing it from one perspective, I'm also hearing it from another, and I don't feel I am getting a definitive answer to allow me to keep that happy balance to make sure I'm not infringing on anyone's rights. As legislators, we do have the right to pass legislation to limit access to certain things, but I want to make sure we're doing it constitutionally. So to the chair to legal counsel, when it was shared in regards to the reporting of the decision of the Supreme Court that some of the things that we're attempting to do here, as one of the testifiers said, has already been covered by the Supreme Court, are you of the opinion that this piece of legislation, when it comes to the banning of certain types of weapons, on our part, is this constitutionally okay for us to move forward if this is something we were willing to support?
Legal counsel, you may proceed.
My response, Mr. Chair?
You may respond.
Through the chair to Senator Francis Heiliger. I think, as I indicated before in an inquiry to Senator, in a response to an inquiry from Senator Franklin Johnson, that the Supreme Court, and more importantly, what has happened since several Supreme Court decisions, most notably, I believe it's the Heller decision that occurred in the 2000s, that the Supreme Court has allowed states and territories and jurisdictions to enact reasonable regulations that would regulate, and in some cases, some states have gone as far as to ban assault weapons as a result of various incidences occurring in the states. For example, in Sandy Hook, in Connecticut, as a result of that incident, if I'm not mistaken, the state of Connecticut has a total ban on assault weapons as a result of the incident at Sandy Hook Elementary School. So specifically to your question, what we would have to do is look further at the even more recent Supreme Court decisions, but I know the general overarching principle articulated by the court has been that states can enact reasonable restrictions on certain classes of weapons, including assault weapons, that do not run afoul of the Second Amendment. There, obviously, given the change in the ideological balance of the Supreme Court, obviously some cases have been tested with respect to the principle of reasonable regulations. So that's something that we could look further at. But on its face, the legislature of the Virgin Islands does have the authority to enact reasonable restrictions on weapons, including assault weapons.
Time.
Okay. Thank you. Mr. Chair, may I ask one final question?
Yes, you may conclude at this time.
Thank you. My other question has to do with the commissioner basically having to deal with the importation of parts for guns, certain parts. The only thing that I know what and how stringent the commissioner's job is, especially being the top law enforcement individual for the entire Virgin Islands. And I fully understand what the piece of legislation wants to do, but I need to hear, do you think this is an additional undue burden on the commissioner or on his office, or is there a possibility for this type of level of scrutiny to be placed maybe someplace else within the department? That is the VIPD.
Oh, Roger. So thank you for that question, ma'am. Sidney Olsko, Assistant Commissioner of VIPD. Based on what we've seen, we would have the commissioner work with the FLLs in the community, the licensed dealers. That way they can take some of the load off. But I think the AG said it best. There needs to be some clarity regarding the identity of parts, and it needs to be very specific.
And I also happen to agree with that. So you're willing to work with another counterpart, with the dealers, to help lessen the load, as well as we need to tweak it to make sure that we can identify specifically what the job description really is, specifically as it relates to the part. Okay, I will make a decision accordingly as we continue, and I will continue to listen. Thank you, Mr. Chair, for the additional time.
Thank you. So the last two will be the two bill sponsors. So before we go to Minority Leader DeGraff, oh, I'm sorry. So it's not two, it's three. Senate President Nova Francis, yes, you're recognized for your 4 minutes.
Thank you very much, Mr. Chair. Good afternoon to everyone, and thank you for your testimony thus far in this. Assistant Commissioner Elsko, in respect to the Bill 35-0215, and I know that the bill sponsor spoke about a fee schedule or fee modification that is supposed to be offered subsequently. Are you aware of whether or not the extension or expansion from 3 to 5 years include an additional cost?
I am not aware, but I can look into it.
Okay. But you're aware that there was a proposal to increase from 3 to 5 years?
I am aware of that proposal, yes,
okay.
not of the fees.
But you're not aware of the fees?
No, sir.
Okay. And you said that the original fee for licensure was $75 and now has been doubled to $150?
I did not say that, but I am aware that the renewal is $150.
$100 per firearm?
Correct.
Which is a doubling? That's...
Yes, sir.
Okay. And if that's the case, then... And you say you don't know whether or not there will be an additional increase to the 5 years?
No, sir, I'm not aware.
Okay, all right, so I'll leave that alone for now. So tell me, is AR-15 considered an assault weapon?
As far as I know, it's, I'm sorry, Assistant Commissioner Olsko, VIPD. The description that I have heard, AR-15, is a military assault type weapon, so the answer would be yes.
Well, a simple Google of AR-15 tells you that it's not an assault weapon, off the bat. So that's an issue, again, I think that it'll be critical for us to really identify exactly what we're looking at in terms of assault weapon by numbers. Obviously, an AK-47 and those type of AK numbers, then because of their ability to fire rapid rounds, is considered an assault weapon. Are you aware of any requests that have come in for licensure for AR-15 or AK-47?
Yes, sir, there's been several.
Several of them. And have they been approved?
Those licenses are in a holding pattern.
Under what grounds?
This is a decision that's been made by the agency. We scrutinize each application and make a decision as they come in.
So currently there is no license granted for AR-15s or AK-47s or any of the AK or AR numbers?
Well, that, sir, I am not aware. The commissioner handles those himself. He does not offer the ability to anyone else to handle those licenses. So I'm not aware of that at this time.
Okay.
1 minute.
Real quickly, Mr. AG, I know that in your testimony, from your research, AG, is AR-15 considered an assault weapon?
From my research, I do believe that it is. I'm sorry, Ian Clement, Acting Attorney General, Department of Justice. I believe that it is, and even if an AR-15 is firing in a semi-automatic fashion or in a single-shot fashion, it is easily convertible with certain parts to become a fully automatic weapon, and then would qualify as an assault.
Any semi-automatic weapon could become fully automatic with a conversion kit. Do you agree with that? Or you're aware of that?
Time.
Well, I'm not. Ian Clement, Acting Attorney General. I'm not aware that any semi-automatic weapon, I couldn't testify to that.
Okay, very well. But any, again, with a conversion kit, a semi-automatic weapon could become fully automatic. Also, in your testimony, Mr. Chair, if I may just
you may
wrap up. In your testimony, you spoke about that you would consider modeling the Virgin Islands legislation after the laws of Connecticut, which explicitly includes semi-automatic weapons. Is that your testimony, that you believe that semi-automatic weapon should also be included in the ban along with assault weapons?
Yes, it is our position. I'm sorry, Ian Clement, Acting Attorney General, Department of Justice. It is my position that semi-automatic weapons as well as automatic weapons really do have no place on the streets of the Virgin Islands.
Are you aware of what's a semi-automatic weapon?
I don't have the textbook definition in front of me, but I mean, I have an awareness of what a semi-automatic weapon is.
Is a 9mm a semi-automatic weapon? A 40 caliber, a 45 caliber? Any of those pistols a semi-automatic weapon?
I'm unaware, Senator.
Okay. All right, so again, I believe that we have some work to do here in regards to making sure that we really truly identify what we're considering. I believe that firearms, assault weapons, there should be some punitive action taken against individuals that possess these weapons, but we need to be careful in terms of laws that restrict individuals from being able to possess these firearms, because in fact some of those, there's nowhere else where a semi-automatic weapon will be banned. Thank you, Mr. Chair, for the time. Again, I'm not a member of this committee, but I have some reservations in terms of I think that these two measures, especially to the end, the 250, definitely requires some additional conversation as we move forward.
Mr. President, just gave me even more reservations as well. Really and truly. Because the lack of data makes it even harder for us to make an informed decision in approving some of these measures that we're discussing. Not an indictment on anyone here, because I'm happy that there's representation from the Virgin Islands Police Department and the Department of Justice. but we are ill prepared for this discussion. As I sit here as a retired law enforcement executive, someone who served as the special assistant to the police commissioner, we would not have been to this table as a soloist. We would have had maybe your chief of detectives with you, your head of planning and research, who will have the data, and our firearms ballistic expert. It's real hard to make these, and I think it was the AG. I mean, if we don't even define firearm components, then what are we doing? What I'll ask of the department, if I do support 0215, which speaks to the increasing the term of licensure from 3 to 5 years, what I want to ask and encourage the police department to do, because I'm not going to ask if you do it, because I've asked a number of agencies during the budget season whether or not they do certain proactive initiatives. And in this case, I would only ask that the VIPD be proactive regarding the license renewal efforts, in that in your data, you see that someone's firearm is due for licensure within the next 6 months. Don't wait until it expires for them to come in to then tack on a late fee. Send something in advance, letting them know you're 6 months out before your license expires. And if you come in, this is what we will do for you. If you come in ahead of time, whether you reduce the cost or whatever the case may be, so you won't have an influx of people coming in at the same time when these licenses are expired. It's the same thing that we've been seeing with the Bureau of Motor Vehicle in years past. Everybody would wait until the end of the month to go in, and then motor vehicle packed with people down there, instead of sending out something and saying, hey, you're 6 months out, or you're however much out from your expiration. If you come in now, this is the incentive that we're giving you. So I'm asking if you could take that into consideration if 0215 were to be passed. Again, regarding the other two, especially 0250, I am not convinced that it's not duplicative of 7091. That's Act 7091, that is. And I do concur that the definition of firearm components is crucial to be in there, so that we could know what components we're talking about. On that note, I will yield now to a point of information, and then we go to Senator DeGraff and finalize with Senator Potter.
I definitely wanted to chime in on what you were talking about as far as registering these firearms and the cost. I have a friend that has 6 firearms.
Wow.
Some for collector's item and different things. It's going to cost him $900 based on those new fees to license his firearms. $900. Some of them are collector's items. I have a collector's item firearm that went to be refurbished. It's a collector's item. It's antique, but it's still a legit firearm that can be used to fire, but it's a collector's item. And you'll have people that has these type of old antique weapons that are only collector's item. They don't go, they're hunting, they don't utilize them, But it's like a prize. It's like having an antique car. Somebody might believe in having guns and they have antique weapons that they send refurbished and have them in their safe. $900. We can't price people out of having something as a collector's item, something as a weapon just for their trophy case to have. Somebody might buy a John Wayne gun. It might be still usable, but that's the cost of licensing a firearm, and it's really getting a little ridiculous with that, especially for law-abiding citizens. We got to understand, those people who gonna have illegal gun, this doesn't affect them, and they're going to have bigger, badder, and even more weapon than the law-abiding person. I'm not saying that. I'm not saying to get more. I'm just saying that we cannot put our people, our community, to not be able to protect themselves if they pass all the criterias. And by raising these prices, that's what we're saying. And you don't have police to go all over and protect. You don't. So those law-abiding citizens who can pass that legitimate statute should be allowed to have the firearm and not have to pay a cost.
Thank you.
Thank you very much.
Point taken. Point taken. For 6 firearms to 1 man, that's, wow, okay. Senator DeGraff, you're recognized for your 4 minutes.
Thank you, Mr. Chair. Good afternoon to everyone present. Title 23, Virgin Islands Code, Section 455, subsection B. The initial fee for the license under Section 454 of this chapter shall be $75. The license may be renewed every 3 years for a fee of $150. That's in the law under Title 23, Section 455. The assault based on Bill number 35-0250 is the conversations have been excellent to me. You know, incidentally, I first submitted this bill on June 24th, 2021 at 11:36 in the morning. It was BR 210593. So I had this bill from 2021, trying to be heard, trying to have these conversations to address our young men and women being killed in the territory. I take the Second Amendment as serious as anyone. And I don't believe in taking any firearm from any law-abiding citizen. They have gone through the process and they deserve to carry the firearms. So I'm 100% in support of that. But sometimes you have to stick in the paint and stick with it. So from 2021 to have it heard in 24, I'll take that. I've heard some great discussions here in regards to ownership of firearms and legalities and different things. Tell those people who cheering done dead, don't get killed. A rifle, semi-automatic rifle destroys you. Guns destroy us. I carry a gun for many years, military, police, in the military and in the police. My colleagues who are law enforcement have. You know, can we get together to address this here? Hey, I'm willing to make it right to try our best to address this here. Because if we think it was for the law-abiding citizen, no. So maybe to adjust for the law-abiding citizen who are licensed individuals who want to possess assault weapons, maybe that might be the road going down the road. But when the house get broken into and they ain't home and they get stolen and they're on the road, I've seen that in my years as a police, and then they're on the street. So to try different things, whatever it takes, if it means to come in here to get beat down, everybody believe you're against this, you're against that, I don't have that problem. My back's strong. But the issue still remains when the young generation pick up that AR-15. Yes, Google say it's an automatic weapon, but Google say it's not an assault rifle. Google did say that, so I will confirm that. But I'm saying, you know, we gonna mix semantics with life and death. AR-15 bust through your house, gonna take you out. And even if they miss the perpetrator on the street, they come to your house, they come in for you. They come in for us. So I really take my hat off to Mr. McSheen and the two McGrath gentlemen. I think it was, I didn't remember the first name, but I take my hat off to you gentlemen because, again, you're private citizens, one a gun dealer business, who came here to state your case. I highly appreciate that because that's what I'm here for, to represent the people. But the fact remains, our people on the street are being killed on a yearly basis, and to sit down and just leave things happen, you know, I choose not to. Now, Attorney General, how many states are you aware of? If I may wrap up, Mr. Chair?
You may wrap up.
How many states are you aware of have bans on assault weapons?
Ian Clement, Acting Attorney General. I believe my prior testimony was 10, but I can't find it at the moment.
Yeah, I think it was 10. So yes. Again, in terms of it being legal to be done, and muster the Constitution and muster challenges, hey, that's what life is about. Sometimes somebody got to stand up and face, you know, the reality. And finally, Mr. McSheen, when someone legally applies to get a firearm through you, can they, one, ship a ghost gun to you and is getting that coupon from the police department, permission from the commissioner to move forward with the process?
Levi McSheen, CEO of StarTime Firearms. No, they can't ship a ghost gun. But to follow up, I have a question that I wanted to ask you.
Wait, if
Mr. Chair,
that was my final question to the chair. If you could go through the chair and just answer them, and then if he wants you to go on with that, that'd be fine. So, Mr. Chair, thank you for the time, and you could just answer in your time.
Thank you, Minority Leader. Mr. Sheen, you had a concern. Let me hear your concern, but you can't question the senator. But you want to put your concern on the record?
Yes, I sure do. Levi McSheen, StarTime CEO. I'm bill number 35-215 is kind of leery due to the fact that 5 years somebody could do something with a firearm, and then for the next 5 years, you know, they wouldn't be brought to justice due to the fact that there's no background check when they come in to renew. So I feel like 5 years is a really long time, because in order to renew your firearm, you still have to do another background check, would allow law enforcement to see that this person is still clean and still responsible for carrying a legal firearm.
So, Mr. McSheen, let me ask you then. Again, you're, 1 second. I'm trying to find your testimony. You're a firearm expert, correct?
Firearm dealer.
Okay.
I wouldn't say expert.
You won't say expert. So you're a firearm dealer. So let me ask you, can a semi-automatic weapon be converted into a fully automatic weapon?
100%.
How long it take you to do that?
Me personally?
Would it take 3 years or would it take 5 years?
No.
Okay. Thank you.
A few minutes.
Senator Potter, you're recognized for your 4 minutes.
Thank you very much, Mr. Chair. I want to thank the testifiers for spending a couple hours with us on this very important topic. Without question, gun violence is taking a serious toll on the Virgin Islands community. There's no question about that. Far too many of us in this room have attended funerals where the unnatural thing is taking place, where mothers are burying their sons. We've seen it over and over again. So I have to applaud the proponent of the legislation, colleague, minority leader, for coming forward with at least something that will attempt to address the issue that is really doing a number of the people in the United States Virgin Islands. I wanted to ask, though, and I want to applaud the McGrath, I almost said the McGrath brothers, I don't know if they are brothers, but they both made compelling, passionate presentations here before us today. One thing that I believe it was Gregory McGrath said was that, and it has been repeated over and over here today, honest, law-abiding gun owners who have their license legitimately are, for the most part, not committing any significant gun crimes here in the territory. I wanted to ask Mr. Assistant Commissioner Elsko if the Virgin Islands Police Department has any statistics in regards to who are committing these gun crimes. What percentage of these crimes are being committed by law-abiding, licensed gun owners, to your knowledge, if you can right now, if you can provide us with that information?
Assistant Commissioner Elsko, VIPD, I do not have those stats with me now. This is something that I can review and get back to you.
Yeah, I know that nothing, thank you for that. I know that nothing is 100%, but I would suspect that the vast, vast majority of the crimes that are being committed are being done by persons who acquire their guns illegally. I wanted to ask the Attorney General a question regarding a statement that one of the McGraths made, and that's that the Supreme Court made a ruling recently that any firearm that is in common use may not be banned. Is that a hard and fast rule that just came out of the Attorney General's, the Supreme Court's recent ruling?
I don't believe that's a proper interpretation of that ruling.
Okay.
I would also state that post-Heller, post-Bruin, there was a case out of Hawaii, State v. Wilson, in which the state of Hawaii diverged from Bruin on independent state grounds. In fact, it said, we're not going to follow the Supreme Court, we're not going to follow Bruin, we're going to use Hawaii's own history on independent state grounds and determine...
Media, can you put the camera on the testifier, please? Thank you.
Okay. And so the Supreme Court of Hawaii eschewed Bruin, said we're not going to follow that. So there was a statement made by one of the McGrath brothers, I would just refer to them as that there are precedents that this body has to follow. Now, the Hawaii decision has not been tested here in the Virgin Islands. But to your question, I do believe that the Virgin Islands has the ability to define for itself what is an assault weapon and which weapons it's going to prohibit.
I thank you for that. And I know the McGrath brothers made a passionate plea, and I think one of the statements he said was that public safety, just paraphrasing, if I may just wrap up, Mr. Chair.
You may.
He said that public safety should not trump constitutional rights. And I understand constitutionalists may hold on to that position, but as lawmakers here in this territory who is witnessing crime after crime, death after death, 20-year-olds, 19-year-olds being gunned down by these automatic assault rifles, we have a responsibility to do something. And I am very comfortable with the banning of these assault rifles that have no real purpose. I agree with the Attorney General. No real purpose in the Virgin Islands community. And I think matching fire with fire will just have all of us meet a really serious demise. But thank you very much for your flexibility, Mr. Chair. Thank you very much, AG and the testifiers, for a very important discussion, and hopefully we'll have another opportunity to do, to have more deeper discussions on these important issues. Thank you very much.
Thank you, Senator Potter. We've now exhausted all debate times, and I will allow VIPD and the Department of Justice and testifiers to just close out with a 30 seconds closing. 30 seconds. Madam Timekeeper, thank you.
Sidney Olsko, Assistant Commissioner, VIPD. I'd like to close by saying that we exist in a civilized society. The Second Amendment says that the right to bear arms shall not be infringed. It takes good people to have meetings like this to make the tough decisions. If you can, well, let me put it this way. Anyone can justify anything at any time if they try hard enough.
Time.
Conclude.
Why not a 50 cal? Why not a rocket launcher? Why not a tank? Why not a cannon from one of our forts? Why can't you have those things? Because it's readily acceptable that individuals should not have these weapons. That's all I have.
Thank you. Department of Justice.
Good evening, Ian Clement, Acting Attorney General, Department of Justice. I would just like to reiterate and to add that and echo the Deputy Commissioner in that the Virgin Islands really does need to take a stand on very dangerous weapons that really have no sporting use or no real purpose other than to be used as weapons of war. And they have no real place on the streets of the Virgin Islands. And while this legislature must do it in a way that is constitutionally sound, I believe that it can do so and must do so. I appreciate the time. Thank you.
Thank you. Mr. McSheen.
Levi McSheen, StarTime Firearms CEO. I just think that you can't really take away the rights of law-abiding citizens. And when you look at the stats, it's like 98% or 98.9% illegal firearms is what committing the crimes, not legal firearms. Thank you for having me.
Thank you. Now to the M&M brothers. We're lucky the third one in here, but we'll start with the eldest.
All right, Gregory McGrath. Real quickly, the Hawaii case is a defiance of the Supreme Court of the United States. Matter of fact, I consider that to be treason. As far as the weapons that the commissioner was talking about, Deputy Commissioner, those are not weapons in common use. And as far as me saying anything about the public good or the public safety not being a reason to impede or infringe on people's rights, I didn't say that. That's a Supreme Court decision.
Time.
I don't come in with anything of my own. It's all predicated and based on Supreme Court decisions and the Constitution.
Thank you.
Horace McGrath. First of all, thank you for this opportunity to testify here today. And the Bruin decision is a very interesting decision. I think it will be in the best interest for some to look at that Supreme Court decision. The issue of gun violence is a serious issue. It needs to be addressed. It should not be addressed at the cost of loss of constitutional right, but it should be addressed. We need to get to the table, look at the root cause of crime, and address it. Don't put the burden on the law-abiding citizens of this territory. Thank you.
Thank you. Thank you all for your testimony and your responses. The discussion was very engaging. I really enjoyed having and want to encourage the public, just like how the McGrath brothers, yes, they are brothers, Senator Potter, just like how these brothers were paying attention to what's going on in the Senate, sent emails, text messages, called, and came in and asked to be part of the process. This is exactly what we want to encourage the public to do. Not because we're elected officials, we know everything. You know, our eyes and ears open to other things as people see things differently from different perspectives, etc. And, you know, because of that, it really made today's discussion a balanced one. So now is the time that we came to now make a decision on what's before us and what we heard today. And I'll accept a motion on bill number 35, that's 0215 at this time. Any motion on 0215? Motion, Senator Angel Bolkes Jr., you're recognized for your motion.
Thank you, Mr. Chair. Mr. Chair, I move bill number 35-0215, an act amending Title 23 Virgin Islands Code, Chapter 5, Section 457, subsection A, paragraph 3, relating to the contents of a firearm license to change the statement in the license, increasing the term of the license for 3 years to 5, be favorably voted upon in this committee and forwarded out to the Committee on Rules and Judiciary for further action and consideration. I so move.
Second. Bill number 35, that's 0215, an act amending Title 23 Virgin Islands Code relating to the contents of a firearm license to change the statement in the license, increasing the term of the license from 3 years to 5 years, have been properly moved by Senator Angel Bolkes Jr. and second by Senator Franklin D. Johnson. Hearing no objections, roll call on bill number 35, that's 0215.
Yes, Mr. Chair. Senator Angel L. Bolkes Jr. Senator Bolkes Jr., yay. Senator Dwayne M. DeGraff.
Yes.
Senator DeGraff, yay. Senator Ray Fonseca.
Yay.
Senator Fonseca, yay. Senator Alma Francis Heiliger.
Yes.
Senator Francis Heiliger, yay. Senator Javon E. James Sr., absent. Senator Franklin D. Johnson. Yay. Senator Johnson, yay. Senator Kenneth L. Gittens.
Yes.
Senator Gittens, yay. Mr. Chair, you have 6 yeas and 1 absent.
Thank you. Bill number 35, that's 0215, an act amending Title 23 Virgin Islands Code relating to the contents of a firearm license to change the statement in the license, increasing it, the term of the license from 3 years to 5 years, have been properly moved and seconded and voted upon favorably here in this committee and will be forwarded to the Rules and Judiciary Committee for further action. Do I hear a motion on bill number 35, that's 0243?
Motion.
Motion, Senator DeGraff, you recognized for your motion.
Thank you, Mr. Chair. I move bill number 35-0243, an act amending Title 23 Virgin Islands Code, Chapter 5, Section 470, to require individuals to obtain permission from the Commissioner of the Virgin Islands Police Department before purchasing the firearm components that will be mailed or shipped to the Virgin Islands, be held in committee at the call of the chair. I so move.
Properly moved by Senator Properly moved by Senator Dwayne DeGraff, second by Franklin D. Johnson and Senator Alma Francis Heiliger. Hearing no objection, so ordered. Next,
Motion.
I have a motion on bill number 35-0250.
I move bill number 35-0250, an act amending Title 23 Virgin Islands Code, Chapter 5, by adding Section 454B, banning assault rifles in the Virgin Islands, be held in a committee at the call of the chair. I so move.
Second.
Properly moved by Senator Dwayne M. DeGraff, second by Senator Alma Francis Heiliger. Hearing no objections, so ordered. Now, let's remember that at the call of the chair could mean at the very next hearing. And if that's the case, then we need to know what we're doing to dispose of these bills, because ain't no one going to say that the bills were lingering in committee. But at this time, again, I want to thank everyone for their participation today. We had 3 blocks, whereas bill number 35-0248, the resolution petitioning the U.S. Congress for the people of the Virgin Islands to be authorized to elect the Attorney General, failed in its measure to pass this committee. In block 2, we had bill number 35-0238, an act to confer peace officer status on qualified enforcement officers employed by the GERS, which was passed by this committee and be forwarded to the Rules and Judiciary Committee. And in block 3, we just concluded with bills number 35-0215, the act amending Title 23 Virgin Islands Code relating to the contents of firearm licensure to increase the term of the license from 3 to 5 years, which was passed and will be forwarded to the Rules and Judiciary Committee for further action. And bills number 35-0243, an act amending Title 23 regarding the purchasing of firearm components that will be mailed or shipped into the Virgin Islands should receive the permission of the police commissioner, and 35-0250, an act amending Title 23 of the Virgin Islands Code banning assault rifles in the Virgin Islands. Both of these bills were held in committee by the bill sponsor or by action of the committee at the call of the chair. Again, thank you all for your testimony today. Thank you, colleagues. Thank you, staff. Have a good evening. And again, it's National Police Week. Please extend our courtesies to our law enforcement officers and thank them for their service. It's also National Hospital and Nurses Week. Also extend your gratitude to them as well. And don't forget our seniors in the community. It is, what's the name? What's the fancy name? Older America's Month. So again, respect and gratitude shown to our seniors, our elders in the community. And again, we have about 4 centurions coming up this year right here in the Island District of St. Croix. Thank you again, everyone. The Committee on Homeland Security, Justice and Public Safety for Tuesday, May 14, 2024 is hereby adjourned.